has been the person who's been putting this together with Kyle Brady, who's the editor of the Law Review. And the faculty involvement is with Kenneth Townsend and Mark Rabel. Mark Rabel is going to be running the first panel. I'll tell you a little bit more about him when I introduce the next panel. This is an important discussion on secondary trauma, and the way that it has been designed for this particular webinar is to start with a real understanding of what secondary trauma is, and then to close with some ideas about how we can deal with secondary trauma, some solutions for it. And of course, critical to this discussion is an awareness of how structural inequality can in fact have a disparate impact on people. So there's a section on the impact, the racial disparities in secondary trauma and the degree to which people of color, particularly Black people, are affected by trauma, and that has a real impact on them as lawyers. So I'm excited about this. I wish you all a wonderful day. I'm going to be coming in and out because of my work, but I want to start you off with the first panel. And this is moderated by Mark Rabel, who is pretty much the inspiration for this. And no one else could know more about secondary trauma than a lawyer who's been doing death penalty work and exoneration work for his entire career. He's a clinical professor of law and the head of our Innocence and Justice Clinic. He is well known for his work with Daryl Hunt, an amazing effort to have him exonerated. And his prior practice was doing civil and criminal litigation, in particular death penalty cases. So I will turn this over to him, and I wish you a wonderful day. Thank you for being here.
Thank you so much, Dean Aiken, for being here and for introducing us. And thanks to the Law Review for agreeing to sponsor this very important discussion. It's something that, as Dean Aiken just mentioned, I've been very concerned about because of my own experiences over the last 40 years of being a lawyer, doing death penalty work and trying to free the innocent people from the system. It's something that I personally became interested in about 2008 as a result of a lot of death penalty work and having witnessed an execution. And things really sort of got more difficult from there because of the cumulative impact of everything. So we're not going to be too technical here at the beginning of this symposium on what is the definition of secondary trauma. Generally speaking, it's how those of us in the legal system are affected by what we do, what we hear, what we report, and what we see. It means not only the lawyers, but also the judges, the jurors, our partners, our spouses, our children. And so we're going to hear about that. Now later, particularly with Dr. Porterfield, you will hear a little bit more of the definitions of secondary trauma and how it relates to post-traumatic stress disorder. But suffice it to say that direct and secondary trauma end up having the same effects, not to belittle or deny, certainly the people that go through the direct experiences of crime and war and things like that are not affected in a completely different way. But the science and the medicine are now showing us that we who report on it, we who witness what happened to these people are also affected. It's been particularly a difficult year, as we know, with this pandemic, and it has made most of us solo practitioners, no matter where we are. We could be in a big firm, we could be in the military, we could be in a public defender office, a prosecutor office, but we've been isolated. And so one of the discussions this morning will be, what effect has that had on us? We know, of course, from studies recently released by the ABA and others, that it's a difficult profession. We know that we have higher rates of depression, substance abuse, suicidal ideation. And some of the work can be harder than other parts of the work. So the outline for today, as Dean Aiken sort of indicated, goes from the testimonials that you hear in this first panel to scientific ways of studying and documenting the impact in the second panel, to the third panel, which goes into what are the ways out and what are the remedies. In other words, how can we promote resilience and hopefully try to prevent secondary traumatic effects on those of us who do the work or who are dragged into the work, like the juror that you'll hear from. We'll hear this afternoon that race and being a marginalized person can be, in many ways, an exacerbator of secondary trauma, probably more of a direct experience. And I know personally, I learned a lot about that, paying attention to these things in the last year. So we have a whole separate panel to talk about the effects on particularly Black people. We have judges, a prosecutor, and lawyers who will be talking about that on the first panel this afternoon. And then in the end, we have to make our institutions, our court systems, and our law schools aware of what's going on so that we can take leadership and train our young lawyers not to be affected or how not to be too affected by it. We're going to be affected because of the work. The question is, how do we avoid the secondary traumatic impacts? So I'm going to be introducing each speaker as they come up, but I can't really ask these people, who are wonderful people, to do this without doing this myself, because the three people that are going to be speaking after me are really pretty brave, and one has really never, two actually have never spoken publicly about some of this. So it's emotional. It's going to be difficult, but I really appreciate what they're doing. I have to say that I found myself in a situation in 2016 when my client of 20 years and friend of 12 years took his own life. And to me, this was a real existential crisis. And even though I've never been someone who felt suicidal, I would have to say that in the weeks after Daryl was found dead and it was ruled a suicide, I found myself in very strange situations, standing on a balcony at the Innocence Conference in San Antonio a few weeks after Daryl's death, looking down, wondering what that would be like to fall. That is not something I ever experienced. And I attribute it directly to the work, to what had gone on. And there's other things, there's always, like with death penalty work, the dark cloud of the next case. With innocence work, it actually can even be more difficult because the chances of extricating somebody who's been buried by the system are, at best 1 in 500, despite a very high rate of innocent people being locked up. I'd like to begin this morning with a friend of mine who passed away last year. His name is Larry Hammond. Larry was just a little bit older than me, but he founded a big firm, I would call it a big firm, with 50, 60 lawyers in Phoenix, Arizona. And he started this firm after clerking for the United States Supreme Court. He was there when the Furman opinion came out. He worked in President Carter's administration. And then when he founded this firm, which was basically a civil litigation firm, he always pledged that his firm would have 5 or 6, or at least one death penalty case. And in practice, they always had 5 or 6. So I interviewed Larry a few years before he died. And I'd like to play a couple of clips from that interview from 2015. I think the sound might be a bit delayed, but we're going to give it a shot.
This is something I have wondered about and worried about, but have not done a thing about it for a long time. I think I may have mentioned to you that my oldest daughter is an MSW who treats abused women and children. She fully understands the need for separate counseling for people in her profession. The other professionals who do work in her field have their own support system to provide mental, psychological, and other kinds of therapies for them. And so I began thinking years ago that we should be doing the same thing for the teams of people who do capital cases. But as I thought about our conversation, Mark, I was more and more disappointed in myself for not having ever done anything about it. But I think it's essential that we understand the effects and pressures on people who do this work at every level.
Don't beat yourself up too hard. This is my 35th year as well, and only in the last couple that I've started. But let me go back to something you mentioned. Your daughter, the MSW.
Yes.
Tell me a little bit more about what she says about the effects on her and why you think there might be some similarities in the traumatic effects of capital lawyers.
Well, the one part of it is that when you work with people who have suffered trauma, and many of our clients in capital cases have, when you work with someone who has suffered trauma, in order to understand what they have lived through, you need to bring that trauma to life. You need to do one of the things that they may have avoided doing, in some cases for decades. You may be inviting your client to relive horrible traumatic events that happened when they were children, things that they have put in a box and hidden from their own conscious minds for a long time. And so what are we doing? We're out there because we want to understand them, and we want juries to be able to understand them. We are inviting them to relive the most horrible moments of their lives. Well, that takes a toll not only on the client, but on the people around her or him. It's so obvious to me. We all internalize the horrors that we hear from our clients. And so we wind up carrying around with us part of the trauma that they've experienced. But first of all, we're often not in a position to do anything about the trauma they've suffered. We're not ordinarily in the treatment and care business. We're trying to get ready for a trial. So what do? We raise to the surface the worst moments in our clients' lives, and then we say, okay, that'll be good. That'll help us to tell our story, and then we're done. But that trauma is carried around inside of the lawyers who care, and it's not, it's the mitigation specialists, but I'll tell you, Mark, it is everybody in the offices that do capital work, the secretaries, the paralegals, the investigators. You get close to this stuff and you become involved in the worst things that have ever happened in someone's life, and it affects everybody. And yet we do not much about that.
So I couldn't say it any better than Larry. And there is a tendency of us capital defense lawyers to sort of have kind of a cowboy mentality that, we have to forge forward against all the forces to try to save the life of our particular client. And so we have to present the trauma in order to try to save their life by telling their mitigation story. And we understand it's hard work, but as Larry says in another section that I'm not going to play, that's why we do it, because it's hard. Now, what effect does that have on our families? What effect does that have on our bodies? What effect does that have on our emotions? What effect does that have on the way we do our work? Well, I can tell you that it has a huge effect, and I have personally experienced that. And so I think if I had not found some practices of meditation and yoga these last 12 years, I don't know what I'd be doing. So we try to pass that on to my students so that re-traumatization of our clients and the traumatization of others in the system, including ourselves, doesn't occur. I'd like to move now to what I would call one of the concentric circles of what happens, particularly in a capital case, and introduce Robbie Greer. Robbie, if you could hit your camera and our video and sound here. There we go. Robbie was a guy working in Charlotte almost 20 years ago, not quite. And he was called to be a juror in a terrible capital case of Henry Louis Wallace, a man charged with, I guess you'd call him a serial killer, is what he was convicted of, with 9 homicides, rapes, sexual assaults, including the assault of a 10-month-old baby, as Robbie will talk about. So, Robbie, thank you so much for being here. I know you have not spoken publicly about this, but we really appreciate it, because lawyers and others in the system, judges, prosecutors, defense lawyers, everybody, we need to hear what happens when people are just seemingly doing their jobs and then somebody like you comes along. So thank you for coming out of your retirement and all the volunteer work you do with your church and speaking with us. And yeah, we'll give you about 10 minutes, Robbie, but we really appreciate it.
Absolutely. Well, as Mark said, I was kind of going along with my life when I got the jury summons in the mail. And as with, I would hope, many people, I answered the call. In fact, the morning that I was going in also was election day. And I remarked to a friend of mine in line waiting to vote that I was really doing my civic duty because I was there voting, and then I was going to answer the call for jury service. I had even joked to my wife that morning as I was leaving that the Henry Louis Wallace case was going on, and with my luck, that would be the one that I'd be called for, little knowing that that was indeed going to be the case. Went through a week of voir dire, which was, challenging in and of itself. But then I was seated, as a matter of fact, as the last juror before they started on the alternates. Henry was charged in our case with 9 counts of first-degree murder that had taken place over about a 4-year period of time. I later learned after the trial was over, he had confessed to 2 additional murders, but they didn't fit the pattern of the ones that we were considering, so they weren't rolled into our case. Fortunately, I was spared most of the really graphic photographs, but we did see some, and they were in and of themselves graphic enough. I shared with Mark as we talked, one of the things that I most remember, they had hours of confession tapes because he went into great detail about how he had murdered the young women, how he had sexually assaulted them, what he did with their bodies afterwards in order to, hide the fact that he was involved, and in some cases even hide the fact that they'd been murdered. Because the quality of the tapes were not particularly good, they actually had us wear earphones so we could hear them better. And I have commented over the years to the few folks that I've talked about it with, that it felt like he was whispering in my ear, telling me about this. And it was still the most troubling part of that case. I get chills just now even telling it. That's something I'll never forget. But he did go into great detail about how it had happened. We were between the guilt innocence phase and the penalty phase. This case lasted about 2 months that I was out of work, and this was my job day in and day out. We were not sequestered as far as our living arrangements, but we did come in and park in a designated parking spot each day. The guards met us, walked us into the courtroom, walked us out to lunch, walked us back from lunch, walked us back to our cars in the evenings. Of course, we were charged to not watch TV, read the newspaper, discuss the case with our family and friends. we found him guilty of all but one of the charges that he was charged with. One charge, the assault on the 10-month-old baby, we found him guilty of a secondary charge in that one. But 9 counts of first-degree murder, multiple counts of rape, sexual assault, arson, robbery, just a laundry list of charges. Then we went into the penalty phase and ultimately found him to be sentenced to death for each of the 9 capital cases. I told Mark, I ended up being the foreman of the jury. And one of the things that I had to do as foreman that I was not prepared for, because when we went through voir dire, the attorneys for the prosecution had let us know, or let me know at least, that if we found him guilty, we would be asked to stand up in open court and, say, yes, this is my verdict. So we were all prepared for that. What I didn't know was, as foreman, at that point at least, because we found for the death penalty, there was a form that I had to sign. I'd print my name, sign my name and date for each of the 9 death penalties that we found for. And that was a particularly chilling moment for me as well. I think partly because I didn't know it was coming. I haven't talked about it. Well, I haven't talked about it publicly until now. I didn't talk about it for years, even with my friends. The ones that I had at the time would ask questions, and what I always felt like was they wanted graphic details that I just wasn't prepared to share. Up until about 4 years ago, when I started getting therapy, I couldn't even mention the case without tearing up. And if I tried to tell any details, I would literally start crying. The day that we finished, the day that we came back with the penalty phase and were dismissed from court, I went to my wife's work, which she worked at a school. She was a basketball coach, and they were having practice that day. When I walked in and she looked at my face, she knew that it was over. And she and I walked back in her office, and I absolutely just burst into tears. And so I got through that. Then at her desk, I called my dad, who I was in Charlotte. He lived in Gastonia. Called my mother and dad to let them know that it was over and that I was through. And as soon as he and I started talking, I burst into tears again. I was virtually inconsolable. Got through that day. The next morning, this was a Wednesday. The next morning, Thursday, I got up to go to work. I'd been out of work almost 2 months. I got up to go to work. Before I could even get to the interstate, the loop there around Charlotte, I had already started crying. As I was coming down the ramp to get on the interstate, the local NPR station started carrying a story about the trial, and I started crying so hard I couldn't drive. I had to pull over on the shoulder until I could compose myself. I got to work. I walked in the office, and at that point I had, I think, about a dozen direct reports. I came in, went to my cube, my booth, and sat down and was, people talk about being a zombie. I was nearly zombie-like. It was all I could do to just walk in and sit down. One of my direct reports came and sat across the desk from me and simply said, "Good morning, boss. It's good to have you back." I burst into tears again. He was so concerned that he went and got my boss, who called me back into her office and in a very loving way said, "You need to go home and you need to take care of yourself and you need to not come back until you're better." And so I stayed home Thursday, Friday. Of course, over the weekend, I didn't work on the weekends. And Monday morning, I went back to work. But for basically 20 years, I couldn't even talk about the case. If anybody asked, anybody that knew I'd been involved asked, I would just tell them, I can't talk about it. I started in therapy about 4 years ago, and as a result of talking with the therapist, was diagnosed with PTSD associated with the case. I told Mark when I was going back to work, I knew I needed therapy. I knew there was something wrong with me. But like so many people in that toxic masculinity, particularly back in the 90s, I felt like that was saying that there's something wrong with me and I should just be able to suck it up and deal with this. And I wish now I had gotten help back then. I do believe if either the attorneys or the judge had said, here's a resource that you may need to contact, that would have made a difference. I would have felt a certain amount of that it was okay, that this was not to be unexpected, and here's some help in dealing with it. I wish now I'd had that someone reach out to me in that way. I'm not positive I would have taken advantage of it, but I believe I would have. And it certainly would have made those years a lot easier.
Robbie, thank you so much for sharing that. I would want to say thank you for your service on a jury, but that just sounds so trite. And, but I think it's important for us to know, what we're doing to people when we have these cases.
Yeah.
Thanks and if you'll stay around, and I'd like to, you can mute and stop your video for now. We'll come back to you. And I'd like to introduce Eileen Zimmerman, if you would magically appear, Eileen. Thank you, Eileen. Again, moving into the concentric circles of the work, Eileen was married to a lawyer who was an intellectual property lawyer, a patent lawyer, as I recall, for a number of years. She went through law school with him in the sense of she was there while he went through law school, and has written an amazing book called Smacked, A Story of White Collar Ambition, Addiction, and Tragedy. Eileen is a journalist. She works with the New York Times, and she's also now a social worker. And I've asked Eileen to speak to us because this idea, this reality of secondary trauma is not just something in criminal cases. It's not just something in trials, but it's something that affects partners, spouses, and children. And Eileen could talk all day. I mean, I listened to her book all day over various hours. But Eileen, if you could just give us the story here of how lawyering and lawyers can have an impact on their wife and children. Thank you.
Thanks for having me. So in 2017, I wrote a New York Times story that many attorneys in this country read, titled The Lawyer, the Addict. And subsequently, I wrote a memoir, Smacked, that Mark just mentioned. Last February, in fact, it came out, that expanded on that story. It was published last February by Random House. The article in the book focused on the death of my ex-husband, Peter, who was a mid-level partner at a prestigious Silicon Valley law firm that many of you may know, Wilson Sonsini, Goodrich, and Rosati. Peter's behavior in the 18 months before he died was bizarre and alarming, and his physical appearance changed dramatically. He stopped showing up at events for our kids, forgot to pick them up from school, had increasingly far-fetched excuses for his lateness, absences, and odd behavior. His texts and phone calls had become meandering, nonsensical soliloquies. He was always shivering, sick with a low-grade flu for months, and his skin, which harbored little cuts and scratches, took on a gray pallor. He limped. He slept all the time. In July 2015, I went to Peter's house after he had been unreachable for 2 days to check on him. In the days before I had been there, my children had been there with him. Peter had spent those last days of his life in bed, vomiting, in and out of consciousness. When my son, who was 16 at the time, told his father he was going to take him to the emergency room, Peter found the strength to shout at him that he would not go. My son retreated to his room, unable to fathom what was happening. 2 days later, I found Peter dead on his bathroom floor, track marks all over his arms, legs, and torso. He had been taken down by a systemic infection related to intravenous drug abuse. 6 months later, a landmark study of substance use and mental health, a study of substance use and the mental health concerns of lawyers was released by the Hazelden Betty Ford Foundation and the American Bar Association, and many of you may know about that. It found that nearly 30% of lawyers suffer from depression, almost 20% from anxiety. So fast forward to 2020, an American lawyer media survey done right before the pandemic found that 31% of lawyers feel they are depressed and 64% feel they have anxiety. So both are up, not down, from the survey done in 2016. Today, according to the ABA, as many as 1 in 5 lawyers is a problem drinker, and that's twice the national rate. Over the past year, I have gotten a lot of emails from lawyers and their families talking about the stressors they encounter every day, the punishing culture of an AmLaw 200 firm, the misery of billable hours requirements, the 24/7 never off culture that technology has made possible, and the inability to admit weakness, to admit to not being at the top of one's game and instead suffering in silence, which often leads to the use of a variety of drugs and alcohol. And that use doesn't just affect the attorney, but their family, their friends, and colleagues. I know for myself and my children, who were teenagers in 2014 and 2015, when Peter's behavior and physical appearance was deteriorating, the impact of that behavior and of his death and the way he died. It has profoundly affected all 3 of us. My children and I were in therapy for years to cope with the initial trauma of the loss, but even more than that, to cope with the guilt we felt for not recognizing what was happening and feeling somehow complicit in Peter's death. Especially for my children, who in hindsight realized they were literally watching their father dying a slow, painful death. It's hard to put into words the agony it caused them. I suffered survivor's guilt for many years and sometimes still do, especially when there's a milestone type celebration for one of my children. And I question why I get to be there and Peter isn't. We all did a kind of trauma-focused therapy known as EMDR, which stands for Eye Movement Desensitization and Reprocessing, to help us reprocess the traumatic memories we have of the day Peter died and his alarming behavior and illness in the weeks and months leading up to his death. I suffered for months from intrusive images, as I was the person who found Peter. Most people assume that Peter's physical death was the cause of most of our grief that our family experienced, but the reality was that we had already lost a great deal in the years leading up to that day. My marriage, for example, never stood a chance with Peter climbing the big law ladder, and he was not present for so many important events in his kids' lives and in our family life. He worked through Christmas dinner and other holidays, rarely took vacations with us, and the few times he did, worked most of the time. He missed soccer games, birthday parties, school plays, you name it. In the year before he died, my teenage son would get to his father's house only to find that Peter was gone. No food in the house. He didn't even remember it was his night with his son. After years of this, we all felt marginalized by Peter's job. That job we knew would always come first. I remember when my son was about 8 years old, he asked me one night if Peter was ever sorry that he'd had children because it forced him to work all the time. But no one was forcing Peter to work the way he was. Yet he could not see a way out. Even as he lay dying, the last call he ever made was to dial into a work conference call, not to call his kids and ask for help or tell them he loved them, not even to 911. He was working, or at least he was trying to work, up until he died. I spoke to many attorneys and judges for my memoir, Smacked, and the reasons for drug and alcohol abuse were strikingly similar: relief from the intense stress and pressure of both job and life. Like Peter, most of these folks felt they were being squeezed from all sides. Peter, for example, could never work enough hours to satisfy his firm's insatiable need for revenue. He would never have enough time to really be present and involved with his children or his wife. He had few friends other than those at the firm who were, at the same time, competing with him and each other to build their book of business. Brian Cuban, the brother of famous Mark Cuban of Shark Tank and the Dallas Mavericks, was addicted to alcohol and cocaine when he was a practicing attorney. He told me, quote, "Stress from the competitive environment certainly played a factor in my desire to drink and use drugs. I was scared of losing my job, afraid of failing, afraid of walking into a courtroom. The only way I could do that, the only way to perform as a lawyer, was to do coke." Will Miller, who was an attorney in Seattle prosecuting sex crimes against children, became a methamphetamine addict. He was arrested, convicted of possession, and sent to prison and disbarred. He fought for 8 years to get his license back, and he was officially reinstated in 2010. He now works in a family law firm in Washington State. Will told me that other jobs are stressful, yes, like being a surgeon. But he said, "It's not stressful in the same way as being a lawyer." And I quote, "That's like being a surgeon with another doctor across from you trying to undo your operation. Lawyers are hostile, and that is reinforced by their clients. Now you have someone who is financially rewarded for being hostile. So it makes sense to me that people want to go home and sedate. Your client wants to see you respond, so lawyers get drawn into a lot of hostile conflict. It's hard to separate that from you as a person." Lawyers usually have the personality type INTJ, which is introverted, intuitive, thinking, and judging. It is one of the least common personality types among the general population. The mindset, as described by the consultant Larry Richard of Lawyer Brain, whose work is based on more than 25,000 sets of data on lawyer personalities, is a negativity mindset. This glass half empty way of viewing the world is often essential for the practice of law, as lawyers look for problems and irregularities and have to think dispassionately about them. But with that mindset comes depression and anxiety. In fact, research from psychologist Martin Seligman, who is the father of positive psychology, found that emotions like anger, jealousy, and anxiety serve a role for lawyers. They narrow the social and cognitive environment, which helps them maintain an unwavering drive to win. But, he also writes, that mindset is a liability in every profession except the law. And then there is law firm culture. Research has shown that psychological predictors of well-being decrease as lawyers are required to bill more hours. In that survey, done right before the pandemic that I mentioned earlier, nearly 80% of the lawyers surveyed said they knew of colleagues experiencing anxiety. 73% reported that work conditions were contributing to their own issues of anxiety, depression, and substance use, and other mental health problems. The majority of respondents cited 4 workplace issues that are negatively impacting their mental health and well-being: always being on call, billable hours pressure, lack of sleep, and client demands. 2/3 of respondents said that work had caused their personal relationships to suffer. Respondents to the survey blasted billable hours, clients, unrealistic deadlines, and unused vacations as causes of the profession's mental health crisis. Yet many respondents also professed doubt that these realities, which are in part responsible for the profitability of modern law firms, will ever be changed. I think it's especially important to recognize how severely the 24/7 workplace impacts an attorney's satisfaction with work and their mental health. Lawyers say they feel their career is at risk anytime they turn off their phone or ignore their email inbox, even on vacation. This always-on mentality exacerbates an already stressful profession. Many of the attorneys surveyed said that they would take a pay cut to work fewer hours and be able to disconnect. And as it is doing in nearly every sphere of our lives, the pandemic is bringing to the surface and exacerbating the problems that already exist in the legal profession. The New York City Lawyers Assistance Program, for example, recently held a discussion of substance use and mental health. Normally, a webinar like that would attract about 100 attorneys. 700 attended. And at the end of May, the Kentucky Lawyers Assistance Program also held a webinar. Theirs was titled "Managing Your Anxiety and Well-Being While Transitioning into the New Normal," and gave attorneys the ability to ask questions anonymously. Pre-COVID, they told me about 50 lawyers would have showed up. More than 500 attended.
Eileen, thank you so much for sharing. That term negativity mindset explains so much. I know when I went to law school, first and second year were pretty hard as they taught us to, quote, think like a lawyer. And I think traditionally we have done that. We're starting to change now. In fact, one thing I have started is a contemplative practices class here at Wake Forest. And one of the things that my students uniformly tell me is that rather than just simple meditation, which I teach them, that what changes the way they see the world is a gratitude practice. I ask them to write down 3 things each day that they're grateful for: a cup of coffee, their dog, anything simple. The sun came through the clouds. And uniformly, my students tell me that this changes the way they see the world. So we need to do something about that to prevent a lot of these problems that you've helped us with, Eileen. And I highly recommend Eileen's book for all of us. There's so much in there. Thank you, Eileen. Lieutenant Colonel Hall, if you could turn on your camera and sound now, please. I'd like to welcome now Lieutenant Colonel Andrea Hall, recommended to me by my former student, Brad Simon, who is in the JAG in the Air Force for several years now. Thank you, Brad. Andrea, you have, well, there's so much that I could say about you. You're the staff judge advocate of the Peterson Scrivener Garrison Legal Office in Colorado Springs. You've been in the Air Force since 2006. You've served in Iraq, so much more. But for our purposes today, I'd ask you to share with us your work in defending sexual abuse cases and the impact that that's had on you. And I really do appreciate you and my other speakers today sharing these very, very personal things, but I really believe, I think we all believe that they're going to be helpful to us. So thank you very much for being here.
Good morning, everyone. I just want to start by saying that my opinions and views are those of my own and not of the United States Air Force. I should say the greatest Air Force in the universe. And this is the first time I'm speaking publicly about this, so bear with me. I'll try to maintain the best composure that I can. So I spent the first 4 years of my career in 2 base legal offices doing a variety of things. I prosecuted some cases, did some fiscal law, deployed, various other things. After I'd been in for 4 years, I was selected to be a base level defense counsel, and I did that job for 2 years. I started off defending some low level types of cases, and then if I did some more serious cases like sexual assault or possession of child pornography, I would have a senior defense counsel working with me. And every year, all base level and senior defense counsel would get together and for training. And during one of those trainings, I remember one of my colleagues talking about how he had defended a lot of child sex abuse cases. And it got to the point where he didn't want to bathe his girls at night. He would come home and he would pour 1 finger of whiskey, and then it was 2, and then it was 3, and then so on. And he ended up getting help, and he's talked to us about secondary trauma. And this was, like I said, like 10 years ago, probably at least. But he was very candid about how he felt and what he went through. And I really applaud the Air Force for ensuring that he shared that, because this was really before anybody was talking about it, to my knowledge, at least. So after my 2 years as a base level defense counsel, I became a senior defense counsel, and I performed that duty for 3 years. All the cases kind of run together, but there are 3 that really stick out to me. The first one involved a man that was accused of sexually abusing multiple boys that he met through a Big Brothers Big Sisters type of program. He also took photos of them and videos of them. And I remember reading discovery on the way to a hearing. I was on an airplane, and I was reading the Child Protective Services records for one of the boys. And let me just summarize by saying that that child had an uphill battle to begin with before he even met my client, and my client didn't help. And during the trial, I had to cross-examine him, because in his first statements, he said that my client had only abused him a handful of times. But by trial, it was, I think, more than 20. And I could not confront that inconsistency. So I remember standing in the well of the courtroom and just thinking to myself, Andrea, don't cry. And I managed to get the questions out without losing my composure, and then sat down. And sorry, my kids are also waking up right now. It's Colorado in the morning, so it's crazy right now. But I do think it's important to also add, because real life is also going on while you're doing these things, that I had my first miscarriage during that trial. So the next case that really shook me involved allegations that my client sexually abused his 4-year-old stepdaughter. The child went up to her grandmother and stuck her face in her grandmother's private area and said, "Daddy makes me suck it like a popsicle." And my client maintained his innocence throughout the whole trial, throughout the appeal, and probably still to this day. And I did a pretrial interview of that girl, which is standard practice in the Air Force. And she talked to me about the popsicle story, but she also said things that didn't make sense, like my client would sit on top of the refrigerator and poop in her mouth. So trial came, and we started a day late because I suffered my second miscarriage. And the 4-year-old took the stand, and the prosecutor and I stood right in front of the witness stand to try to block her from seeing my client, to not upset her or not distract her. And the 4-year-old girl got on her knees and bobbed her head. And she talked about the popsicle, but she also, I questioned her, and she did talk about the crazy stories about the pooping in the mouth. I don't know how I managed to hold it together, but I did. I do remember though, when I gave my closing argument, I was thinking in my head, how can I sell this? Like, how can I explain that a 4-year-old girl knows how to bob her head? He was convicted, and he wasn't grateful, to say the least, for my services. He filed a claim I was ineffective. He did not prevail, but it had bothered me. That night, the defense team and the prosecution team all went out for dinner and drinks, and I drank too much that evening because that was my way of dealing with it. The last case that sticks out involved another case where my client abused his stepdaughter. His wife confronted him while wearing a wire and asked if her child spit or swallowed. And he responded that she had swallowed. And I realized after he was sentenced that I just seemed hardened to all of it. And I knew that was not good. So I was coming up on the end of my 3 years as a senior defense counsel, and my marriage was not in the best state. We had stopped talking to each other about our lives, and I was drinking too much. I kept thinking about the 12-year-old that didn't have a very high IQ and already had a terrible upbringing, and that 4-year-old child. And I kept hoping that they would both forget about what my client had done to them. I didn't want to have kids anymore, and I was only talking with my defense counsel friends, and we would joke about the worst things just to make light of them. I mean, the bottom line is it wasn't healthy. So because of my friends speaking years prior about not being able to bathe his children, I got help. I talked about it, and I probably honestly should go back and talk some more, because it never goes away. I will never forget those children, and I have 2 boys now, and at first I didn't want to bathe them either. And I'm still worried, how am I going to handle them getting older and them having electronic devices and, you know, just the realities of the real world, how I will protect them. I just want to take a few things away from this. And one is that secondary trauma is real. 2, you should talk to somebody about it. And I would personally argue that your significant other shouldn't be the only person. And 3rd, I have absolutely no regret in defending those men for any minute. They have constitutional rights, and I am proud to say that I defended them. My only regret is that I didn't seek help sooner so that I could start employing healthier habits in my life. I just ask that you all do better than I did. Thank you.
Andrea, thank you so much. While you're still here, let me ask you. So you're going to keep doing this work. What are there changes that you can recommend to other attorneys who work with you and handle these kinds of cases that can help prevent the suffering that you endured?
I think anytime you do a child sex abuse case, or even a child pornography case, or a sexual assault case, just go talk to somebody. I mean, it doesn't hurt. I mean, maybe you can ward off some of the worst effects of it. Get ahead of it. And I think also pay attention to your colleagues and your friends, and be able to be honest with them if you start seeing them drinking too much or acting funny. Encourage them to go get help. Just be honest about how you're feeling. I think that would be beneficial.
On the 3rd panel, we're going to hear from Cheryl Nickham, who works in the Department of Justice, really on the other side of what you do. And she'll talk about the normalization of techniques that should be taken with prosecutors who work on these cases. In other words, to make it normal to regularly talk about what you're going through, and maybe with somebody in the office. Is that, when you said talk to somebody, did you mean talk to somebody like a therapist or somebody within your own office?
I think both. I do think a therapist is important though, because they can really help you with working through what you're dealing with in a professional manner. I mean, that's what they're trained to do. And they can give you healing techniques and coping mechanisms. But I mean, also talking with colleagues, I think that's really helped me as well get through this.
the other thing, it's really interesting. You know, of course, you're in the military, you've served in a war zone, and you said something a minute ago that one of the takeaways should be here that secondary trauma is real, which I think says a lot about where we are in the world today, you know, because for so long, a lot of people in the military and in society even denied that there was such a thing as post-traumatic stress disorder. Do you see progress?
Oh, I do, absolutely. And I really do have to give the credit to the Air Force for being in front of this. Like I said, we were talking about this 10 years ago. So yeah, I definitely see progress. And I see PTSD too as being more acceptable and understanding in our country.
Thank you so much, Andrea. If you'll stay on, and if Eileen and Robbie will come back as well. Robbie, we had a question for you, which was, I guess this is either for you or maybe you talked to your therapist about this. Do you believe that the trauma that you suffered was the result of being confronted with the horrible circumstances or the case, you know, the evidence, or was it the fact that you had to sentence somebody to death?
I think it was both. I will say over the years, my mind goes back to the young women, and I say young because they were all in their 20s. My mind goes back to those young women and what they endured. And honestly, to think about the last moments of their lives, Henry was somebody that they knew. And in fact, in almost, if not every case, they had worked for him at various fast food restaurants. So the last moments of their lives, they were looking into the eyes of someone they knew and trusted who was taking their life and had just sexually assaulted them. And that trauma I found very troubling. But I also, the idea that I had, and I kept telling myself there were 11 other jurors, and any one of us, you know, simply had to say no, and he would not have been sentenced to death. So it wasn't all on me. But the fact that I was the foreman, that I helped shape the conversations, and that I voted for the death penalty has been troubling as well. I will say he is still on death row. He has not yet been executed.
Robbie, I mean, this symposium is not about the appropriateness of the death penalty, but with everything that you've been through, have you changed your opinion about the death penalty in and of itself? I mean, would that, if you had not had to, you know, sit and listen to this, in other words, was it worth it?
Ooh, that's two different questions. Has my opinion changed? I would say my opinion has remained over the years in flux. I have talked with, the only persons that I've ever talked with until I started seeking therapy were my pastors, because I moved a number of years or over a number of years to different cities. And I talked with various pastors about what I'd gone through. And they frequently gave me some reading to do. And so I've done some reading on the death penalty and, you know, whether it's right or wrong. And I honestly don't know where I stand at this point. But I will say, I said then, because I had several people between voir dire and the case starting, I had about 2 weeks that I was back at work. And I had various people say, well, you know, I would have known what to say that they wouldn't have seated me on the jury. And in every instance, I told them the same thing. I didn't volunteer to be on this jury. I wish I hadn't been assigned to this particular case. However, I couldn't ever imagine a case where I would need a trial by jury. But if I did, I would want people like me to be on the jury, because I believe I'm a reasonable, rational person who listens to all the evidence and makes the correct decision. And if that's what I wanted, I had to be willing to do my part. So if I were called again under similar circumstances, I would talk candidly about what I'd been through, and I would pray they wouldn't seat me again. But if they did, I would serve again.
Robbie, I've heard that in at least one federal case, a very difficult case, a judge actually extended jury duty so that people who had been on the jury could get counseling at the government's expense. Do you think that's a good idea, or would you have taken advantage of that?
I think it's a wonderful idea, and I believe I would have taken advantage of it. Part of the reason that I didn't seek professional help at the time was I had in my mind, at least, that there'd be no way I could go to extended sessions of therapy without people at work knowing about it, because I'd been taken off for a couple of hours a week for whatever period of time, maybe months, and the stigma at that point of seeking seeking professional help, excuse me, that was one of those, back in the 90s, where the only people that see therapists are crazy people. And I didn't want people to think that about me. I wish now I had sought help.
Thank you, Robbie. Speaking of this so-called stigma, Andrea, let me ask you this question, and somebody's raised a question about it as well. Law students are afraid to get counseling because under certain circumstances that has to be reported to the bar. If they've had counseling or treatment for substance abuse, that sort of thing. And some people believe that actually is a deterrent to people getting help. What about with the military? If somebody, say, in law school has gotten help or even help during the time that they're in the military, in the JAG service, what impact does that have?
So I have to start just by saying that I'm not an expert in JAG recruiting, but I have done accessions interviews, and I've interviewed people who have gone to mental health treatment, and it doesn't prohibit them or bar them from coming into the military. I think there might be some diagnoses that would require waivers, but I absolutely don't think that it should be a deterrent to people who may want to join the military. They should still go get help.
Thank you. Eileen, I know you talked about law school and this negativity mindset we've mentioned. What do you think about that same question about this whole stigma?
About the stigma I just want to make sure, for attorneys for them to.
Right, attorneys or law students to get help for substance abuse, depression, all that.
To be perfectly honest, from what I hear from the law firms and what I hear from lawyers is very different, and law students. But I think law schools are really trying to encourage, it seems to me, trying to encourage students to get help and trying to destigmatize it. But it seems like there's also these two systems. It's like there's a black market and a regular market. And it seems like underneath what's going on publicly, people are still afraid to get help because it is a sign that you are not up to snuff, that you can't handle the pressure. And it's, I remember Peter died now 5 years ago, but I remember telling him, why don't you go see someone? And he would just laugh at me, you don't understand anything about this profession. I'm not going to go get help. I don't have time, and nobody does that. And, and I think I remember doing stories as a journalist many years ago when we were in the Iraq War about PTSD and mental health issues. And even though at the time the military was trying to shift toward an openness to getting help and seeking help, none of the Marines I talked to, for instance, they were not going to seek help because there was a definite stigma in terms of their peers about admitting that they had a problem. And I know recently I'd spoken to somebody just in the last year who felt the same way. So I think that in law firms, the law firm managers I talk to, they do want their employees to feel better, but I'm not sure, there's a lot of talking the talk. I don't know how much walking the walk there is. And so I think the stigma is still a very real thing in the legal profession and in law school.
Thanks, Eileen. And I think it's interesting, and I don't want to leave this panel, although we're almost at the end here, without noting the resilience of the three of you. You have each been through a lot. Lieutenant Colonel Hall continues to do her work. She's a great mentor to people like Brad, my former student. Eileen has written this wonderful book, and you're smiling now. You're a social worker. Robbie he's a funny person, in this great sense of humor, does a lot of work with your church. We've overcome a lot. I I used to be a really funny person. I think I'm funny again. I mean, I'll save the jokes till 4 o'clock when this thing is over. But I don't want people out there to think that just because we've all been through this, that there's no resilience. Eileen, just a last note. Tell us, what exactly are you doing now, and how do you think it relates to everything that you've been through?
Well, I just finished grad school a few months ago and got my license in New York. So I'm starting to do some work with at a healthcare clinic for people that have a variety of complex mental and physical health issues. But I think ultimately what I'd like to do is work with people that are also, I'd love to learn to do EMDR as a practitioner, which was a wonderful, helpful therapy for me. And I don't know, Andrea, if you've been through anything like that, but it's a great, you basically follow a light. It has to do with bilateral movement, but it really helps your brain kind of reprocess something that feels really visceral and immediate and make it seem more like something you might have dreamed. And it's kind of a way to come to cope with that. So I'd like to be able to provide people that have been through secondary trauma, direct trauma, some kind of help and relief the way that I've received it. So I'm hoping I can do that.
Thank you, Eileen. Yeah, I've read in Vander Kolk's The Body Keeps the Score that EMDR is a great modality for treating PTSD. And so is yoga. Anything that
Absolutely,
the timing back into our bodies is the way we perceive the world. Well, Andrea, Eileen, Robbie, Larry, I know you're watching. Thank you all. And on behalf of the 706 that are currently on this, I give you a big round of applause. So thank you very much.
Thank you.
Thank you.
Thank you.
So now say goodbye to these guys. I'd like to call up Dawn McQuiston. Dawn, if you could make a magical appearance on the screen here. Thank you. So transitioning into our next panel. So this is going to be where we try to bring science into looking at this, into this problem of the secondary trauma. There's a lot of discussion about we want to have evidence-based modalities, evidence-based treatments, evidence-based laws. Well, that's what this panel is about. And Dawn has been a leader in that. She's a professor now at Wofford College. Before that, she was at Arizona State. I have her speak to my Innocence and Justice Clinic and sometimes my criminal procedure class about eyewitness identification. And lately, we've been talking about these issues with judges and jurors. And she's been helping us also with another study that we're going to be talking about today. But so Dawn's a psychologist. Don't ask her for a prescription because she's a research psychologist, but she's going to be heading up this panel now. And the other speakers, I'll be talking with Stephanie Seaton and Kimberly Wiseman in a little bit, and then we're going to have another professor, Lindsay Harris, as we move into this next hour of discussion about studies. So, Dawn, I will turn this over to you.
Hear me. Great. A couple of things that I wanted to say before I get started on my presentation. We have 3 presentations today, and I'll be going first. I wanted to say how much I appreciated the tribute to Larry Hammond. I have such fond memories of him. I met him when I was a first or second year being a professor out of graduate school at Arizona State University, and I do some consulting, and he hired me on my first case when I was just getting my feet wet. And I just have such great memories. He came to speak to my class. I teach psychology and law, and he guest lectured a few times in my classes, and students really loved him. So I wanted to say that before I got started. One more thing related to the research that I'm presenting today is how much I enjoyed Robbie Greer's presentation. And I don't know if Robbie is still watching, but what he had to say really echoes the research that I'm interested in doing, that I've been conducting over the last few years. He mentioned that for 20 years, he couldn't talk about the case that he was on, that it took many years for him to decide that it was time for him to seek counseling. And so that really speaks to one of my main interests here, which is in jurors' processing of information in the courtroom. So I'm going to share some slides with you. So this is what I'm going to be talking about today, and I'm going to give about a 12-minute presentation or so, and I'm going to share the results of a couple of studies that I've conducted on jurors and judges, along with my students at Wofford College, a couple of different groups of students that have been integral to carrying out this research. So let's start here with what is vicarious trauma and what is secondary traumatic stress. And so vicarious trauma, experience psychological trauma from secondhand exposure to traumatic situations. And so there are people in all kinds of careers that experience this kind of trauma, people in the medical field, people in the legal field, social workers, doctors, lawyers, et cetera. Of course, we're focusing on the legal field today. And one of the negative consequences of experiencing vicarious trauma is secondary traumatic stress. And so those symptoms are similar to post-traumatic stress: unwanted flashbacks, avoidance, nightmares, the potential for substance abuse problems, depression, anxiety, all of those things that degrade normal functioning. And so the research that I do, which is really in its infancy, is focused on how the stress of serving on a jury, as well as how judges are susceptible, both of those groups, how they're susceptible to secondary traumatic stress. And so let's begin with jurors. So I love this line: can jury duty actually be hazardous to your health? Of course, if you do a quick Google search on jurors and trauma, jurors and crying, jurors and stress, you're going to find a ton of articles like this. And I just grabbed some headlines that I came across. The trauma of jury duty, the hidden horrors of jury duty, why jurors are often left without counseling. So there's a lot of articles online about this. And so these are obviously sensationalized headlines, but the takeaway seems to be that some jurors, their experiences can be traumatizing. Now, these are all interesting pieces, but they appear to be full of anecdotal evidence. And so what I was interested in doing was looking into the literature to see what has been done scientifically on this topic. And it turns out that there has been quite a lot of research done that dates back to the mid-1980s. And so research looking at jurors and stress started out with what they call these free-flowing interviews. So the initial studies looked at a group of capital jurors, asked them about their experiences, and then some jurors from particularly traumatic cases. And so what it turned out was that, yes, indeed, many ex-jurors experienced symptoms that were consistent with post-traumatic stress and depression, things like nightmares, intrusive thoughts, memories, insomnia, avoidance, etc. And so these initial studies sparked a real interest in then going forward and doing very structured interviews and using more validated scales, psychological measurements. And so here's just a sampling of some of the results of those studies. In a couple of these studies, about a third of participants reported symptoms that were consistent with post-traumatic stress. Another study found that traumatic cases resulted in more post-traumatic stress and depression symptoms than non-traumatic cases. And then the Capital Jury Project, which has been going on for years, interviewing ex-jurors serving on capital cases, found that more than half were emotionally upset and a third had insomnia, loss of appetite. So again, these findings are really consistent with each other. We're finding that many ex-jurors are reporting long-term side effects. And so not just right after the trial, during the trial, really long-term side effects that are consistent with post-traumatic stress. And so overall, what are the specific factors that are associated with jurors' symptoms? And so I've listed what seem to be at the top of the list here, and gruesome evidence, graphic evidence, emotionally disturbing testimony. Those seem to be the things that ex-jurors list most often as contributing to their symptoms. Some other interesting findings, of course, the traumatic stress can worsen in the following weeks and months after trial. I think that's an important aspect of this to consider. And interestingly, that women tend to demonstrate more severe symptoms than men. So next, what is it that is being done to reduce juror stress? And so what I found were 3 different things that the courts are often offering to jurors. The first is pretrial conversations with jurors. And so this is simply just having conversations, the judge having conversations with jurors before the trial starts, letting them know what they might see and how they might be able to cope with what they're going to be seeing and hearing during trial. The second is post-verdict debriefing, led by either a judge or a clinician or both. And this is in a group setting, post-verdict, giving all the jurors the opportunity to discuss what they all just went through together, also giving them some ideas on how to cope with their stress, perhaps in the short term and the long term. And then third, perhaps most effective then is counseling, jurors being offered a series of counseling sessions. And this actually isn't all that popular in the literature that I have found. There are not a lot of states and jurisdictions that are offering this. One notable exception is Wisconsin did a pilot study looking at the effectiveness of offering post-trial counseling and found that it in fact is quite effective. Alaska is the only state that has legislation at this point, I believe, that mandates some counseling on the dime of the state. But the problem with that, and this speaks to what Robbie got to, which is the counseling sessions have to be used right away. The counseling that's mandated there, counseling sessions, they're free to ex-jurors, but they have to be used within several months. And it may turn out that people aren't ready to talk about it for several months, if not years, as Robbie mentioned. And so what me and my research team at Wofford were interested in looking into was what judges think about this. So in the first study that I'm presenting here, we did interviews, one-on-one interviews with jurors, which there's not a lot of that in the literature. It's a lot of surveys, but we wanted to do one-on-one interviews with judges, asking them about what they thought about what jurors go through. So we had 13 judges, circuit court judges in the state of South Carolina. We did one-on-one interviews with them. We designed a 14-item semi-structured interview that we conducted that took about 30 minutes. And we asked them things like, what do you think are the biggest sources of stress that jurors experience? Do you think they might experience stress in the long term? What do you think about these debriefing programs that are being implemented? So I'm just presenting some of the key findings today. So we asked, what are the typical sources of stress for jurors during a trial? What do you think, judges? What do you think are the typical sources of stress? And here's how the results broke down. The biggest one that was mentioned here was courtroom procedures. So being unfamiliar with the courtroom environment, insecurities about the law, also the emotionality of the experience, the shock of being involved in a trial, feeling empathy or sympathy for people that are testifying. Of course, deliberation was also something that the judges thought really weighed heavily on jurors. We asked judges, do you think stress or trauma could affect a juror's participation in the trial process? And over half answered yes. And of those that answered yes, we then asked how. How do you think stress affects jurors and their participation? And so here were the answers that we got. We grouped them into these groups. This one here, decision making. Judges were concerned that really it could affect their decision-making ability. Maybe it's going to introduce bias into the jury process, into the deliberation process, and influence other jurors. It might cause them to doubt their own abilities in the courtroom, and they might lose focus. Here we asked whether judges had witnessed reactions from jurors that led them to believe a juror was having a difficult time. And most of them said yes. So we asked, what kinds of things did you notice jurors doing that would lead you to believe that? And so things like averting their eyes when there was difficult testimony being presented or graphic photographs, jurors crying, jurors being panicked, emotional outburst, anxiety, etc. And then we asked if judges thought that jurors might continue to experience negative symptoms post-trial. Do you think they're going to continue having symptoms? And most thought that this was a possibility. And so after we completed this study, I wanted to turn to judges' experiences, their own experiences with many of these same things. What is the potential for judges to experience secondary traumatic stress based on their work? And my specific interest is in the things that they experience in the courtroom. And so I dug into the literature to see what kind of research had already been done in this area. And there's been several studies looking at different sources of stress. So here's the kinds of things that judges tend to say lead them to have higher levels of stress: the impact of their decisions, having a heavy workload, dealing with unprepared attorneys, repeatedly presiding over the same case with no resolution, worrying about their own personal safety, and then the kinds of things they're confronting in the courtroom during the course of a trial: gruesome evidence and emotional family court situations. And of course, they are also at risk of negative outcomes, that things that affect their job satisfaction, their likelihood for depression or anxiety, and ultimately burnout. And all of that, their own stress response varies as a function of how supported they might feel, their age, gender, coping ability. All of those affect the likelihood of experiencing those symptoms. And of course, ABA's recent publication outlining some coping mechanisms that might be beneficial: hotlines, mentorship programs, sabbaticals. And so I was interested in following up on this research, again, doing some one-on-one interviews. And I do think, similar to the idea of jurors, I think conducting one-on-one interviews, you can get you can go deeper with those interviews than you can in a survey type of situation. So here we were able to interview 18 circuit court judges in South Carolina and North Carolina. And we asked them items from a 15-item semi-structured interview that we developed, spent about half an hour with each judge. And we asked them things like things about sources. What are your sources of stress? What do you think the stress does to you, both mentally and physically, and how do you try to manage that stress? And so here are some of the findings from this research. So we asked, what are the top sources of stress as it pertains to hearing a case? Again, that's my interest in, is what's happening to judges based on the kinds of things they're dealing with in the courtroom specifically. And so you can see on the left-hand side of the graphs, what are the top sources of stress that judges said they're experiencing. Things related to children, the weight of making decisions in the courtroom, making life-altering decisions, overseeing how the court is functioning, and of course, trauma in the courtroom, gruesome evidence, and emotional testimony. Those are kind of at the top of the list here. We asked judges, are there certain kinds of cases or evidence that impact you emotionally? So on the left here we have the type of case. So at the top of the list was anything related to children, anything involving abuse, murder. What kind of evidence impacts you the most emotionally? Gruesome evidence, anything related to children is at the top of the list there. We asked judges, in what ways does your work affect you physically and emotionally? And I didn't know if judges would be willing to be forthcoming when it came to these two questions in particular, but to my surprise, they were all very willing to answer these questions. And so here's some of the physical symptoms on the left that they listed, the ways that they're impacted physically. At the top of the list was trouble sleeping, fatigue, high blood pressure. Some said they're not affected physically. Emotionally, here on the right, many said they felt isolated. They could no longer connect with for instance, their friends that they used to be, the attorneys they used to be friends with when they were attorneys. That they couldn't talk with them about their cases and what they were experiencing. Irritability, being anxious, overwhelmed. Some said they don't experience any emotional symptoms. We asked what strategies they use to manage or reduce their work stress. At the top of what they mentioned was exercise, hobbies, time with loved ones, reading, distraction, trying to distract themselves, being in a good routine. And then last, we asked what they thought about the possibility of stress reduction strategies at the organizational level, things that could be offered to them. Would this be helpful on the left? And most thought that yes, or maybe this could be helpful. And we asked, well, what kinds of things would you like to see? And at the top of that list was workshops, educational programs, also having time off. So to wrap this up, when it comes to jurors and the potential for secondary traumatic stress, overall from our research with South Carolina judges, they're clearly they're in tune with the fact that there's the potential for some real troubles when it comes to what jurors are experiencing. And this is a great quote from Leslie 2017. It is time to reform the age-old jury selection process to bring it in line with our modern awareness of mental health issues, especially since jurors are duty-bound to serve if selected, despite the risk of injury to their mental health. So it's obvious that the stress associated with jury duty can result in really serious negative effects on physical health and mental health. I think we need to think very seriously about what jurors need if we're going to ask them to be involved in trials that they don't have a choice over. And similar to what Robbie mentioned, they may need immediate and delayed counseling in order to help treat what they went through in their experience. And when it comes to judges' susceptibility to secondary traumatic stress, I think this is an understudied area and there needs to be more research. It's going to be important for research to start examining perhaps how decision-making might be affected by long-term stress over the course of a judge's career. We might need to start talking about really the efficacy of workshops, sabbaticals, et cetera, to help reduce judicial stress and find more information on whether these are practical at helping jurors or judges. This is ongoing research in its infancy. I would love to talk with anybody who has interests in this area. I myself am on sabbatical this semester, and I'm spending a lot of time thinking about what the next step are and what needs to be done empirically. And I would love to talk with anybody who's interested in this area. And I also want to acknowledge this research could not have been done without all of the people listed on this slide. I had two excellent teams of Wofford researchers, some students who helped conduct these interviews. On the left-hand side, especially big shout out to Abby Brasington and Dylan Hooper, who we wrote a joint article reflecting these findings together. And then on the right-hand side, Alyssa Rogers and Erin Tinkler, we will be presenting these data at a conference, the American Psychology Law Society, coming up soon. Chelsea McNeil, Circuit Defender, 8th Judicial Circuit in South Carolina, as well as Professor Mark Rabel. They helped us get in touch with the judges who, thank you to all of the judges who helped us out with this research. We couldn't have done it without you. So that wraps up my presentation. Thank you so much. for listening to that. And I want to now introduce the second person who's up. Actually, it's a group of people who are up next. I want to introduce Mark Rabel from Wake Forest School of Law, Dr. Stephanie Walker-Seaton from Wake Forest School of Medicine, Kimberly Wiseman from the Wake Forest School of Medicine. And the four of us are involved in another study of secondary trauma, focused specifically on capital defense attorneys. We've been spending the last several months developing a survey to be sent out to capital defense attorneys. So I want to ask Mark, Stephanie, Kimberly to turn their cameras on and their volumes on, and I'm going to hand it over to them to talk about their project.
Thanks so much, Dawn. Yeah, sabbatical. I think that's the overarching answer to everything that we're going to talk about today. Everybody needs to take a break from this stuff at some point because we don't realize what's going on. We're going to be probably the briefest panel because even though we've been working on this for a while, we've only just sent a survey out to capital defenders in North Carolina. We actually started talking about this a few years ago when I made a presentation at the medical school to a group organized by Dr. Mark Wolfson, who's now gone on to teach in San Diego. But Stephanie Seaton and Kimberly Wiseman have wonderfully agreed to assist with this particular project. So here's how it came about. I mean, as I've already talked about, and as Larry Hammond talked about in the very first comments that we had in this symposium today, I and Larry realized that secondary trauma is a thing. It affects our work, it affects our partners, it affects our children. As we heard from Robbie, it affects jurors. It affects lots of people around us. And so one of the remedies would be to understand how we are affected. Can we document that there is an effect? In researching this several years ago when I first started, I found that there was a study done of public defenders in the state of Wisconsin. And in that study, which was the type of study that we're doing and that Professor Lindsay Harris is going to talk about here in a few minutes, there's certain scales that are put together that I'll ask these guys to talk about in just a second here. And in order to document whether people are suffering from either secondary trauma, vicarious trauma, fatigue, and those sorts of things. And we wanted to compare how capital defenders do in comparison to public defenders in Wisconsin who handled violent cases. In other words, they had to defend violent cases. And there was a definite increase in fatigue, burnout, substance abuse, marital difficulties, all of the things that you don't want to happen because of your job. But after that, there didn't seem to be a whole lot of studies. Now there are some that are beginning to be done. So I asked these guys to help me figure out how we could do this scientifically so that we could show that, yeah, this is a thing. And we actually sent out yesterday after we had to get a lot of different approvals from the Institutional Review Board in order to be able to, I guess, experiment on people. It's not really experimentation, but it comes within the purview of that. But let me ask first Stephanie Seaton. And by the way, Stephanie has she's got her PhD in psychology and law with a minor in statistics from the University of Wyoming. She's has experience as a professor, department chair, research associate, and currently is with the medical school here at Wake Forest in the Department of Public Health Sciences and Wake Forest University's bioethics program. And Kimberly Wiseman has a master's in psychology, also from Wyoming, and has 10 years conducting mixed methods research in psychology, law, and public health. And she's also at the medical school here at Wake Forest. Maybe Stephanie, can you talk a little bit about how we designed this, and then we'll talk to Kimberly about whether within 24 hours we have any results from our survey yet.
Yeah, absolutely. Kimberly, I think, has some slides available. Quickly, while she's pulling those up, I want to thank those from the first panel for sharing your stories and emphasizing the importance of mental health care. I really appreciate that. As Mark said, we with most research, we stand on the shoulders of giants. So we pulled most of these scales from that Wisconsin study. The first is the positive and negative affect schedule. The short version, PANAS, is what it's referred to. And that measures your positive and negative feelings. And it was invented by Edmund Thompson in 2007. We have the Sheehan Disability Scale, or SDS, and that assesses your functional impairment in work or school, social, and family life, created by Sheehan in 1983. We have the Satisfaction with Life Scale, created by Ed Diner and all in 1985, and that measures your global life satisfaction. We have the Professional Quality of Life Scale, created by Henry Stamm and his colleagues in 1995. That measures compassion satisfaction, burnout, and compassion fatigue, which is obviously related to secondary trauma. We have the Impact of Events Scale revised. This evaluates distress one feels in response to trauma, created by Daniel Weiss in 2007. And finally, we have the Center for Epidemiologic Studies Depression Scale, or CESD, which screens for depression, and that was created by Radloff clear back in 1977.
So I'm going to take it from here. I was able to pop into the data last night, and we have 16 completes, so a very, very small sample so far. But I wanted to kind of share just a little bit with us since we had some data. So like I said, 16 completes. We had an additional 7 that were partial completes. And first, looking at some of the demographics, you can see that so far the sample is heavily male, heavily white, and the average age is about 59 years old. And when you look at the years of experience, the sample so far is also pretty heavily skewed into heavily experienced capital defense attorneys. I'm also going to show some outcome data, but I just wanted to give a caveat before I do. This is a very, very small sample. And so, I'm going to show the data, but obviously we're not really drawing any conclusions at this point. And the trends are obviously probably going to change as we continue to have more people fill out the survey. So here is a preliminary look at some data with that caveat. I looked at the percent of the sample experiencing significant PTSD symptoms as measured by that impact of events scale. And in our sample, which is the gray bar on the left, we have about 21% of the sample experiencing significant PTSD symptoms. And then I wanted to compare that to the Wisconsin Public Defenders from the Levin study that Mark referenced. And so in that study, they had about 11% of their sample. I also looked at the percent of the sample experiencing significant secondary traumatic stress as measured with the Professional Quality of Life Scale. And in our study, we've got about 25% so far experiencing that significant secondary traumatic stress. And that's as compared to the blue bar in the Levin study, which is 34%. So, like I said, this is just a very, very quick dip into our very small sample so far. But, we're continuing to collect data. We're in the field right now, and we'll be doing a very deep dive of everything we collect and publish a paper in the future. So that's sort of where we are right now. Mark, I know you hadn't seen any of this. Do you have any follow-up questions?
No, I thank you guys so much. I know that's a very small sample. We sent out about 300 and some surveys to people that are on the list in North Carolina to defend capital cases, including Office of the Capital Defender, as well as private attorneys and public defenders. A couple of observations. Yeah, since it's mostly the old guys like me, they're mostly white, which is, and like I said, we're going to talk about race this afternoon, but this is a huge factor. And hopefully some of our studies with this capital defender study will talk about race and gender in terms of how people experience things. And I know Professor Harris in the next talk is definitely going to talk about that. The other thing is that I don't know if you want to call it a kink in the works, and maybe Stephanie or Kimberly could comment on this, but we didn't know the pandemic was going to happen when it did. And so some of our questions had to be retrospective to prior to the pandemic. How were you feeling about this, that, and the other? Either one of you guys have any comment about the pandemic factor?
I'll just speak on it briefly. We did, what's the word I'm looking for? Modify, I guess, the questions to try to relate to a more typical time period. So for example, one of the scales might have asked, how often did you feel this within the past week? And so we did modify those items to how often did you feel this in a typical week, prior to COVID, sort of. We had a disclaimer, that we encourage participants to think about their experiences in sort of the pre-COVID world where things were more quote unquote normal.
Thank you, guys. I want to say we're continuing to work on that North Carolina Capital Defender study. We intend to do it as well in other states like Arizona, in which there are active death penalties, to see if there's comparisons, similarities, or differences. For all you funders out there who would like to help out with that, please let us know, because these things, are resource heavy, and we could certainly use some help. I'm also working with the Innocence Network, which is a combination of the 70-some innocence organizations around the United States that deal with innocence cases. And we'd like to do a study of all of the innocence attorneys and staff people as well. And eventually also with capital defense and with innocence, people who are not lawyers, like paralegals and investigators, fellows, law students, that sort of thing. But I think we'll certainly write all this up. A lot of these will be written up in the law review that's going to be published. I think some of this stuff about the North Carolina Capital Defender study will also be more of a research type article in a psychological journal in a little more scientific way, so that it could be relied on in your workers' comp cases when you sue for occupational disease as part of your job. I'm not advocating for that. I'm just hinting maybe it might be relevant. Hopefully more to make reforms. But Dawn, I think probably great to get on to Lindsay. Thank you, Kimberly and Stephanie. And Dawn, did you have anything else to add? I'm sorry, I was rushing.
No, that's okay. The only thing that was great. And Kimberly, I'm excited that you were able to put together some results very quickly. So thank you for presenting that. So I wanted to add that there might be people watching now that your email, Mark, was sent to yesterday. So I think we all want to ask that it would be great if you filled that survey out and got it back to us as soon as possible, because we're anxious to dig into the data. Anything else, Mark? Or
No, thank you.
Okay, thank you. Thanks to Mark, Kimberly, and Stephanie for that presentation. And we're going to move on to the last presentation and hopefully have a few minutes for questions at the end. Next up is going to be Lindsay Harris. So Lindsay, can you please turn your camera on and your volume on? There you are, Lindsay. Lindsay Harris is an associate professor and director of the Immigration and Human Rights Clinic at the University of the District of Columbia, David A. Clark School of Law. She will discuss a study of secondary trauma focused on immigration attorneys.
Thank you so much, Dr. McQuiston. And I'm just setting up my slides, but I wanted to start by thanking the Wake Forest Law Review for having me for this incredible symposium today on a topic that's near and dear to my heart, and I think critically important to how we lawyer and how we train law students. So today I'm going to talk to you about a survey of 718 asylum attorneys in 2020 focused on assessing burnout and secondary trauma. I myself am an asylum attorney, so I'm essentially studying myself. And I just want to start by saying it's very intimidating to be speaking alongside research psychologists with PhDs who research these issues and talk and write about them. So just going to take a deep breath and start talking into the small screen in my basement. So thank you for having me. Asylum attorneys are one subset of immigration attorneys. So there have been studies done on family lawyers, on public defenders, as has been mentioned today, and lawyers practicing other areas of law. There really hasn't been any work done on immigration attorneys. There's been one study of immigration judges back in 2007, 2008 that my work builds on. But asylum attorneys, essentially immigration attorneys could practice many different areas within immigration laws, from business immigration to family immigration, family-based petitions, to removal defense in immigration court, which may include asylum work, to other humanitarian work, including U visas and T visas for victims of crime and victims of trafficking. So in focusing on asylum attorneys, I'm not saying that other immigration attorneys or attorneys more broadly may not also be suffering from secondary trauma and burnout, but I did decide to zero in on this one specific population. And I'd like to start by telling you why. And in doing that, I want to tell you a little bit about the asylum seeking process, in case you're not familiar with it. Thanks to the Trump administration, I think many more people these days know what I mean when I say I'm an asylum lawyer. They don't think I'm working with people maybe inside an insane asylum was sometimes the assumption. People have more of a sense of what an asylum seeker is and what the asylum seeking process may involve. But I want to set up what it is and how it may mean that asylum attorneys are especially vulnerable to potentially suffering from secondary trauma and burnout. So most asylum seekers themselves are trauma survivors, survivors of torture or trauma. They then come to the US and have to go through an inherently traumatic process. They are required to, as has been mentioned this morning, retell and relive the worst moments of their lives over and over again in great detail. That is required to establish credibility for the adjudicator, the immigration judge, or the asylum officer to believe them and to grant them asylum. Asylum seekers may also be subject to highly dehumanizing detention conditions, which have only been exacerbated further by the COVID-19 pandemic. These cases are also very high stakes cases. So we've talked a lot about death penalty and capital offense cases today. In asylum cases, the consequences of someone being returned to a place where they face persecution or torture or death are very high. So they are, as one immigration judge has said, Judge Dana Marks has said, asylum cases or immigration court is like cases with death penalty stakes in traffic court. So the demand for services is also incredibly high. So asylum attorneys are unable to meet that demand for pro bono, low bono, or even paid services. And asylum seekers themselves are not eligible for any kind of federal benefits while they go through the asylum seeking process, and very rarely any state benefits too. So they're really struggling to adjust to life in the US with the trauma they've suffered back home in the home country, often also the traumatic journey to the US, and then what they've faced since arriving here. And they often have no access to work authorization for a long period of time, and I could talk for hours on that. So they have no real way to support themselves. So very vulnerable individuals who are incredibly resilient and strong, but also really at risk of exploitation. And there are immigration court backlogs, and backlogs at the asylum office mean these cases can go on for anywhere from 1 to 10 years, essentially. Really, really a backlog delayed system. You also have a fairly dysfunctional system where there's a phenomenon called refugee roulette, where there are disparities in adjudication. So an asylum seeker in Atlanta, Georgia, for example, or Charlotte, North Carolina, may have a less than 2% chance of being granted asylum ultimately by an immigration judge, whereas asylum seekers in other jurisdictions, like maybe New York or San Francisco, may have a much higher rate. Some judges have an 80% grant rate for asylum cases, for example. Finally, there's this issue that asylum doesn't actually cure all ills. It doesn't actually remedy the human rights abuses that have occurred. All it gives the asylum seeker, if granted asylum, is the opportunity to rebuild their lives again in a new place. It does not, the perpetrators of the harm, of the human rights violations that have occurred are not brought to task, or there's no justice in any sense there. And the underlying root causes of the human rights abuses themselves are not addressed. So attorneys in the survey that I did put out, and 718 attorneys consented and responded completely, so that's the data set I'm working with, did share in the one open-ended question at the end of the survey feelings of feeling complicit in a dysfunctional system that many of them found, and I would agree here, is xenophobic and racist. So this is all of this that I've just described is pre-Trump administration. So all of this was happening before the Trump administration. The last 4 years have made it even more difficult to seek asylum, to be granted asylum, and to go through the process of accessing counsel and obtaining asylum. So I'll just go over this briefly, and I've written a whole different article on this. It's called Asylum Under Attack. If you want to Google it, it's available on SSRN. But from turning people back at the border at the end of the Obama administration and the beginning of the Trump administration, metering, which means just a very few number of people are allowed in on one day, or none very often, to family separation, which really catapulted asylum seekers and immigration issues into the spotlight in 2018 when that policy came to light and Jeff Sessions started overseeing the policy that separated families at the border, ripping children, infants from the arms of their parents through the zero tolerance policy, zero tolerance for unlawful border crossing, so entering without papers. That's actually permissible for asylum seekers. There's nothing illegal about coming and seeking asylum without documentation. There's no way to get that documentation or to seek asylum outside the US. The Trump administration also put in place asylum bans, and I won't get into detail on what that means really, but essentially restrictions on people who do enter between ports of entry, even though they weren't allowed to enter at ports of entry to seek asylum, and then also restrictions on people who had transited or gone through other countries before coming to the US. You may have heard of the Migrant Protection Protocols, or the Remain in Mexico program, which advocates often call the Migrant Persecution Protocols, because it had led to more than 65,000 people being sent back to Mexico while they awaited their US immigration court cases to claim asylum, and in very dangerous, precarious conditions, subject to targeting by cartels and other organizations that were literally preying on people waiting at the border to come into the US. There's been a series of attorney general decisions from the various attorney generals who served under Trump to undermine protection specifically focused at people fleeing gender and gang-related violence, as well as agreements that have now been suspended by the Biden administration State Department with the Northern Triangle countries of El Salvador, Honduras, and Guatemala to basically send asylum seekers to those countries instead of allowing them to go through the US process. There were fees introduced. They tried to put fees in place for seeking asylum, which has never existed before in the US and not many places in the world. New rules for work permits to delay access to work, really pedantic, persnickety rejections of applications for asylum based on, for example, failing to list the location, geographic location of your deceased relative on the form. You know, what do you put in that box? So again, an inherently traumatic process that was made worse in the last 4 years. There's also been the COVID ban under Title 42 of the Public Health Act at the border that has literally stopped asylum at our southern border and is essentially still in effect today. And then there's been an onslaught of proposed regulations. I think I counted 19 sets over the last couple of years, focused on asylum and focused on restricting access to asylum and making it more difficult to access asylum. So these are not even all of the actions under the Trump administration that were aimed at dismantling asylum protection, but it gives you an idea. And essentially, asylum attorneys have been navigating all of this. It literally changes every day. It might have changed today, right now, while I've been speaking to you in the last 10 minutes. So my question was, going into this research, having been personally affected by doing this work, working with trauma survivors, but then also just the trauma of the system, was what does this mean for the advocates? And I did focus on attorneys here. I would love to do broader studies where I could focus on paralegals, accredited representatives, support staff, social workers, all those who are supporting and making this work possible for attorneys, who also may be more directly affected than attorneys. Some attorneys assign support staff to actually sit with clients and draft their detailed declarations of what they have endured and what they fear to support their asylum claim. So I started to look at this, and I wouldn't say there's been mainstream media attention on this, but there has been some media attention. Some media are starting to pay attention to this issue, looking at immigration attorneys and burnout. Immigration attorneys leaving the profession quite quickly because of the stresses that they were feeling. So in 2020, and again, I didn't mean to launch my study during a pandemic either, but I did. So in 2020, I launched this survey, and I came up with the questions in conjunction with Dr. Stuart Lustig, who had been part of a prior study of immigration judges back in 2007, 2008. So my study uses the same two scales that they used in that study. So I could kind of compare immigration judges versus this subset of immigration attorneys. So 718 asylum attorneys completed the survey between February 25th and May 15th, 2020. So there's kind of about half who completed the survey before what we determined as the lockdown period, kind of maybe March 13th was the date we decided to divide kind of pre-COVID and post-COVID. And obviously this is also just during the first few months of the pandemic. I'm not going to share a ton of results on that, other than to say, interestingly, the rates of burnout and secondary trauma were actually a bit lower during the pandemic times. And there's lots of reasons why that might be, why lawyering became more stressful and less stressful during that time. For a lot of people during that specific period, the immigration courts did slow down a bit. The asylum office shut down. So they were probably having less actual exposure and contact with their clients and with the traumatic stories that they would be hearing. And also commutes would definitely would have been reduced. There was a little bit more time for family, or less, depending on your situation. I have 2 young kids, 2 and 6. So definitely them being home didn't lead to me having more time. And I'm sure many of you, that resonates with many of you. But for colleagues who do a lot of detention work, for example, that became increasingly stressful as we literally fought to, and are still fighting to, get clients released from immigration detention who have pre-existing conditions or who are especially vulnerable or just in detention during this pandemic. So it wasn't a huge effect, but it was actually interesting that burnout and secondary trauma were slightly reduced in the population of attorneys, about half who took it post-COVID. So I used questions using the Copenhagen Burnout Inventory and the Secondary Traumatic Stress Scale, and I'll tell you a little bit of that, and one open-ended question at the end of the survey. I had about 321 responses, so 321 people wrote in and shared something at the end, and I'll share a couple of those responses with you, but they're incredibly rich. And then the beginning part of the survey focused on attorney characteristics, so kind of some demographics around the age of the attorney, race and ethnicity, gender and gender identity, the circuit courts that they practiced before, so which jurisdiction they're in by circuit, their office size and type, so solo practitioners versus academics like me who teach in a clinical setting, versus nonprofit practitioners, people who are in small firms, large firms, medium firms, to get a sense of how that might affect levels of secondary trauma and burnout. Also, how many support staff they had, and then the volume of asylum cases they're actually handling. So the number of cases on their docket, as well as their estimated weekly work hours. So those are all the factors that we tried to consider. So just to share with you a couple of responses, and these are, I'm not being dramatic here, these are pretty symbolic and representative of the wider set of 300 responses. So here's what one attorney wrote at the end of the survey. I think this administration has created a generation of public service workers with serious PTSD from the absolute chaos and the horror of the changes in the immigration system. It feels like we're all drowning and there's no one to save us. So really honing in there on the effects of the Trump administration specifically. There were attorneys who wrote and said, I've been doing this since 1982, and this is the worst it's ever been. There were a few people who wrote that in. Another attorney shared, it's like hacking away at a cement wall with a plastic spoon. There are no walls to describe how awful it is to tell a client they have to go back to the place where they're in so much danger that the law doesn't protect them, especially after we grow so close to our clients. So I'm just sharing a couple of those quotes to give it a little bit of texture to the numbers I'm about to share. But before I do, I'll just explain these two scales very briefly. And the previous presenters shared some other tools that have been used. But again, I use these two scales specifically because there had been one study at least done in the immigration arena. So the Copenhagen Burnout Inventory is measures kind of 3 dimensions of burnout, and then it also gives you an overall score, and the score is on a scale of 0 to 100. And I am not a math person, so I'm doing my best with presenting this to you all. I have a fantastic co-author, Dr. Hilary Mellinger, who has helped me to understand all of this and who ran our regression analyses, and I had to look up what an regression analysis even was, so bear with me. I just want to share with you the dimensions of burnout that the scale measures. So first, personal burnout. And personal burnout is the degree of physical and psychological fatigue and exhaustion experienced by the person who's being surveyed. Then you have work burnout, which is that same thing, but perceived as the person as related to their work. And then client burnout, and that basically is the people work, and it refers to the extent that individuals, here asylum attorneys, may feel frustrated or exhausted as a result of working with clients. Here, that would be asylum seekers. So the second scale we used was the secondary traumatic stress scale. And as Professor Rabel and others have mentioned, secondary traumatic stress often mirrors PTSD symptoms. So for PTSD diagnosis, you would need to have symptoms of intrusion, arousal, and avoidance. And then there's also an overall secondary traumatic stress score. And this is on a 1 to 5 scale, so different numbers. So there's 19 questions in this scale, and they basically measure, intrusion, focusing on intrusive thoughts, maybe nightmares or unintentionally thinking about your client-related work during non-work hours. For me, actually, as a survivor of trauma myself, I think of this as when you lose the ability to decide when you get to think about that traumatic event or exposure that you've had. Avoidance, that's pretty understandable, kind of avoiding working on your cases or work. And then arousal, thinking here about things like hypervigilance or sleep disturbance, feeling very restless, etc. So I'll share with you these numbers. Again, I am not a statistics person, and I rely heavily on Dr. Mellinger as my co-author here. In terms of the overall findings on secondary trauma and burnout, asylum attorneys scored highly on both scales. And so what I want to do here is show you a couple of comparisons with other professions and other helping professions who've taken the same kind of test, and they have a mean score overall. So first, on this slide, I have asylum attorneys compared with prison wardens, hospital doctors, nurses, social workers, and midwives who've taken the same Copenhagen burnout inventory. And I'm looking at the work burnout here. So how burnt out are you physically, emotionally exhausted by your work? And as you can see, asylum attorneys are at the bottom, and they're about 63 on the scale of 0 to 100 versus, midwives or prison wardens. Everybody else is in kind of the 30 to 42, 43 range. Immigration judges are very high too. So they were about 56 on the scale when that population was surveyed. And this is just, of course, the asylum attorneys actually surveyed, and we can't really generalize to everybody, but I think it's still quite helpful to see these numbers. And then similarly, on the personal burnout, asylum attorneys, again, are higher than everybody else, all the other populations I could find that have taken this specific burnout assessment tool. They're still, about 10 points higher on the scale than immigration judges. They're much higher than hospital doctors, right? And there's been studies of ER doctors working with people coming in and experiencing trauma. It's the same thing. Asylum attorneys are really high on this scale. And the client burnout scale, they are the highest again, but not as high, which is interesting here. So you can see the other two scales on work and personal burnout, they were about 20 points higher than most of the other professions. Here it's just a couple points higher than the immigration judges. And, I don't know why that is, but a lot of attorneys spontaneously wrote in that the survey seemed designed to say that this was all about the clients and the exposure to the clients and the trauma. And they wanted to make clear that it wasn't the clients, it wasn't hearing the traumatic stories, it was the system and the dysfunction of the system. So on secondary traumatic stress, I just have a comparator with immigration judges. But again, asylum attorneys scored much higher on the scale of 1 to 5 than immigration judges did. And, this is not actually surprising. So Dr. McQuiston talked about her research on judges, and I don't want to minimize secondary trauma in judges, but, and the judges still score higher than other helping professions here who are in immigration court, those judges. But the asylum attorneys, it kind of makes sense that they would have higher secondary trauma because they're working very directly for hours on end to prepare testimony for court with asylum seekers. And immigration judges are essentially just hearing that neatly packaged testimony on the day of the trial. So I'll just end by sharing a couple of thoughts on the attorney characteristics that we looked like. So consistent with other studies of lawyers in the past in Canada and the US and various lawyer attorney populations, our average scores for females definitely were higher on both burnout and secondary traumatic stress. And I learned today that this is the same with jury members. So we need to especially be concerned about female identifying attorneys. Also, every non-white group of attorneys measured higher on both scales than white attorneys. So I'm really interested to hear about the panel this afternoon, thinking about race and secondary trauma, because that's definitely something coming from my study and some other studies. Higher age, however, actually reflected lower stress levels, and I'll leave it to you to imagine why that might be. And then the other findings, so this is probably not surprising to you either, but solo practitioners responding to the survey reported higher levels of secondary trauma than other attorneys in small, medium firms, nonprofits, or academia. Having zero support staff also definitely made a difference, and those with no support staff had much higher levels of both. And as you might imagine, weekly hours were predictive of higher secondary traumatic stress scores, but actually not statistically significant for higher burnout. So that was an interesting finding. Maybe those folks have kind of figured out ways to manage that. One thing, some things we didn't look at that we should in future studies are kind of supervision, and does that make a difference? Prior trauma in attorneys' lives, right? Are those of us who have suffered any trauma in our lives especially affected? Prior studies do suggest that that is the case. And then, especially important in the last year, kind of having children or having other child caregiving responsibilities and how that might affect things. So I will just say, I wasn't surprised by these results, having worked in this field for a while, but I think it's valuable to have some data around these phenomena. And I've suggested areas for further research, but I'm looking forward to the next panel where we'll be talking about what we should do about clearly documented stress levels and burnout in asylum attorneys, likely if we studied them, immigration attorneys more broadly, and attorneys practicing other areas of law. I think that in immigration, solving some of the dysfunction and unfairness in the system is very important. We need an Article 1 independent immigration court so that we're not as subject to the whims of the political branch in terms of our immigration system. But beyond that, we need to normalize these discussions around our emotional responses to lawyering. And that starts in law school and thinking about our clinical and non-clinical curricula, but it also extends to the legal profession and thinking about how our institutions, state bar associations, professional membership or organizations, and then employers at every level in the system, what we need to do in order to properly address, prevent, and then mitigate symptoms of burnout and secondary trauma. So I'll stop here, and I'm really thankful to be here. I also just want to acknowledge that none of the work I've done, and I'm happy to share my draft article, would have been possible without my mother flying from California and moving to the DC area to care for my child and during remote school in the pandemic. So a big thank you to her and my husband for their support, and to my institution for some summer research funding last year. But thank you so much, and I look forward to any questions.
Great. Lindsay, that was very interesting. Thank you. That was fantastic. And I know we have about 8 minutes for questions. Questions have been coming in to the conference organizers, and I have a few that I'm going to ask. So if all of the panelists from panel 2 would go ahead and be on camera, go ahead and show your videos and unmute yourselves so we can all answer some questions. And there's a few that I think have probably pretty quick answers. Let's cover those first. Have you considered specifically targeting and reaching out to capital defenders of color from outside of North Carolina in order to create a more representative sample? So Lindsay mentioned this in her talk just now. There's going to be a panel on this afternoon, but Mark or Stephanie or Kimberly, anything to add to that?
Well, I think when we reach out to other states, they'll be included. But that's a good question, though. We'll have to think about that because it's a whole different set of issues. I mean, great in the sense of when I first started doing capital cases in the 1980s, there were maybe 1 or 2 Black attorneys, and it has only very gradually increased. It was mostly white guys like me, and then women started being added in really only in the last 20 years, with obviously some exceptions, but yeah, it's been a white male thing, and I think there are reasons for that we'll go into this afternoon.
I'll just add, sorry, in the immigration context, studies show that 65% of immigration attorneys working full-time are actually white women. So it's actually a more female-dominated profession, and my study does reflect that. And, you know, we had a good number there are 154 people who responded to the survey identified as Latinx or Hispanic, but some of the other numbers were very, very low in terms of Black attorneys or Middle Eastern attorneys doing this work.
Great. Here's another question. Why do you think states are so resistant to provide post-trial counseling? Is it cost, lack of knowledge about the problem, stigma? Mark might have additional thoughts about this. All of you might have additional thoughts about this. I would say in my research and conversations with judges, yes, I think it's the idea that there isn't money. There isn't money to provide something like this. And interestingly, to add to that, I think it was the pilot study that I talked about. I think it was Wisconsin, did a pilot study looking at the effectiveness of providing counseling to ex-jurors. And their conclusion was that it's really a small subset of jurors that we're talking about here when you think about the cases that are going to involve the kind of evidence that we're talking about. This isn't every trial. It's really a small subset of jurors that that the courts would need to provide this for. And so it really might not be the kind of expense that the courts think that it might be. Anybody have anything to add to that?
I think that's right. I think largely it's a matter of expense and awareness. You know, as traditionally a death penalty lawyer, I would probably say there's also a fear that creating evidence of trauma of jurors could create some sort of argument that the death penalty is unconstitutional. That would be my personal opinion, that makes it cruel or unusual if it affects the people in the system that way. But I think most judges and people in the system are just not aware of it. And if they were, they would certainly want to protect the jurors. So I think it's not only the capital cases, but particularly, as we've already heard some from Andrea about the sex cases. Sex cases with children are absolutely the worst. They're like, you know, homicide cases with children are, I find, and most other capital attorneys find to be the most traumatizing. And certainly they got to be that way for jurors.
Great, thank you, Mark. To everyone, but Lindsay specifically, what good habits do you recommend for people that are entering a field like immigration or public defense for that matter, to help them sustain their work for a full career?
So this is a huge topic and I've written many pages on this, but I'll just say that if you're entering this field or in your first few years, talking about all of this is really kind of counterculture, because I think law school really has a mentality that it's good, you know, to pull all-nighters, to just be so committed to the work and to the cause, and maybe specifically in public interest arenas. You know, we think first about our clients and not about ourselves. We don't want to talk about our emotional responses to this because, again, you know, we are not the primary victims or survivors of this trauma. And so there's a kind of like burn it all down, win all the cases all the time mentality. And I think that what I would say is one person can change a culture. So if you can listen to all those cliches about, you know, putting on your mask first as the plane is going down, or you can't fill from an empty cup, and actually normalize and prioritize your own well-being, you know, mental, physical, spiritual, all the dimensions of kind of self-care, that can actually lead to some kind of institutional changes and people around you also feeling like that's okay. One really effective thing, you know, Professor Rabel talked about a gratitude practice. Another one that I really like is kind of an accountability practice. So finding a couple of people who are in your field, right? Maybe they're in your public defense office or wherever you are, and kind of like setting up a text chain and just sending each other messages every day. Like, what did you do for yourself, right? What did you do to carve out a moment of time for yourself, and just kind of building on that and making it feel like it's okay to spend this time on ourselves, and to push back on so much of what Eileen spoke about this morning in terms of the culture of just focusing on the work and not talking about our emotions. So there's a lot that has to change, but it does start with you, and then pushing your institutions, pushing your law schools if you're a law student, to think about these issues more.
Great. There's so many great questions, but we only have a couple minutes left. So know that if you sent in a question, I'm looking at all these questions. this one just came in and I haven't read the whole thing yet, but I think it's worth asking. What advice would you give to a prospective law school student who has gone through sexual trauma? This was the reason that it took me 13 years after undergraduate school to apply. Also, I was an undocumented person since the age of 5. So I feel like that affected my value and worth to society. Any thoughts there for the group?
Don't want to dominate the discussion, but I'll just say I would be personally happy to connect with you and have connected with others. Sometimes the things that we do endure in our own lives are driving forces behind the work that we do, whether we realize it or not. Most of my work has focused on working with survivors of gender-based violence too. And I think that, again, it's so important to take care of yourself and to reach out and take advantage of some of the resources you have available to you as a law school, probably through your school and through your local bar association. And yeah, there's a lot that first of all, we're so happy to have you in the legal profession. So thank you for taking this step, right? No matter how difficult your journey has been, you deserve to be here. We need you. And thank you for stepping up. And we really need your voice as an attorney in this profession.
Great.
From a psychological background, I want to emphasize that you should definitely take Lindsay up on that. Social support is often the #1 resiliency tactic that we find in our research. So finding that social support and understanding that there will be triggers, especially if you're going into law school, and being prepared to handle those.
Great. Another quick question. Do you think the nature of the position affects judicial health in that judges are generally viewed by the public as these, quote, all-knowing, impartial, and even-keeled or non-emotional figures, so they may be more hesitant to show their emotional trauma? I know in the conversations that I had with judges and my students have had with judges, that is absolutely the case, that they are not supposed to show anything, any sort of emotion. And then last, one more quick one, Mark, this might be to you, but maybe to the whole group. Are you aware of any studies or research being done for other types of lawyers who deal with highly emotional cases, family law, domestic violence, etc.? If so, is secondary trauma consistent across those professions?
Lindsay may actually know more about that. I know there's articles written about it, studies, I'm not sure. Lindsay, do you know?
Yeah, there have been some small studies done. I can't kind of cite them off the top of my head, but I do in my very long law review article that I'm about to submit next week. So I'll have that up on SSRN next week, but I'm happy to share a draft with anyone who wants to contact me. I'm on Twitter, and my email address is easy to find on my school webpage.
Great. I know we're over time by a couple of minutes, so many great questions, but I want to thank all of the panelists on panel number 2. I want to tell you what an honor it has been to be able to speak with you all today and to moderate this panel. Thank you so much to Mark Rabel for organizing this amazing event. But thank you to panel 2, and now I'm going to pass it back off to Mark.
Thanks so much, Dawn, and thank you everybody so far. I know to me personally, this has all been very moving, and I think from what I'm hearing from text that I'm getting, that people are definitely being affected by the things that the panelists have been saying. I mean, in an ideal world, this is where we would stop and take 15 minutes for silent meditation, but Kyle and Ethan would not want me to do that right now, but we may do a little bit of that during the lunchtime period if you want to hang around. So this really brings us to one of the last questions that Dawn was posing to the last panel, particularly to Lindsay. Secondary trauma is a thing. We are documenting it, and those of us who are lawyers and those of us who are married to lawyers, those of us who've been on juries, we know the trauma is a thing. And we know from our clients who've been traumatized that they're re-traumatized, and we need to learn about that. The next panel really gets into the question of, okay, what do we do about it? And we're going to hear from, let me call up Mark Godsey and Donna Mayerson. Dr. Mayerson, if you guys would appear. So we're going to hear from these guys who run the, or work with, or run the Ohio Innocence Project. And then we're going to hear from somebody with the Department of Justice, And then we're going to hear from a psychologist who has all of the answers. No pressure, Kate. But let me first call on Mark and Donna. So Mark, he's got quite a broad background. Right now, he's the director of the Ohio Innocence Project. In his past, he was a prosecutor. He's appeared on all of the national shows that there are, from looking at his list here, including Larry King Live, Dateline, NBC, it goes on. He's been written about in all of the major publications. He's written a book in 2017 called Blind Injustice. A former prosecutor exposes the psychology and politics of wrongful convictions. Politics. That's what innocence work is kind of all about, right, Mark? The law is one thing, but they are all political resolutions. So Mark has his group has exonerated quite a number of people, or freed a number of people. They've made a lot of reforms in Ohio, and they've been very fortunate, as I found out, to have Dr. Donna Mayerson come along to work with their project. Donna has a PhD in counseling psychology from the University of Utah, a master's degree in special education from University of Cincinnati. She worked as director of practice for the VIA Institute, focusing on the science of character and promoting human flourishing. But for our purposes, what we want to hear her talk about with Mark is, what has she done in the Innocence Project of Ohio? When I've started talking about this with other innocence groups, I'm almost coming to the conclusion that innocence work is in many ways harder than capital defense, which is very hard. But Mark, let me turn it over to you guys, and let's hear your story and what you guys are doing. This is great because it's in one project. What can be done? So tell us why, Mark, and then tell us how you're doing it. So you need to turn your microphone on, I think, Mark. I'm not sure. Donna, can you test yours and let's see if it's working?
Can you hear me?
We can hear Donna. Mark, having a little trouble hearing you, but yeah, while we're reading Mark's lips, Donna, why don't you start out and then we'll go back over to Mark.
Okay. So I'm very happy to be here today. Mark has a compelling story to say, to explain sort of how I got involved in this, which he'll tell you hopefully in a few minutes. Just to say that I'm a practitioner, and I met with Mark several years ago, and he told me in a very impassioned way about the impact this work has had on the attorneys and the fellows in the Innocence Project in Ohio. I'll just start off by saying I wasn't about proving or disproving whether secondary trauma or PTSD exists for attorneys, more about understanding what the situation is with the attorneys and the staff in the Innocence Project in Ohio specifically. And so I set about to really discover what all the sources of stress and trauma were in the innocence attorneys and the staff here in Ohio. So I really was looking sort of at sources of trauma to understand sort of from the inside out what those were, what the stressors were that they were experiencing. I was interested in looking at the processes and outcomes of cases and what the requirements of that were, and sort of hearing about the never-ending onslaught of cases and them never really resolving or resolving in different ways. Looking at the infrastructure of the project, what sort of supports were in place, what the office dynamics were, how much people shared information and supported each other, and also interested in what sorts of things were already in place, like were there opportunities for vacations or breaks? Were they having sessions around stress and just what had been done generally?
So the way I did that was I interviewed everybody that I possibly could interview.
Donna,
which was
let me ask, I don't mean to interrupt. Can you describe, and I think Mark would have done this, and hopefully he'll be back in a second, describe the physical offices there and describe who these fellows are, how long they work, because I think that probably plays into a lot of what's going on with your group.
So Mark could probably
Can
do
you
a
hear me
better
now?
job. Oh, good, Mark, good.
Okay.
Yes.
I was scrambling around with tech people trying to fix this, so I didn't get to hear what you said. Did you want me to start, or do you want me to wait till after you? It sort of made sense for me to go first.
Yeah. So yeah, Donna was just talking about some, and in one of the things I was asking her, I know you'll touch on, is describing physically your offices, the big area and who the fellows are. And then, yeah, probably some of what Donna was saying would make more sense. Glad you're back.
Yeah. So sorry about that, everyone. I'm the director of the Ohio Innocence Project, and I've been doing this work since 2001. And what we're doing is identifying people in prison who are wrongfully convicted and innocent, and then litigating to try to get them out. And, being in prison or the criminal justice system in general is traumatic, but for somebody to be wrongfully convicted, just picked out of the blue and sent to prison they didn't do, is a particular kind of trauma and pain. And as I got more and more immersed in this work, I started at some level realizing I was suffering from secondary trauma. I don't think I could fully articulate it, but I started having anger and sort of depression and anxiety. And by the time we got to about 2013 is really surfaced, where a client whose case I had worked on for a decade and I'd come to love him and his family, I freed him from prison, and then the prosecutors were trying to retry him. And I was so involved in the case, and he trusted me and not really anyone else, that I was actually going to do the trial, the jury trial. And I have a background as a prosecutor, I have court experience, so I could do it. And so in the spring of 2013, I was actually getting ready for a jury trial right as soon as my classes ended. And I was every week filing motions. And one of the things I was doing was trying to stop the retrial, saying it's unconstitutional for them to retry them. And finally, I was successful in that about 2 weeks before the trial was supposed to start. And at that point, it came to a head where I was just so frustrated. And the way I sort of describe it to people is, you can imagine somebody who's a doctor in like a Ronald McDonald House, or deals with children who have cancer and their patients are dying, and the sort of trauma that would involve. And I sort of relate innocence work to that, except there's an extra layer. When you're a doctor dealing with children with cancer, everyone's trying to save the children and everyone's on the same side. In our work, though, we have these people who have had the greatest injustices against them. And we had prosecutors who are putting up procedural bars and arguing dishonest things in court and trying to stop it. So it's like you're a doctor trying to save children, but other people are coming in and trying to steal the medicine. And so you're seeing this intense trauma from your clients, but you're also seeing, in my opinion, sort of the worst of humanity, and these people that are just operating in their bureaucratic roles and not caring about actual justice. And so by the time I got to 2013 and that happened, and I narrowly avoided a retrial, I was just sort of a mess. And I said, I've got to step back from these cases. And fortunately, by that time, I had a large staff. And so other people could take the cases, and I sort of decided I'm going to write a book, and I'm going to do fundraising, and I'm going to do more high level stuff rather than down in the trenches, because I just can't deal with it anymore. And through this time period, 2014, 2015, 2016, when I would start talking about this, the emotions were so close, and the scars were so raw that I would start crying. It was hard to even talk about some of these cases. And so Donna, I had known her previously because her family foundation was a donor. And I met her in a restaurant simply to go over sort of their annual re-up of their gift. And she asked me sort of in general, just how are things going with the cases? And I started talking about a case, and I broke down crying. So it's like embarrassing. I'm sitting here with a donor and I can't even hold myself together. That's what a mess I was by this point in time. And she starts asking me questions about it. And she's a psychologist with a background in this work. And so almost by pure luck, we developed this relationship. And I'm so fortunate to have Donna, because she started counseling me and has been doing so for the past several years. And that has expanded into counseling my entire staff, both in group meetings and individually. Then it's gone on to the student fellows, because we were realizing, we'd lose these cases. These students had worked on this case their entire year. They were in the project, and they would be devastated. They would be shocked at the injustice of the system. And then we'd find out they were carrying this with them 2 or 3 years later, working for big firms, and they're still sort of messed up over this experience. And then she started working with our exonerees. So it's almost like we have an in-house psychologist that's been absolutely incredible. And I'll let you tell it from her perspective, but I mean, she has dramatically helped me to the point where I'm able to handle it much better. I'm actually doing cases again, and was able to sort of get me out of that haze, and I could focus on different things it was doing to me and work on fixing myself. So for example, one of the things was I just didn't care. I didn't have any self-care. And I gained like 60 pounds during that period. I've lost half of that, and I'm on my way to losing the rest because of helping her get centered on how I need to take care of myself, which I wasn't doing because of this trauma. And the meditation and other things have honestly helped to the point where I'm sort of back in the trenches again, and I'm able to handle it in a better perspective. I was told to go for 6 minutes, and it's been 5, and I took up some of your time with the technical problem. So now I'm going to turn over to Donna to tell her end of the story.
Thanks, Mark. You can see how compelling his story is and why it was so persuasive in terms of responding to it, being responsive to it. I think I was starting to say before Mark got on that my fatal flaw was interviewing everybody, because everybody I interviewed had an angle on how they were affected. And so I think it's just a professional I guess, flaw that everybody, I started caring about everybody. And so I started really understanding where the sources of trauma were and how people were impacted, and really getting pretty clear sense of what was happening in terms of the structure of the office and the way that cases were being played out, and what kinds of things were really impacting people in the most significant ways. And they were all the things that have been mentioned prior to this, and the other presentations. And similar to the work with asylum attorneys, it was case material that was really hard. It was visits to prison. It was losing cases and filing and filing and filing again. It was the systemic dysfunction of the system. All of those things had an impact on everyone. And the work itself is endless. One case doesn't seem to end. It bleeds into another case, into another case. And for all people who have parts to play in it, it has different demands and different stressors. The additional things I think that were true, that are true for innocence work in particular, is that cases go on for years and years and years. That there are people that are in prison that you have ongoing relationships with. And I think attorneys end up being very personally invested in those individuals. Family members, they have relationship with family members that span many, many years. They also care about these law students who begin their second year of law school the summer before that in these fellowships, and they last through the year. And like Mark said, they have experienced a lot of the trauma, and they're very invested. They're very young and eager to do everything. And so they overwork, and they are very idealistic sometimes when they start. And so I just became aware of all these things. And then with the exonerees themselves and the people that were released, another burden that I think that many attorneys carry is they work so hard, they become so personally invested in these people's lives that when they get out, they're very vested in how they're doing and just carrying the weight of the material goods and needs that they have, basic needs that are not being met by other organizations and systems in place for others released from prison. And so all of this is just a way of saying it's a bigger thing than one aspect alone. It's all of those things. And so I had to sort of sort through like what's the best way to approach all of this. And so I'm just going to tell you some interventions that I've been implementing and how it's grown over time. So I started off with the attorneys and staff with group psychoeducational programming, and just to normalize, to help educate on what PTSD is and what secondary trauma is and how it looks and feels, because awareness of those things that happen, those stressors and the way they impact your life, you become sort of numb to them. You don't realize that you're experiencing them, that you're jaded, that you're, we go through life often without really recognizing and noticing how it's impacting us. And so awareness is a huge piece that group format was really good for. But just to say that also everybody has life and their own personalities and their own family dynamics. And so a lot of this work is individualized. So at the same time that I was doing group psychoeducational presentations and bringing in some people also who were doing some stuff on mindfulness and things like that, I was also meeting with the attorneys and staff individually to help them sort of assess stress and trauma and to work on individual strategies around that. And another piece of this in terms of behavior change is that, once you're in the habit of living your life and working in a particular way, you have these habits of dealing with stress and trauma. Those are really ingrained in you and ingrained in all of us. And they're really hard to break. So awareness is one piece of it, and changing that is a second piece. But the third piece, I think, that is really significant is maintaining the changes, because we all sort of regress back into the ways that we have functioned forever. So having ongoing contact and, conversations with these individuals has been really important for maintaining behavior change. And I'll say that especially during the pandemic, it's been essential, because the pandemic has flipped everybody, the work on its head, and all of the players on it just flipped it upside down. And then just to say, the piece about the fellows, I'll say quickly, because I know we're over time, is that, and many people have talked about law school and preparing young people or people who are in law school for what to expect. I think it's like imperative that it happens. And it happened in a time when people are sort of formulating what their life will be as attorneys and making choices about what kind of law. So I've done some work with the fellows in terms of preparing for the experience and setting expectations, talking about self-care and what the demands are of this work and why it's so critical. I had some videotapes from the attorneys and also from the exonerees speaking about the stresses and strains, and from the exonerees' vantage point, how they see the stress playing out on attorneys. That's been pretty impactful. And then I follow them to the end of the year to talk about how they take this forward. So, and I think that's really critical work. And then the last piece of it is the work with the exonerees themselves, because everybody's in this work because they care about the individuals that they're representing. And truthfully, when they get out of prison, that's a huge monumental thing, but it's not nearly what they need in terms of emotional supports and psychological well-being. I mean, they're people who have been very, very abused and broken by the system, and they come out with unbelievable needs. And so this is relative to your stress, or as attorneys, that having somebody who's helping them with post-release adjustment and with PTSD and the trauma that they experience and the relationship trauma of getting out and trying to reconnect with family members is unbearable for the attorneys to carry going forward. So I've been meeting with them and doing programmatic stuff with them, and have just really leaned into supporting them in the best ways I can. And that's it in a nutshell. And it's it's bigger than that, but that's what I got for you.
Donna and Mark, thank you so much. I know we have at least one exoneree watching, Ricky Kidd, who got out a year and a half or so ago. If any other exonerees are out there watching, please let us know through the Q&A so we can recognize you. it's, it took a while to get people out. There's been over 2,600 exonerations to date, and other people have also been freed. But what these people go through is just unimaginable. And I think the lawyers and the social workers and the investigators who work with exonerees can't not be affected. I know what it's done to me, and it's very difficult because we want things to go smoothly, but after you've been incarcerated, it's really hard. We had a great question, and this brings me to our next speaker, Cheryl Nickham. Cheryl, if you can turn on your camera and everything. The question we got was a great one. It says, will you be addressing or acknowledging or including a reference to prosecutors and the secondary trauma they experience? I keep hearing capital defender innocence cases, but no one seems to be saying anything about those prosecutors who are meeting these victims and their families. We are all having experiences. Well, that's exactly right. And we have reached out, and we have somebody here right now to speak about the prosecutor offices. And I'd like to introduce Cheryl. I'm pronouncing your name right, Nickham.
Nickham, that's correct.
Okay. Cheryl is a clinical social worker with the Department of Justice Executive Office for U.S. Attorneys. She's now serves as a clinical director for the Project Safe Welfare Wellness Programs. She has a specific job now where she works with prosecutors who work with the sex cases and human trafficking, almost the worst imaginable. So in some ways, Cheryl's on the flip side of what Andre was doing. And so the question is, what about prosecutors? And, I just have to say, they don't like to talk about this sort of thing, maybe privately. So, I know it sounds like maybe a prosecutor on here, which is wonderful, but, these things are probably going to be best dealt with prosecutors talking to prosecutors, maybe judges talking to judges. I mean, each area needs their own thing. But Cheryl, I'm going to turn it over to you. If you could tell us about some of the work that you've been doing to sort of normalize awareness in this area.
Terrific. Yeah, thank you so much. And I appreciate everything that I've been hearing. I've been sitting here thinking, I'm nodding my head an awful lot because so much of this resonates with the experiences that we've had. So I'm going to be echoing some of the information that you've heard earlier this morning. And I want to start with a quote that I like to use from Dr. Rachel Remen. And what she says is, the expectation that we can be immersed in suffering and loss daily and not be touched by it is as unrealistic as expecting to walk through water without getting wet. And so I see our job as helping people to walk through that water and to avoid drowning, quite frankly. So my work with the Department of Justice Executive Office for United States Attorneys, so we work with the prosecution and the prosecution team from A to Z. And what I noticed when I came to the department from my previous experience working with the Army was that there was some things going on that seemed obvious as a clinician that we needed to be helping folks with, but there wasn't anything in place. And some of that was a result of the culture, the stigma, a lot of different obstacles to them getting some help or some prevention tools dealing with this sort of thing. So what we did, first of all, is, of course, we know, and I, again, working with the Employee Assistance Program, was lucky enough to have some buy-in from our front office where they allowed us to contract with the local university. And we did some of the research and we got some of the same findings that you have reported earlier today, that yes, people are being impacted. We're losing people. They're moving on to other areas or other career fields. And our goal really should be helping our folks stay in the job and stay healthy in the job, as well as their family and friends. So from there, we were able to kind of provide a business case analysis as to why we needed to implement a program to address these issues. What we did then is we looked at what were three kind of main areas where we needed to provide our focus. And that was with the organization, the organizational issues, the culture, the kind of the team, the prosecution team, and then the individuals themselves. So within that, we broke our program into the wellness component. And then from there, I was able to spin off and develop a peer support team, which is that piece that you mentioned, Mark, with prosecutors talking to prosecutors. And ironically enough, we did a video with that program that introduced the team, introduced the concept of secondary trauma. It's only about 10 minutes, but it's very engaging kind of Q&A with some of the prosecutors and support staff. And we named that Allies in the Trenches, and that's been very, very well received. So it was funny when you said being in the trenches, I'm like, yes, absolutely, that's what it is. So basically what our goals were to increase the awareness and normalize that there were going to be reactions to this kind of work and decrease the stigma of getting help. We wanted to integrate our services into this is the culture. This is just kind of how we roll. This is part of what we do. Much as you might speak with a new attorney about this is how you process a case, or these are the policies and procedures or what have you in the office. This is also part of what we do. This is just how it happens. Here's an EAP person. Let them talk to you a little bit about secondary trauma, because it's going to happen. It's a matter of to what extent, how far you can get in front of it, and at what point in your career it's going to happen. And we obviously have had some very lengthy conversations with folks about what the SF-86, which is the background clearance. I am happy to say there's been several revisions with that document. The challenge I have with the revisions is the more that they try to destigmatize the question, the longer it gets. And so it seems actually less friendly in terms of the response. But in actuality, we have not had many folks that have had to answer in the affirmative unless they've gone outside and gotten some real significant care for other issues, addiction or what have you. And I can honestly say there's been no one who has been in any loss of their job because of as a result of seeking mental health care. And in a offhand sort of way, what I tend to say sometimes, and we have those conversations about how is this going to impact me, the effect of the work, if you don't get help, is going to have a more severe detrimental effect on your career and on your person, your relationships as well, than getting help is going to have. So let's do a cost benefit analysis on that. So dealing with that from the organizational standpoint, we did a lot of training first for the front office so they could kind of then lead and bring the message down that people, though they're our most important asset, we need to take care of them. We need to be aware of the impact. We need to be aware and minimize to the extent that we can the obstacles for getting help. From the very top level, then once we got that buy-in and that support, we started to develop the educational materials and do training. We started with the training for managers, and some of the things we talked about with those managers was talk to your people, check in, ask how they're doing. And we would coach them through those conversations, because we didn't want a manager to come by and ask someone how you're doing and run away because they didn't know what to do with what they might hear as an answer. If someone said, I'm not doing well, and that manager didn't know what to do, that obviously could make things more difficult. So we did a lot of training around that. We also did training around how do you assign these cases? Who gets these cases? Where is someone in their life? Is that a good time for them to have that? Or should people be able to come in and out of this work? Take a few cases, or some people feel like this is what they do and this is the only work that interests them. And maybe that's okay, but having some conversations around gauging those sorts of issues. Talking to the managers about setting healthy examples, Again, the culture can tend to be, you're the first one there, you're the last one to leave. That may not really be the example that you want to set when you want your people to be healthy. Talking about integrating all of these strategies into the culture right from the day they come in. This is just how we roll. This is what we do. We talk with EAP, they're available, they're a resource, it's confidential, etc. And making sure that the managers are aware of the resources available. Some things were already existing, like listservs and other things that were already in place. We went ahead and just optimized that. We also talked with management about having dedicated resources. Sometimes in some of the offices, we actually provided a standalone computer. This is what you use when you're going to view evidence. Some people felt like it was more helpful for them to look at it on their own desktop. My feeling was if there's a screensaver of your kids or here's your family photos, that may not necessarily be the place where you want to view these materials. I've had other folks that have come back to me and said, no, that's exactly why I want to do it there, because that's what gives me the impetus and challenge that into my work. So that's can be a very individual situation. So after we did the training and kind of got some devoted equipment and got some other logistical supports into place, we also partner with people in the community through the ICAC or the Lawyers Assistance Program. We found sometimes had some good opportunities for speakers that would come in and talk as well, so they didn't always have to hear from the same person, just to kind of validate what we knew and to reinforce the message. Then we moved on to like the trial teams and looking at it's again, and I've heard people say this morning, thankfully, it's not just the trial team that's impacted. It's not just the prosecutors. It could be that person who is the receptionist who sees these folks coming in the front door, could be anyone in the office, but also could be and is very likely family and friends as well, talking with the team around that, talking with them about how they handle these viewing sessions. Do they debrief as they get done, or how does that all happen? And then talking to them about how they can spread this message throughout the office. One of the things we found, although we started with the Project Safe Childhood work, which is child exploitation, it very quickly, once the word got out that there was this service, so to speak, for this population, other people were coming forward and saying, hey, what about me? And I was so glad to hear prosecutors saying that, look, I'm working this capital case and my trial team is impacted. And so what can you do for us? And we were more than happy to reach across and provide that service for them as well. So our peer support team members, which consists of everybody from victim witness to prosecutors to lit support. We have each representative from each of those areas, and we give them some specialized training. They will work with those folks as well, and that's a completely anonymous type service. They do work under my clinical direction. And so if there's some issues, I always have them debrief after a case. I don't necessarily, we don't want to know the name. We don't keep numbers. We don't do any of that stuff. We just want to make sure that we're available to help debrief our team members as well. The next thing that we looked at, or actually this all kind of happened simultaneously, was working with the individuals. And we were very fortunate in that we have here in Columbia, South Carolina, the National Advocacy Center, which is where all of our folks come and go for training at different points through their career. So just about every time that there was a training, because I'm here in Columbia, I would be down there and I would be at least, just kind of talking to people in the hallway or putting out brochures, or just if there's 5 minutes and a speaker shows up late, I'm going to jump up there and say, hey, just want to introduce myself. And this is what we do. So getting the word out any way that we can. Webinars, newsletters, a lot of marketing materials, informational videos, you name it. In dealing with the individual prosecutors, one of the things that we make sure that we underscore for them is something they already know, is that this can be the most difficult, but also the most rewarding work that you will ever do as well. So many say there's no higher calling. This is really where I want to be. This feels like the pinnacle of the work for me. And we're happy to support that. What we want to do is make sure that they're doing it in a healthy sort of way. I've heard people talk earlier this morning about different scales and assessment measures that are used, and I think those are fantastic. One of the things I recommend to people is when they come into the work, they kind of go online, and they can do this in the privacy of their home or whatever, and they go on and they do maybe the ProQual, which is going to give them the information on compassion, satisfaction, fatigue, and burnout. Look where you are. And then 6 months from now or 4 months from now or what have you, look again, do that again and see where you are, just to gauge, give you some kind of third-party objective information as to how you're doing. So many folks say, oh, in the rearview mirror, I wasn't doing very well, but I didn't know it at the time. I was so immersed. We try to talk to people about It's setting time, doing specific strategies around viewing. Limit the amount of time that you spend viewing this material. Don't do it at the end of the day, because that's what you're going to carry home with you. Don't put it off because you don't want to look at these materials. And then here you are finding yourself alone in the office on a weekend doing a marathon session. That can be very detrimental. So there are some specific strategies and techniques that we share with people. Please talk with your family members. As we know, relationships are impacted, and whenever relationships are impacted, the other person always thinks they did something wrong. So let them know ahead of time. And I say, even if it needs to be a signal to say, this is one of those days. What I know I need to do is go get a run, go to the gym, go garden, whatever, and then we'll come back and reconvene. But it's not about anything you did. It's about what's going on with my work right now. That will help the family member to understand. And sometimes that's how we get buy-in to reluctant prosecutors is, but your family's probably impacted by this as well, or your family may be that third party that's noticing a difference in you. We can help them, we can talk with them as well. So sometimes that's an entree into helping that individual. And the last thing, because I think I'm kind of running out of time here, is please be aware, take your vacation. No one ever takes their vacation. No one ever rests in between cases. One of the things we know is that there's a lot of compassion satisfaction from this work. When you finally get that, you get that good outcome, you get something positive happen, but we never stop and say, oh, that was great. We may go out and have a few drinks with colleagues or whatever, but unless you build in that time for that rest and that recovery, that restorative time, you have difficulty then resulting in that post-traumatic growth. And I guess that's a good point for me to leave it. Anyone who has other questions, I'd be happy to hear it from them.
Cheryl, thank you so much. And you're going to share those anti-trauma cupcakes with everybody that you have on your screensaver. I think.
I know, I laughed. I'm so sorry about that. I had to use my daughter's computer. She's got the best tech in the house.
Thank you so much, Cheryl. I'd like to now introduce Dr. Kate Porterfield. I guess I'm going to call her the guru of trauma. I don't know, that sounds insulting, but I mean, when I read about your background and all the work you've done with victims of torture, you work with lawyers, you work with journalists, you've worked with Innocence Project people. I mean, I could go on, but I'd rather you go ahead and talk to us. I know you've been with us all morning. Maybe also you could weave in the question we got is the way prosecutors and defense lawyers, do they deal with trauma in different ways? I mean, is it a different thing? But anyway, I'll let you carry it away. And I'm going to tell everybody, we're going to go till 12:10 with this panel, and then we'll take a lunch break. Whoever wants to stay, we're going to have Kate lead us in a breathing exercise, but we'll come to that in just a minute. So we're going to go to 12:10. Take it away, Kate. Thanks. You so much.
Thanks, Mark. You can hear me?
Yes.
Okay, good. So hi, everybody. It's really nice to be here. I want to thank Mark and his team for inviting me, and Wake Forest Law School, of course. I'm going to dive right in because I have a pretty fast and furious stuff I want to power through to finish up this really excellent panel with, and morning, by the way. I just thought all the presenters were really incredible. So I want to give you a little intro and then dive into a couple PowerPoint slides about my material. But what I want to start with today is let you know that what I'm hoping to do is share with you a frame that I found really helpful in my work. I'm a clinical psychologist, started my work at the Bellevue Program for Survivors of Torture in New York City, and have worked with really an incredible array of wonderful clients at Bellevue who have suffered severe trauma. And over the last 10 years, I've actually expanded that work and been really fortunate to learn about the impact of not just severe primary trauma, but secondary trauma on journalists in war zones and covering natural disasters with attorneys dealing with really serious trauma in their cases, as well as human rights workers going into the field. So I've been really lucky to learn about secondary traumatic stress. And I've found that some of the application of the frame that I find helpful with trauma survivors, some of that application really does work with secondary trauma as well. So I want to quickly share that frame with you. It's called a biopsychosocial model. And I didn't make that up. That's a very common word in traumatology. And then I'd like to kind of give you just a preview of a couple of the practices that I think can be really effective and helpful. So let me begin with some slides here. Mark, if you could give me a verbal, because I can't see it, just that you can see that slide, that'd be great.
Yes.
Okay, great. So what we're going to start with today is the idea of this frame. And what I'm going to argue to you in my time is that there's a lot of use that you can have to having a frame, a cognitive construct around what you have been through in your life, including adversity and trauma. And so when I do this with trauma survivors, so torture survivors or folks who've been through violence or other kinds of severe experiences, the frame that I try to introduce as I work with them is the idea of that recognition of something has happened to me. I've been through something difficult and it has affected me, and I'm going to acknowledge that that has happened and that there have been effects on me. And then I'm going to start to be able to think about what helped me. What are the things that actually got me through? We talked a bit this morning about resilience and the folks in that early panel talking about how they survived really serious traumas that they were exposed to. And then even if you're really, really fortunate, the idea that maybe there was what Cheryl actually just referred to, I think, post-traumatic growth, which is not to say, hey, this is great, I'm glad it happened. Of course not. But that there were ways that I've changed and grown that I'm actually going to own and open up and sort of accept about myself. So that frame for me begins with the idea of teaching. And again, Cheryl hit a lot of really great points about psychoeducation for folks to first learn about what they have been through and learn about how it leaves a mark to be exposed to trauma. And so the frame I really like is what is called a biopsychosocial frame, which says that traumatic events, extreme events, impact us in multiple dimensions of our humanity. And when I teach my clients about this, I'll say often, look, we're wired to survive. We are bodily survival machines. We are mammals whose body first takes on the stress and the threat of traumas and then carries the threat afterwards with some of the impacts that we'll see, which I'll try to break down in a minute. But we are wired to survive as a body, and that's an amazing capacity we have that actually does save us. We are wired to make meaning. We are psychological beings, and we make meaning about our feelings that we feel, and our brain, especially this frontal part, puts them usually, those feelings, into sort of a language-based construct, right? We usually think things about our feelings, and that's part of being a psychological being. And trauma lands in our psychology, as we know. So our meaning making ends up being a really important part of understanding what has happened to us and what we're gonna carry with us from it. And we are wired to attach. You cannot thrive and do well as a human without human connection, whether from infancy on into late in life. We must have other humans in our world. And that social contact can be a manifestation of traumatic stress, the way we isolate, the way we get irritable, the way we fight, the way we push people away. And it can be a source of tremendous strength and healing after trauma. So this biopsychosocial frame for me is always where I start with my clients, including with secondary traumatic stress when I'm working with folks. So what happens? Well, traumatic stress means, I don't think I'm going to do a big definition of this, but events that really overwhelm our normal coping. In other words, the stuff coming at us is more than we can just sort of get through with a little bit of white knuckling, right? Normal coping stops working and we start having some threats coming into our system that tell us you're really, really in trouble. And amazingly, going back to that biological model, we're a survival machine, right? So our nervous system is wired to involuntarily kick in and help us when we are traumatized and under serious threat. And so when I don't have time to do a big description of our nervous system right now, but a lot of this will be familiar to you all when you think about fight or flight, right? That's understood to be the way that our nervous system, when it recognizes a stress, kind of amps up, right? And it amps up with the sympathetic nervous system giving us a set of reactions that are thought of as uproar reactions. Heart racing, you start breathing in a more shallow, rapid way, your pupils dilate to take in information, your gastrointestinal system stops so that you can conserve energy and use it on muscle mobility and speed. All of that happens within seconds when you are under a trauma moment, right? I am under stress and I am under threat. Now that nervous system reaction actually also then has the flip side. And I think of these arrows, you'll be seeing them again. The red means I'm going up, I'm amping up into fight or flight. And our nervous system also then takes us down into a parasympathetic reaction after we've been under threat or after we've exposed ourselves or been exposed to too much of that nervous system arousal. And that shutdown reaction starts to take over, which makes us lower energy, heart goes down, heart rate, blood pressure goes back into a normal pattern. breathing goes into a normal pattern. The body's able to evacuate and do other kinds of processes that it needs to do. So this fine-tuned homeostatic process, right, of amping you up when you're in trouble and bringing you down when you are, coming out of the threat, is actually then something that can leave a mark on us after trauma. And the problem is then we're kind of having those reactions, uproar reactions, heart racing, sweating, trouble breathing, or being shut down, detached, kind of feeling low energy after the trauma. And so that's where that sort of mark of trauma, which is classically thought of as PTSD, is a problem. The trauma reaction is now coming afterwards as I remember or am sort of intrusively gripped by images of what happened. Now, everything I just described very quickly, that sympathetic and parasympathetic reaction, is part of the construct of PTSD. But what we also know is that it's part of secondary traumatic stress as well. And what that means is that secondary traumatic stress, and lots of these amazing speakers already hit this, so I'm going to be fast, but secondary traumatic stress really mirrors the same symptoms as post-traumatic stress, which is that uproar reactions and intrusive arousal problems, so feeling edgy, irritable, having images come back to you intrusively, those kinds of problems persist after you've had an exposure to other people's trauma, to stories of trauma, to images of trauma. And here I am having the same kinds of symptoms that someone with PTSD might have. You also can have nightmares and flashbacks. You can have a really exhausted, fatigued presentation from being overly stressed by trauma, even secondary trauma. Attention and concentration problems. This is a huge one. Folks who are really receiving just too much of what we call a dose of traumatic stress will say, I just kind of can't take in stuff the same way. I can't write the same way. I know for you attorneys, that's a huge demand on your work, is both taking in information and being able to write about it. And so attorneys will talk to me and say, I'm really having trouble functioning with my attention and concentration. And I think it is a matter of the stress overload I've been experiencing. Social isolation, also a part of the symptoms that can come from secondary traumatic stress. And then one of the ones that I'm really, really interested in and have spent a lot of time talking to folks about is this idea of meaning making. Remember, bio, psycho, social. So if the bio or those irritability, those nightmares, that edgy feeling, the psychological is, what do I do to make meaning of what I've done in my work, right? How do I feel about that case I just did? How do I feel about that client I just worked with who I know caused tremendous harm to other people? Or how do I feel about that person who I just, assisted in their prosecution and they now face a death sentence? I mean, Mr. Greer's discussion of that was incredibly profound. And I think Cheryl also raised those issues, which is that participating in prosecution also can raise issues of traumatization as well and meaning making. Sometimes that idea is called moral injury, and I don't have a ton of time to talk about it, but if you're interested in it, I could refer some articles. Moral injury comes out of the journalism field initially, and sometimes out of military service as well. And the idea is that one has participated in things that in the aftermath you feel unbelievably overwhelmed by, and even question some of your own actions, or at least what it meant to be part of it. And I think for those folks working in criminal justice and sometimes in asylum processes as well, or asylum practice as well, that moral injury can really be a painful place where meaning making goes kind of south. And what I mean by that is people then struggle with guilt, shame, and self-attack. So secondary traumatic stress, I think we're pretty convinced, if we're still sitting here at 12 o'clock, that this is a real thing and that this is what it looks like. Also, we've talked about self-medication and really just a sense of lack of pleasure or feeling positive in one's life. So let me shift to a few minutes of what I find to be the kind of top strategies for dealing with secondary traumatic stress. And this is what I argue in my work with folks. First of all, I'm a huge believer in what we call in the field self-assessment. And that doesn't mean none of us need professional help, and it doesn't mean we shouldn't go to therapy. But what it means is you actually have a real capability to look at your own biopsychosocial processes and practices and say, how am I doing? Where am I seeing rough spots, right? Where am I seeing I'm not doing so well? And then when you identify them, you can actually start putting in some little practices and some little interventions. And we talked about the idea, I think Lindsay was talking about, how do you make this stuff stick? And part of the way that I really recommend you make it stick is that you consider secondary traumatic stress practice a part of your toolbox as a lawyer, meaning just like you learn motions practice and you learn writing and you learn arguing, you also say, how do I manage the stress of this work so that I don't burn out, so that I don't do a bad job? So a couple things. First of all, I'm a big believer in self-assessment, as I've just said, and I teach everybody this, whether you're a survivor of torture and trauma or a big shot attorney doing lots of work. First step in self-assessment is you have to be willing to say, I will pause. I will find a moment to sit. I will build into my work a moment of stopping. And when you stop, the second part is I will now notice. I will take stock of my physical, my psycho, my social, and start to pay attention to where I'm seeing resilience and where I'm seeing struggle. So when I teach folks about this, I say, first of all, let's learn a little more about that red arrow and that gray arrow. And let's say, how are you doing just in this moment that you're pausing, right? How are you doing in what we call the window of tolerance? Where is your arousal locating itself? Is it amping up into the red zone? Or are you kind of shutting down and going into the gray zone where your body's kind of in more what we call hypoarousal? And I recommend for people to print this little graphic and stick it up on your wall at your desk. And when you're feeling good, you've had that cup of coffee and you're kind of tapping away on an email, and over here you're working on another piece of writing, and you like your to-do list is already going, you're doing great with it, then you're in the green zone. That means you're in the kind of optimal state of functionality. You're not over-aroused and stressed, and you're not under-aroused and fatigued or shut down. And what you'll notice is when you start going into the red zone, if you use the pause notice practice, you'll say, there it is. This is that thing about that red arrow. I feel edgy. I'm feeling like I shouldn't have more coffee. I'm not thinking clearly. I can't multitask as well. I'm getting like a little bit distractible. I'm getting overactivated. And at that point, you can say, I need to implement something to break this pattern. And I have a bunch of recommendations. I make everything from get up and do a 10-minute walk, to do 10 push-ups and sit-ups, to play a beautiful song that you love, to drink a big glass of ice water, to go splash your face in ice. These are all literal things that I have recommended for folks when you're in the red zone to break that pattern a little bit, break that moment, and bring yourself back down to an optimal state. Those are quick ones, by the way. The best thing, of course, is to take a real break and find social connection that is meaningful for you. When you go into the gray zone, you have the opposite problem, right? Which is you're starting to feel a real sense of fatigue, low energy, and difficulty concentrating and functioning. Here, again, we can practice some of the things I just recommended for red zone, but you're noticing your body is starting to really detach, and it's time to re-energize yourself. A 20-minute nap, ice water, a walk, a connection to a good friend or colleague who you trust, some way to reactivate that nervous system. So one of the questions I'll say then is, if you're thinking about window of tolerance, can you pause and notice just what's my body doing right now to help me? Because believe me, when your body's going into one of these two zones, it's actually telling you something. It's helping you. And actually, I thought it was really powerful. I think it was, oh my gosh, I'm sorry, who said this? I think it was Mark Godsey said, I was a mess. I was crying all the time. And I would have said to Mark back then, and I bet Dr. Marison did, you're not a mess. You're crying because your body is telling you something and you're listening to it. That's not being a mess. That's actually listening to what your body's telling you. So if you're amping up, your body's telling you, I'm getting too much of that nervous system arousal from whatever reason. And if you're shutting down, it's telling you, hey, I'm starting to disconnect. And both of those deserve attention. Okay, so just a couple more quick thoughts. And I'm not going to go over this whole chart, but this is another thing I'd recommend that you create for yourself, which is I tell my patients we're going to make a biopsychosocial chart. And we're going to ask ourselves, how am I doing in each category? And when you're feeling bad, you can stop and look at this and just go down the list. Say, where am I feeling bad? Okay, let me look on bio. Well, definitely I have a knot in my stomach. I have not eaten since morning and I've had 3 cups of coffee. And no, I'm really not feeling any pleasure. What am I thinking? Okay, well, I'm feeling kind of anxious. I'm feeling that. Sometimes I'll say to patients, a feeling is a word and a thought is usually a sentence. So for me, I'll use an example. If I'm feeling anxious, I'll notice my thoughts tend to be stuff like, you've got too much going on, you're not doing a good job with your work, the kids are wondering where you are. I start down a little cascade of thoughts that are quite self-attacking. And that kind of pattern of thoughts and feelings being self-attacking needs an interruption, and it needs an intervention. And by the way, I know lawyers are very vulnerable to that because you guys take on a lot of responsibility. And then social, who am I talking to? Who's around? Am I isolating or am I reaching out? So I'm arguing this piece about self-assessment to you. And, before I'm going to wrap up in a minute, and I'm not going to spend much time on this bit about risk factors because we've already talked about it. But, once you learn to self-assess, you can really start thinking about, well, where am I vulnerable and how come? Because one of the things we know is that the risk factors for secondary trauma are things like, hey, your own trauma history. And by the way, if you're doing this kind of work, chances are there's something that brought you into the work of, working in justice and working to fight for, people who've been hurt. Join the club is what I always say. And you might have a kind of identification with a particular case or a client or story that makes you be then a little more vulnerable to have a secondary traumatic reaction. And especially lack of social support. And I think Lindsay Harris spoke a lot about this. Social support is a huge predictor. Working on your own, not reaching out to folks, not having personal and professional contacts who are part of your work. Obviously, also any other life stress hitting you at that same time as you're doing hard work will definitely tax you a little more. Protective factors, again, we've talked about them. I'll just be pretty fast here, but definitely we find that folks who are older and more experienced actually have often learned more. So those senior lawyers, those of you who have learned techniques, you should be finding ways to teach that to the younger lawyers and to mentoring them. Team constructs of cohesion or sort of meaning making that's done together can be a really great protective factor. Training in secondary traumatic stress, that's why I think Cheryl was talking about making that such a critical part of DOJ's training is really a good idea. And then, things that we've already talked about are protective, connecting to others and having a self-care practice. I want to leave you with a quick exercise I really recommend for folks, especially lawyers, which is if you are doing your self-assessment and you're like, oh, I feel cruddy today. Why do I feel so bad? I'm working on this case and I just feel so bad about it. I'm doing such a bad job and it's going to go badly. And you're noticing that spinning happening, right? One of the things I recommend is to ask yourself about that situation. Okay, I feel bad about X, whether this case or something that's happening with a colleague or whatever. What part of this situation do I or did I have control over? And literally list it. And what part did I not have control over? And I'm telling you this because in my experience working with a lot of attorneys now, there is a lot that falls into this column over here. And folks often don't recognize that the part they are feeling more upset about or more distressed or having negative meaning making about is actually the systemic stuff or the injustice stuff, the racism, the inequities of poverty, things that are so much bigger than what you could have done. And again, that's not to say our work doesn't matter, but it's a way to try to break down meaning making so that you can sort of focus on what do I have control over? I have control over doing a good job, being an ethical person, working well, taking care of myself, and being a good human, right? The other stuff, you really probably can't control so much. So I'll end with this with two visuals. One is, again, I really like this chart about being a self-aware attorney and building a self-care practice that is intentional, that involves pacing, which is looking at how much work you do and take on and when you do it, including your boundaries. The biological part of our functioning, right? That part of us that's wired to survive. What's it telling you? Listen to your body as it tells you and shows you where you're struggling, whether with sleep, appetite, mood, irritability, or whatever. Where is the psychological part of you wired to make meaning? What is that telling you and where are you attending to it? Are you using meaning making, processing, thinking, spirituality, therapy, reflection, mindfulness practice? We've heard a lot about that this morning from especially Mark is a great advocate for that, using a mindfulness or contemplative practice to address your thinking around your work. And finally, who is your A team? Do you use them? Do you go to them? And how do you build social support as part of your work? In case you notice, there's one word that appears in all four of these quadrants, which is pleasure. I'm a huge believer that the way to also combat traumatic stress is to have fun and laugh and do stuff you love, go in nature, exercise, see art, whatever it is, do sports. But pleasure is so, so important to healing when you do hard work like this. And my final image is that I'll share is that I really advocate my teams to do this at the end of the day. And I was thinking about Cheryl's idea on this too, in terms of where you have discovery or other material that's disturbing on your chart, on your computer. At the end of the day, I'll argue to some of my teams to close their computer, put something pretty on it, and then send that picture to each other and say, hey, my day of work is done and my work was really valuable today, but now I'm not going to be thinking about the hard stuff. I'm going to be actually doing stuff for me. I'm going to stop share. I do have a must read page for you. Sorry, got to show you that. These are essential reading if you are doing this work. And by this work, I mean any kind of lawyering or advocacy that involves vulnerable people. You got to read Judith Herman, Bessel van der Kolk, and Nadine Burke-Harris. So I think I'll stop there. Mark, I'm going to pass it back to you, and then it's 12. Ooh, well, I don't know if people want to stay for breathing. I'm happy to keep whoever wants to at the end and do a minute of breathing and grounding. But thank you, guys.
Kate, I've just filed for a patent to turn you into an avatar to be on my phone, or to reduce you to a small creature like Jiminy Cricket on my shoulder to say, okay, what are you feeling now?
That is so nice. If I'm honored. Thank you. I'm honored to be shrunken down.
Will you be my Jiminy Cricket? I mean, but I think the lesson that you're teaching us here is that we can internalize these things. Of course, we need systemic and institutional support, but I think that's what I'm hearing from you, and that's certainly what I have found with contemplative practices, with all of the, I mean, what you just said in a nutshell, which is what I've learned in the last 13 years of going away on retreats for 2 weeks at a time. So, that's mindfulness is what you just described. And it applies to everything that we do. It applies to prosecutors, judges, jurors, defense lawyers, no matter what. We all have human brains and we have human bodies. Bessel van der Kolk, the book in the middle on your chart, it's like the greatest thing I've ever read. I buy copies and give it away. There's lots of other books as well. We're kind of running out of time here. Some of these questions I think have already been addressed, and of course there's going to be articles generated from all of this. Let me just ask the panelists who are on this last one, did anybody have anything you'd like to add, Cheryl or Mark or Donna? Well, if it's okay with the, Mark, did you have something? Okay, thank you all. It's been fantastic, and it's been a lot, but we needed to create this awareness this morning. If you need to go to lunch, we all need to go to lunch, but feel free to go ahead and leave. When you think about this afternoon, for all of us people who identify as white or who have been racialized as white, think about putting on a different sort of skin and dealing with exactly these same issues, because it's a whole completely different thing. And I personally am only gradually learning about that, after 40 years of mostly Black and brown clients, representing them, and same with prosecutors too. It's we all have a lot. We have a lot to learn. If people do want to stay around, Kate has gladly offered to sit on my shoulder and guide us in a breathing exercise. So Kate, take it away. And the room will stay on. You don't need to sign off if you don't want to. I think you can stay on and you can come back at 1 and we'll be back again. But Kate.
Great. So Mark, you want me to go? I'm going to go ahead and do the breathing then. And then if you, right. I won't know if you signed off. So I like the idea that they keep their camera on and then it still looks like 600 people are listening. First of all, the cheapest supply you're ever going to buy for self-care is buy yourself a thing of Post-it notes, and you should stick them around your desk, and you should put up pause, and you should put up breathe, and you should put up valuable. And when you look at valuable, you say the work I do is valuable. And you should put up labor, and labor is the beautiful gift you give in this work. I'm like a huge believer in Post-it notes. So please go buy Post-it notes. I do not have any endorsement from whatever company it is that makes Post-it notes or any financial investment in them. Okay, I'm going to take whoever's still on there. It might just be you and me, Mark, but I'm going to take us through a very simple breathing pattern and a grounding. This should take about 3 minutes, I think, maybe 4. And I'm telling you, I cannot endorse this enough. I use this myself, God knows how many times a day, probably 20. And I have used it so much more during the era of COVID and isolation and time home with families and lots of folks struggling. So I'm going to teach you a breathing pattern that's really simple. It's called 4-4-4. And 4-4-4 is simply a breathing pattern where we're going to go in through the nostrils with a nice slow 4-second breath. I'll count it. Then you're going to hold it for 4 if you can, sort of thinking of that breath as going into your abdomen. Imagine your abdomen, you know, kind of holding it for 4 seconds and then out through the mouth. So I'm going to count us through that in a minute. This is a breathing pattern, by the way, that's been shown to reduce heart rate. And the more you practice breathing retraining, the more your heart quickly responds. In other words, in studies of it, if you get yourself doing this even when you're not distressed, then later when you do it when you are distressed, your heart actually gets the message. So it's a really great, easy strategy. You can use it anywhere, any place. So before we do that, though, I am going to ground us. And what I mean by ground us is so much of anxiety and so much of stress is that we jump into the future and get incredibly worried, and we think back on the past and feel really bad about things. And so grounding is a way to say, hey, right now I'm going to sit in this minute, in this space, and I'm just going to pause here and not think about the future or the past. So as we do the grounding, I'm just going to invite you to listen to my voice for the next minute, and then we'll do our breathing. Grounding we're going to start with is we're going to take our feet, and I want to ask you to take your feet and push them on the floor as hard as you can, kind of really pushing against that ground. If you have your shoes off, you'll feel the flat, strong surface underneath you. And really notice the feeling right now as your feet feel the earth underneath you, feel the floor underneath you, and recognize that it's holding you in this moment on this ground. And as we start letting ourselves feel the ground underneath us and this moment that we're sharing together, I'm going to also ask you to start to take awareness of your hands, and take your hands and put them on the top of your legs, on your thighs. And as you do that, we're going to start to kind of relax a little, roll our shoulders back, and try to notice the feeling of your fingertips as your nerve endings take in the texture of your clothing on your legs, or if you're wearing shorts, your skin, and that incredible power that your body has to take in those nerve ending messages and send them to your brain, and your feet taking in that message of the ground underneath you. That's your strong body telling you a message. You're here now and you're safe. As you ground yourself, I'd like you to look at your environment for a minute. Just kind of look around and find 3 things you hadn't noticed before. Just they could be little or large. And as you look at those 3 things, again, thinking about your eyes and the amazing elegance of your eyes sending a message to your brain as you notice those 3 things, the color of them, the shape. Your feet are on the floor, your hands are on your strong legs, your eyes are taking in your environment. And now listen if you can. And besides my voice, try to listen to one other thing in your environment. Again, noticing that the ears have this excellent structure and capability that's sending a message to your brain. All of this is your body being in this moment, being strong and functional. So as we sit here grounded, we're going to start our breathing together, and I'm just going to begin by having you do an inhale on my signal, 4 in through the nostrils, hold 4, and then 4 out through the mouth. Okay? So we'll start now, and you're going to breathe in through your nostrils, and 1, 2, 3, 4, hold, 2, 3, 4, exhale through the mouth, 2, 3, 4, again, inhale nose, 2, 3, 4, hold, 2, 3, 4, through the mouth, 2, 3, 4, again, inhale, 3, 4, hold, 3, 4, exhale, 3, 4. We'll do 2 more. Inhale, 3, 4, hold, 3, 4, exhale. Last one, inhale, hold, exhale. So we'll end with that. I recommend you practice a little grounding yourself this weekend. I'm going to thank you all so much. I see some folks wanted to know the books again. So I don't know, Mark, if you want me to pop that back up there, or you want to share that.
Yeah, why don't you, go ahead.
Okay.
Thank you.
I got it right there. So those are the 3 books I really recommend. Judith Herman, Bessel van der Kolk, and Nadine Burke-Harris. All right.
Thank you so much, Kate. Let me see if Kyle or Ethan has any announcements before we take a little break.
Thanks, Mark.
no announcements for me. We will see everybody back at 1 p.m. for our next panel.
Thanks, everybody. Judge Weeks, do I see you on there?
Christina, it's Henderson. Let's see if I can show up. Well, I thought I saw you.
Hey, Henderson, how you doing?
Good.
Life treating you well?
Well, better than most. I can't complain.
I
Not as good as life is treating Christina.
Hey, Christina.
Hi there. How are you? Hey, Henderson. How are you?
I'm good. I'm
Nice
good.
to see you.
I don't think I've seen you in at least a year.
A dog's ear or whatever it's
That's
called.
right.
In a while.
Yeah, just to let you know,
you got it, Kyle. Okay, I was gonna tell everybody where you're talking to 476 people. So if you're gonna talk about me, I mean, it's okay. It's just if everybody's gonna hear it.
Just about to get good.
Yeah, I was gonna say I knew where y'all were going. As soon as Henderson started in, man, I knew where that was headed. So I figured I better you have the right to remain silent. And oh, thank you guys for joining us.
Thank you.
Hey, Karen.
We're starting what in about 10 minutes, Kyle? 8 minutes or something like that.
Yeah, we're gonna get started at 1 p.m. So y'all can either relax here, talk to each other, or just turn off your cameras, whatever y'all want to do really until 1 p.m.
Whatever we say, though, everybody hears. All right.
Yeah, everybody can hear what you're saying.
Well, in that case, I think I'll go mute and off camera. I'll see y'all in a bit.
I'm still having some technical difficulties here. I'm getting a message saying I've been, what is it? I have to leave and rejoin.
We can hear you, Judge. Oh, well, okay.
There you go, Greg.
I'm back.
That worked.
I need the assistance of my 8 or 9-year-old grandson.
Well, it's always good to have young bloods around.
Amen. Amen. How's everybody doing?
We're surviving, Judge. Just surviving.
I think we're supposed to be on mute.
Judge, you can talk, but there's 482 people listening to you. So whatever, it's good to see. It looks like everything's technically working well. I can see you, I can hear you and everything. So you don't need your grandson.
I have a quick question for either Kyle or Ethan. This is Dawn McQuiston.
How can I help you, Don?
Kyle, I was just wondering, I was looking back over the Q&A and there's so many great questions and comments. Is all of that going to just go away once this is over, or will those questions and comments be recorded somewhere? Because there's so many questions we don't have time to get to, but I think we might want to interact one-on-one with some of the people that are commenting.
Sure. Feel free to respond to some of the comments, either publicly or privately in the Q&A feature.
Okay.
And if you'd like to connect there, I'm not sure if these comments are saved.
Okay.
But I would feel free to interact with people there, unless you're currently on a panel.
Okay, and I also want to remind Mark, if Mark is listening, to make sure that he goes through and reads so many of these amazing comments and questions. Thank you, Kyle.
I am. Thanks, Don.
Joey. No.
All right, everybody. I think that we are just about ready to get started with our afternoon session. So welcome to anybody that is just now joining us. We had a really great conversation this morning, and we're really looking forward to the afternoon. So I'm going to go ahead and hand it back over to Professor Rabel, who will introduce our fourth panel and the moderator.
Welcome back, everybody. We're about to have a very important panel discussion, and I really appreciate all of the judges and lawyers that are going to be part of this next panel, which is a little bit longer than the ones this morning because the subject matter calls for it. Let me introduce our moderator, and then she'll introduce the rest of the panel. And so Seema, if you can appear on the screen, that would be great. Seema Saifi is an academic fellow at the Quattrone Center for the Fair Administration of Justice at the University of Pennsylvania Law School. Now, she only started that a few months ago, and I was able to grab her to be our moderator for this and write an article for the symposium issue on this topic. I met Seema over the years because she was an Innocence Project attorney for a long time and actually handled some cases in North Carolina, but of course we interact at the annual conferences, which we haven't had now, of course, in a couple of years. We hope to regather again next year. So she was a staff attorney there, did some work with the ACLU in Pennsylvania, and challenged civil liberties abuses in cases involving racial justice and national security, and was also a litigation associate at a New York law firm working on federal habeas, challenging the indefinite detention of men imprisoned without charge in Guantanamo Bay. So Seema, thank you so much for organizing this panel and leading it. And I'm going to turn it over to you, if that's all right, to introduce the folks, and they, as you call them out, if each panelist would go ahead and turn on your video and your microphone, because this is going to be an all-panel discussion. Thank you so much, Seema.
Thank you so much, Mark, and thank you to everyone for joining us for this very important conversation on secondary trauma and race. So we have an all-star lineup of lawyers and judges doing incredible and tireless work in the criminal justice system, and I will get right into introducing them. And just to reiterate what Mark said, feel free to keep your audios on mute, but when you are introduced, if you could please turn on your video, that would be great. So we are delighted to be joined first by Judge Gregory Weeks. Judge Weeks served as a Superior Court judge in Cumberland County for almost 25 years, and also served as Senior Resident Superior Court judge until his retirement in 2012. Earlier in his career, Judge Weeks worked for a decade as an assistant public defender, also in Cumberland County. Judge Weeks has served on the board of directors of the Sentencing Project and the North Carolina Justice Center, and he previously served as chairman of the North Carolina Commission on Racial and Ethnic Disparities. In 2012, in a series of landmark decisions, Judge Weeks issued the first and only rulings under North Carolina's historic Racial Justice Act, vacating the death sentences of 4 men after finding that prosecutors had engaged in intentional and systemic discrimination against African Americans in jury selection at the county level and throughout the state. Judge Weeks is the recipient of the North Carolina Advocates for Justice Outstanding Trial Judge Award and the North Carolina Academy of Trial Lawyers Outstanding Trial Judge Award. He is also the recipient of the Frank Porter Graham Award for Lifetime Achievement in Civil Liberties. Welcome, Judge Weeks. Next, we have Henderson Hill. Henderson is senior counsel at the American Civil Liberties Union Capital Punishment Project. Henderson began his career with the Public Defender Service of Washington, D.C., where he remained for 10 years, and he has spent his legal career in indigent and capital defense and civil rights work. Henderson founded and directed the Center for Death Penalty Litigation in North Carolina. He then spent over a decade as a partner at the civil rights law firm Ferguson Stein Chambers and was the executive director of the Federal Defenders of Western North Carolina. He is the founder, first executive director, and director emeritus of the 8th Amendment Project. Henderson also launched and continues to serve as co-director of Redress North Carolina, an initiative aimed at addressing mass incarceration in the state. In 2007, Henderson was inducted as a fellow of the American College of Trial Lawyers. He also won the Center for Death Penalty Litigation's Kirk Osborne Award for Leadership in Capital Defense. In the summer of 2020, Henderson was appointed by Governor Roy Cooper to serve as a member of the North Carolina Task Force for Racial Equity and Criminal Justice. Welcome, Henderson. We are also delighted to be joined by Judge Karen Edie Williams. Judge Edie Williams is a Superior Court judge in Mecklenburg County. She was appointed by Governor Cooper in 2017 and elected to another term in 2018. Judge Edie Williams was previously a district court judge where she served for 7 years after being appointed by Governor Bev Perdue. Judge Edie Williams began her legal career as an assistant public defender in Charlotte. We see a pattern here. She then worked for 7 years as an assistant U.S. attorney for the Western District of North Carolina, where she prosecuted white-collar crimes and served as financial crimes litigation unit supervisor in the U.S. Attorney's Office Civil Division, and she received several awards as an AUSA. Prior to her judicial appointments, Judge Edie Williams also worked as a vice president and assistant general counsel for Wachovia Corporation. Judge Edie Williams is a former vice president of the Mecklenburg County Bar, and she was appointed by the North Carolina State Bar President to serve 2 terms on the State Bar Disciplinary Hearings Commission, where she presided over numerous ethics trials for North Carolina lawyers who are at risk of suspension or disbarment. Welcome, Judge Edie Williams. Next, we have Satana DeBerry. Satana DeBerry is the newly elected district attorney of Durham County, where she took office in 2019. Prior to her election, Satana spent her career working on behalf of poor people in housing, consumer finance, and community economic development. Before she took office as district attorney, Satana was the executive director of the North Carolina Housing Coalition, where she worked on issues of affordable housing, and she was senior vice president of policy and programs for the North Carolina Community Development Initiative. Satana previously was general counsel for the North Carolina Department of Health and Human Services. Earlier in her career, Satana was a criminal defense attorney and also led the foreclosure prevention project at Durham Self-Help Credit Union. Satana has previously served on the board and as interim executive director of Durham Habitat for Humanity. Welcome, District Attorney DeBerry. And finally, but certainly not least, we have Christina Swarns. Christina is the executive director of the Innocence Project. She previously served as the president and attorney in charge of the Office of the Appellate Defender, one of New York City's oldest institutional providers of indigent appellate defense. Christina spent over a decade at the NAACP Legal Defense and Education Fund, where she served as LDF's litigation director and criminal justice project director. Christina previously was a federal defender in the Capital Habeas Unit of Philadelphia's Community Defender Office and a criminal defense attorney at the Legal Aid Society in New York City. In 2016, Christina argued before the US Supreme Court and won Buck versus Davis, a challenge to the introduction of explicit racially biased evidence in a Texas death penalty case. She is one of the few Black women ever to have argued before the US Supreme Court. Christina is the recipient of the Norman Redlich Capital Defense Distinguished Service Award from the New York City Bar Association's Capital Punishment Committee. She was also selected by the University of Pennsylvania Law School's faculty to be an honorary fellow in residence, an honor given to an attorney who makes significant contributions to the ends of justice at the cost of great personal risk and sacrifice. And I thought that was an appropriate sentence on which to end the introductions. So just to situate ourselves among all the other panels that occurred this morning, the ways in which race and trauma intersect in the legal system have too often been ignored by the law and by the legal profession. Lawyers of color have borne witness to this intersection, from individual microaggressions in the workplace to the structural racism that pervades our institutions, including our criminal justice institutions, where the intersection between race and trauma is perhaps nowhere more acute. In just the last few years, this intersection has received heightened national attention. We have witnessed the historic formation of the movement for Black Lives. We have witnessed an endless number of police killings of unarmed Black men and women and the accompanying violent police response to peaceful protests supporting Black lives. We have witnessed stark disparities in just last month's Capitol siege, which as we speak is being replayed in this week's impeachment hearings. And we have witnessed an extraordinarily disproportionate impact of the COVID-19 pandemic on illness and death among people of color, all of which have had traumatic consequences on people of color and have increased local, state, and national focus to issues of racial injustice, but not enough focus. In earlier panels today, we heard compelling personal accounts about the effects of secondary trauma in the profession. In this panel, we will continue that discussion, but with a more specific focus on race and the criminal justice system. So let's dive right in with the first question for this fantastic group. The United States incarcerates more people in absolute numbers and per capita than any other nation in the world. African Americans are disproportionately overrepresented as defendants in the criminal justice system. African American communities are in turn disproportionately affected by trauma in the criminal justice system. Part of addressing why our institutions are the way they are and why trauma is intergenerational involves understanding the legacy of racism in this country and the historic nature of our institutions. I want to start by asking the panel, how do the traumatic experiences that people of color have endured, particularly African Americans, how does that trauma manifest in the criminal justice system? And how does that trauma reproduce the inequality we see in the system? And it's a question for the group, for anyone who wants to begin.
I'm happy to start out, Seema. Thank you so much for the invitation to participate in the panel. I want to thank Wake Forest and Mark Grable. This is a wonderful and really, really important and timely conversation. So thank you very much. So I'm gonna just tell quickly one story of one case that I litigated that I think speaks to the question of how the historic racial terror in this country continues to impact like contemporary functioning of the criminal legal system. When I was at LDF, we litigated, I represented someone on death row in Arkansas. And when we were investigating the case and preparing the petition, we spent a lot of time in the county where this case took place. And part of our job was, of course, to understand sort of the community dynamics as well as our client's individual history. And what we learned pretty quickly and what we heard from African-American, prominent African-Americans in the communities, judges, lawyers, over and over again, was that Black people in this town didn't like going into the courthouse. They didn't like, were not either invited to, and to the extent they were invited to serve, they didn't want to serve. But largely there was this sort of this recurring theme of how Black folks in this community were afraid, were unwilling to interact with the criminal legal system. And so we sort of pushed it. We thought, okay, well, that makes sense. Nobody wants to be a witness. Nobody wants to obviously be arrested. No one wants to go through the system. And so, we were, sort of just trying to understand what this was about. We kept pushing and they said, no, we're not talking about that. That's obvious, right? But folks are concerned here about going to the courthouse to get a marriage license. Folks are concerned here about going to the courthouse to register a deed, like to do, the routine things of interacting with the courthouse. And this was a fact that just puzzled us, for a while. And it started us sort of digging into the history of this particular town and this particular county. And what we ultimately learned over time was that this particular county had a mass lynching in the turn of the century. 25 men, women, and children were lynched in one night. You fast forward over the next, 50 years, we learned that there was another, 8 to 10 people lynched in this county. And then more specifically, there were 2 gentlemen who were lynched in one night where at the courthouse, at the very courthouse in which, on the lamppost in front of the courthouse, in which people were now today, expressing concern about interacting with. And so, we ultimately had the first Black prosecutor in the county, testify sort of to this fact. And he went on the record and this post-conviction hearing, and he said, to no objection from 2 assistant state attorneys who are sitting to my right, that the understanding in that community was that the courthouse, and I'm quoting him, was not a safe place for a Black man to be. And that was for a trial, a capital trial in the 90s. And as it turned out, after he testified, people in the audience came to our defense table and said, thank you so much for sharing the story of what it's like in this community, because it's the same way today. So that's just one specific example of, right, how the history of racial terror in this country continues to operate, right, in the way that that case was tried, right? So our client ultimately, of course, was tried by a jury that was overwhelmingly white, even though the county, you know, the city and the county had a disproportionate number of Black people, right? And there was two dynamics going on, right? Where Black people were afraid to interact with the system, and then there was a separate process of the system excluding them. But that's just one example of sort of the trauma of the history of racial terror and violence in this country, operating in a way that is literally disrupting the functioning of the system today.
And I do want to piggyback on a little bit as to what Ms. Swarms has stated as to how trauma is manifesting itself in the criminal justice system. What I'm seeing as a judge, what I've seen over the course of years, is the issue of trust or distrust of the judicial system because of all the trauma over the past years. So despite the fact that I sit in a position of neutrality, I often find that criminal defendants who appear in front of me all but express that they don't trust me because I work for the system, regardless of the fact that I'm not an advocate, I'm not prosecution, I'm not defense, I sit in the middle. It's hard to help someone understand that despite their lived experiences, I'm going to listen to them. And so they don't trust me from the minute they walk in the room, regardless of who's sitting there. It's the fact that I'm part of this system. Some would believe that because of my race and because of the fact that a lot of the criminal defendants who appear here in Mecklenburg look like me, some would assume, rightly or wrongly, mostly wrongly in my opinion, that there may be some automatic feeling of trust or security in the courts when they see a Black judge. But that's not always the case, because those scars are still there from the past. And they come in with all of that. We don't see it, you don't wear it on your shoulder, but it's there. And so we experience that a lot, is the issue of trust. And how do you overcome that? You can't build a rapport with someone in a matter of 5 to 10 minutes of that encounter. The most you can do is try to help them understand that you are there to listen and to hear them out and to give them a fair day in court or however long the trial may last. And so that's one of the obstacles that I face, is trauma manifests itself as an issue of trust or distrust in the court system, no matter which seat you're sitting in, just by virtue of the history.
Yeah, Judge Williams, A.D. Williams makes a very good point. You know, I am the elected prosecutor in a jurisdiction in which the senior resident superior court judge is Black, the senior district court judge is Black, most of our district court bench is Black. Our chief public defender is Black, our sheriff is Black, the chief of police is Black, on and on and on and on. You know, we have a historically Black college and university right within a mile of downtown. Durham is a quote unquote Black city. And just to give you, you know, Christina talked really about these issues of racial terror that we hear about, these big issues, right? Lynchings in the public square. I think what Judge E.D. Williams is talking about and what I experience every day is just the mundanity of how racism has seeped into the system. So even in a jurisdiction like mine, where all of the people in power who are making the decisions essentially are Black people, and all of them individually, if you talk to each of them individually, would tell you that they have themselves been a victim of racism, that they are themselves warriors for racial justice, that they see the ways in which systemic racism consistently acts in the criminal legal system. We still get the same outcomes, right? And so that is a tension that I think is hard to resolve, certainly for me.
Let me go back and give a different but also historical perspective. I came to Fayetteville, North Carolina in 1977, and as Seema has indicated, I was a public defender for 10 years. Saw it from the perspective of an advocate. In the early mid-'80s, a lawsuit was filed in North Carolina. At that time, judges who ran for Superior Court seats had to run statewide. A lawsuit was filed initially by Republicans. I think their contention was that that method of selecting or electing Superior Court judges diluted Republican voting strength. North Carolina Association of Black Lawyers joined that lawsuit. At that time, if I recall correctly, I think the only African-American who had been elected under that scheme was Cliff Johnson out of Charlotte. As the lawsuit wound its way through the federal court system, negotiations were ongoing, and an agreement was reached by the then democratically controlled legislature that 8 new seats would be created. One of those seats was created here in Cumberland County. We had to run statewide, but the only opposition could come from your district, and the expectation, in fact, there was a lot of effort to bring in folks into the district to run to maintain status quo. So I had gone from a perspective of a advocate, criminal defense lawyer, representing defendants ranging all the way up from misdemeanors at the outset through capital litigation to all of a sudden being a judge. And it was unique in many respects as we traveled around our state, because our scheme provides that typically you're home for 6 months and you're on the road, normally within your division for 12 to 18 months, but you're subject to assignment anywhere in the state. And it was interesting to arrive at a courthouse in not just our more rural districts, but in some of the larger districts where you would go through, where court personnel would go through, and you'd be stopped by a bailiff saying you can't come through here. You would have your robe on your arm and your book bag, because we didn't have computers back in those days. But when you actually took the bench and looked out on that audience, you could sense, because typically you were looking at folks of color who were there for criminal sessions, a mixed response, some expectation that there's somebody who looks like me sitting in that seat. And I think initially, at least the perception that I had, there was an expectation, there was a hope that had not existed before. And now I'm hearing folks who are talking about more recent events saying perhaps that hope is diminished to some degree, that the expectation has gone somewhat back to that's part of the system. And I think, frankly, as I look across the faces of the folks on this panel, all of us at one point or another have had to come to Jesus moment in terms of how we respond to that. And that's not an easy thing to do, because you have your responsibilities as a judge, but at the same time, you've got your life experience that tells you that if there's going to be fairness in this process, you have to be one of the catalysts to bring about that fairness. And that's something I hope we can talk about as we go forward this afternoon with this conversation.
I, for one, would join my confession to Judge Weeks's suggestion that we all share in this tension, as Satana referred to. This is real tension. I mean, as individual professionals, we throw our whole soul into the work we did, and we're proud of the results. We're proud of our efforts. We're proud of the teams that we work with. But then we walk away and look at a system that is every bit as racist and unfair as it was when we started this work. And for me, that's almost 40 years ago. And so the tension that comes with thinking, well, you've put this energy into the work and the system has changed so very little. I think what has been really positive and impactful about the last few years is the addition to the intellectual discourse, the work of Brian Stevenson, of Michelle Alexander, of Susan Herman. There's just a lot of people that have contributed to the notion that we are so far beyond the tweaking of a system to the point that we need transformation. And I think a lot of the discourse has suggested that policing, which started as an institution to control runaway slaves, we've moved from that, but many of the traditions and the culture of that institution still draw from that legacy. And when we talk about the conversion away from lynching, my goodness, what Christina shared, it still stops you in the tracks. But the modern death penalty draws so directly from that legacy. And what we know from even the Supreme Court decisions is that the modern death penalty grew out of the need to replace that lynching system. So I take some comfort that the Wake Forest University Law School has instituted this symposium. I take some comfort from the fact that a Southern governor in North Carolina instituted a task force on racial equity in the criminal justice system. And in that task force, we had other people who are not your usual customers, not your usual consumers of the work that we do every day. And it was healthy and good to see their eyes open. When you talk about mass incarceration as a set of statistics, it's one thing. But then when you hear the stories of a 17-year-old Black woman who appears in court for the first time, no criminal history, the low person on the totem pole of a small drug crew. When she appears for sentencing 2 years later, she's the mother of an infant. The 3 male co-defendants, they get less than 3 years, she gets over 20. Ripped from her arms, is literally an infant. And so when we talk about trauma and racial terrorism, there's the role of police shootings, there's the role of the death penalty, but what about that separation of a single parent mother and an infant to serve decades in prison? And I think when people move away from just sort of the raw statistics to see and to put faces on what mass incarceration means, we can make progress as a community. And that's why I think these task forces are important. I think a symposium like this is important. I think lawyers in particular have a very special role in leading and educating our communities about these fundamental truths. And I take some comfort from this summer's national reckoning on race that we're making some progress. I take some hope against hope, that the insurrection will have some educational value, the impeachment stuff will have some educational value, and we will continue to engage in this moral reckoning.
So let's discuss that tension. I mean, there's a number of different threads I'm hearing here, and I want to go back to one that started with Christina, and I think all of you have talked about this idea of disengagement. And I'm going back to this paper that I read that many of you have probably read. It's by Monica Bell, and it's about legal estrangement and this theory of the relationship between African Americans and policing. And she talks about it in a different way. She said that people have started to develop this theory of procedural justice, but she wants to look at it as a theory of legal estrangement, and the way that communities are just feeling estranged from law enforcement for a whole number of reasons. And when you have referred to this idea of the long-term effects of racial terror people not feeling safe, people feeling disengaged. How do you wrestle with that disengagement when we have seen just this year how engagement from communities of color is vital to protecting our freedoms? Like, a new president was installed because of a robust turnout of particularly Black voters. High Black voter turnout in Georgia's runoff elections determined control of our Senate. And so that political power, which was led largely by grassroots efforts, largely by Black women to mobilize voters, it was the culmination of increased activism as well as increased pain. And so when people disengage because of this feeling that the system is unfair, their voices aren't heard, because of this distrust that Judge Edie Williams mentioned, and you've seen that disengagement, whether individually or community-wide, how do you begin to wrestle with that disengagement when the very people who are traumatized the most are also the most vital to protecting all of our freedoms?
Yeah, you recognize that it doesn't happen by itself. Yeah, Georgia didn't happen by itself. The turnout in Arizona didn't happen by itself. You realize that the policies of folks who look to suppress the vote, the big lies by people in power, that has a real impact on folks. I mean, I recall in the small part of the world that I try to influence in these campaigns, you're making calls, you're trying to turn out the vote, and there's a sense of helplessness that it's futile. It's just complete futility. It's sort of the opposite end of that. The system is rigged. The vote is stolen. Folks in oppressed communities look at people of power and their powerlessness every day, and it's hard to sustain political agendas. And that's why I think it takes sustained work by community leaders. And I think all of us are in every sense, community leaders. I think lawyers are by virtue of profession, community leaders. I mean, it takes us to be engaged in our communities to demonstrate that Georgia and Arizona can happen. And it can only happen with sustained community empowerment, community drives. So I think that's one of the weights that we carry. I mean, we feel the same frustration as our fellows in the community, but we know from history, we know that we've got to overcome and resist. We know from our heroes in the past that we can't give up and give out. And so we've got to continue to inspire and to mobilize our communities. But we need to keep sustaining ourselves in this drive. And I'm sort of pleased to be surrounded by colleagues that I can take inspiration from.
Yeah, and I want to challenge a little bit even the framing of that question, that Black people in communities of color are kind of disengaged from the power structure. I feel like we're always looking outward at what can Black people do more of, what can communities of color do more of, when we are the ones who are consistently in this battle. Like every day, let's take, for example, this rise in gun violence across the United States. There's been lots of conversation about that. And what are Black people doing about that? There are hundreds, if not thousands, hundreds of thousands of Black people every day engaged in saving Black lives in their communities. Black women have the highest voter turnout of any group in this country. We're still in the battle. Kind of like what Henderson says, when you, as a Black lawyer, I don't know there are many of us who are in it for the money, even those of us who are making money, right? I don't care if you're going to work in the corporate offices of JP Morgan Chase every day as a Black person, right? You are still engaging in the struggle, and you're still moving forward racial justice in what you do. And so I think we have to think of ourselves really as doing yeoman's work. Like we are holding up. Judge Weeks said something that was really impactful to me when he says, to the extent that there's fairness, we are it, right? Just our mere presence in a place requires people to look at that place differently. And you know, I think all of us take that seriously. I don't think any of us, when we, you know, when we took that oath, when we raised our hand, when we decided to go to law school, you know, we didn't say, man, I can't, you know, wait for those bucks to come in. You know, I'm a Gen Xer. What it meant for me was that, you know, I saw people like Thurgood Marshall and Barbara Jordan, and I said, oh my God, like that's who I want to be when I grow up, right? So that's why I do what I do. And so we, you know, we're constantly working. So I think to call us to say we are disengaged is to kind of undercut the work that we do every day.
Let me share this with you. I presided over the Racial Justice Act cases, which dealt with the historic exclusion of African Americans from capital juries. It was across the board, but it was in the specific context of capital juries. It's easy to say that we're not, as a community, participating to the level that we can, but that ignores the fact that there's some reasons for that. We're talking about systemic, structural, and institutional racism that, first of all, limits the number of African Americans who end up in a pool. And then we're talking about economic disparities that make it difficult for a person who's making minimum wage or who may be a single parent to serve on cases that are on a variety of levels costly to them. And then we're dealing with the jury selection process where the system comes into play. One of the things that I did as a trial lawyer when I was involved in trying cases, including capital cases, was I recognized up front there were only going to be a handful of African Americans in that jury pool. And when the judge said those words, call for the jury, I was going to turn around and I was going to make eye contact with every African American juror coming into that courtroom. And my eyes were going to say to their eyes, you may not know exactly what's going to come on, but watch as it plays out. And when the prosecutor in the case was examining juror number 1, juror number 2, who were white folks, and then got to juror number 3 and reached over to the law enforcement officer and got a piece of paper, the communication was, that's a rap sheet that's being provided that they pulled in advance with the expectation that it applies to you. So you have means of communicating the same means we use every day in our lives that apply in the courtroom as well. But it also involves a responsibility on our part to go out. It's frustrating, it's disappointing, but we have an obligation to educate. And when our folks in our community understand all of the barriers that are out there and how important that a process is, folks, I spent probably 6-7 weeks in the RJA hearings. And there were days when I would look out the audience and the only folks of color were me, the defendants, and one of the bailiffs. Now, this had to do with issues of life and death. But for all of the reasons that we're talking about, which are complex and multifaceted, we still have that additional obligation of when we're not in the courtroom, when we're not on the bench, going out into the community and doing our part, because our folks, just like everybody else, has been exposed to his story, not history. And educating them exactly why we are where we are based on the history of this country. Oops.
So I would just add, I think that there's a really important component of, I think people reacted over the summer and people reacted over the last, several years of the Black Lives Matter emergence. I think in part because for the first time in a long time, we were calling it what it is, right? Right. We had spent, all of us that are in this panel have been working in the system for, decades, and have seen the, I have never been in a courtroom in any part of the country where it doesn't look exactly the same. Rural, urban, north, south, it doesn't matter where you are, right? Every courtroom I have ever been in, it's a sea of Black people and brown people being prosecuted, and the other side of the bench, of the bar is overwhelmingly white. And it doesn't matter if it's in a place that is disproportionately white. Literally, the courthouse population will be the same. It's never different. And and we have all in this conversation, seen injustices, and we've heard them characterized as this is a bad apple, and this is just a rogue such and such, and this is a bad defense lawyer, and this is a bad prosecutor, and this is a bad judge. But I think what captivated people was we were calling what was happening what it is, right? Which is what Judge Weeks just said, right? This is a systemic problem. It is a structural problem. And I think that there is something about, and I think Henderson flagged this, right? Or maybe not Henderson, right? There is something about the mundaneness of the court process, right? If you're in there every day and people are just coming in, it's sort of numbing, right? The shock of the disparity, of the stark, overwhelming, shocking disparity becomes normalized in a way that frankly, reifies, right, and reinforces the idea that the people that should be going through the system are the people that are, that are in the system, right? These people are in the system because they're the bad people. But that's not true, right? And if you step back from that, right, and you call and you name, right, that there is something wrong here, right, that people's lives are not being treated or valued equally, and the system is not functioning and treating people equally, right? Then, there's just really something important about all of us stopping, right? All of us that work in the system, and certainly I don't mean just Black people, all of us that work in the system, right? It's incumbent upon us to name what is happening and name what we see, because it's real, and it's not, it's not a figment of the community's imagination, right? The community feels disengaged in part by the failure of acknowledgement of the reality that they have endured for centuries. And so it's time for us, right, everyone that's in the legal system to be honest about that, right, to call it by its name and to begin with a process of grappling with, transition and transformation.
So just to follow up on that, and also on Judge Weeks's point about, being a catalyst for bringing change, for bringing fairness into a system that is designed to be unfair. We have seen this shape criminal justice outcomes, but I'd like to move on to sort of discussing how you talk to communities and even your own families. One of the questions that I had sent earlier was, when Amy Coney Barrett, before she became a justice, she was asked in an interview what it's like for her kids to have two parents who are lawyers. And she said, her kids find their father to be much cooler because her husband was a federal prosecutor, and their sons were riveted by his stories about how daddy was putting the bad guys away. And now, of course, she's not the first person to express prosecutorial work that way, but we are in this, new wave of DAs who are reimagining what it is like to be a prosecutor. And it's a role that adds a different kind of weight when speaking to communities, when speaking to youth. And so when so much of your work, whether it's being a judge or a prosecutor or defense lawyer, is not a dispassionate endeavor, but it occurs in a system that harms your own communities, harms your own families, how does that weight shape the responsibilities you take on in your individual and professional lives?
So I really deeply despise that Amy Coney Barrett story. And I despise it because it's so deeply racialized. I have been a criminal defense attorney, currently now prosecutor. And as a Black lawyer, when I was a defense attorney, I was a good guy, right? To a lot of Black people right now, I'm the bad guy, right? And even for me, when I was a criminal defense attorney 20 years ago, if you had told me that I would ever be a prosecutor, I would have, I try not to cuss because, I am trying to get to heaven one day, but I might have cussed you out, right? Because I saw prosecutors and people who chose to be prosecutors as the worst type of people, right? They were inflexible. They may individually be like a good neighbor or somebody I might have a drink with later on afterwards, maybe. But in the courtroom, I saw them as people who ignored the truths of people's lives, to talk about the story that Henderson Hill, gave us about the young woman who literally has her infant ripped from her arms, right? Because the law demands it. I tell this story that if a prosecutor told me the sky was blue, I would have to get up and go outside and look for myself because I would feel like they had done something to the windows, right? To make it look blue, right? So that's how deeply, certainly as a Black person, as a defense attorney, that's how deeply I distrusted the prosecution, the criminal prosecutors. Now, as a prosecutor, I have also come to understand that the dirty little secret of the criminal justice system is that not only are all of the defendants Black, all the victims are also Black. And there are, for communities that have been kind of the historical focus of law enforcement, and for defendants who come out of those communities, they have experienced real trauma, right? They have experienced real. I see horrible things every day, right? I talk to the families of every homicide victim. When we have initiated charges against homicide defendants, I make it my point to talk to those families myself, right? When we offer pleas, I've had families tell me, they don't like the plea that I've offered. It shows that I don't care about the lives of young Black men, right? I've heard it all. So, but what I also know is, so it's for those communities, it's not that they don't want policing, right? They want to feel safe too, right? They want it to be better, right? They want it to be more equitable. They want it to look like what it should look like, and not, they want, like Christina said, they want you to call it what it is right now, and then they want you to move to change that, right? So how do we, it's difficult sitting here as a Black prosecutor. It's kind of in vogue now to talk about progressive prosecution. People might get tired of seeing my face, but I will, remind you that of 2,200 elected prosecutors in the United States, people who look like me still represent less than 2%. So, in the words of Drake, now I'm hot, next time I'm not, right? So, this is still a system in which Black people feel, when they're defendants, they don't feel treated fairly, and when they're victims, they don't feel treated fairly. And so it's hard as a Black person to sit there. So my kids don't think of me as cool, right? I have 3 teenage daughters. One's a freshman at the North Carolina Central University, Eagle Pride for everybody out there. And one is a junior activist. And at some point, she and I are going to have to come to, we're going to have to come to Jesus with each other, right? Because she sees what I do in systemic terms as immoral. Now she's 16, you know, but she regularly talks to me about the criminal legal system and its impact on Black people and how I participate in that. And, you know, I'm her mom and she loves me. And one day I won't be buying her groceries and she'll have, you know, she'll be able to tell me exactly how she feels about what I do. But again, to go back to what Judge Weeks says, what I try to do in my office then is bring as much fairness and equity to what we do as is possible when 100% of the people you're dealing with are Black. Like, it's not like I can say to the law enforcement, hey, go out there and arrest people who aren't Black so I can prosecute people who aren't Black, right? I only essentially can prosecute what I have before me. And so, you know, and so what I try to do is, and what fairness and equity looks like to me is being more transparent, right? Talking about how we make the decisions we make, why we make the decisions we make, being really more transparent about what criminal justice looks like. You know, most Americans only have interaction with the criminal legal system on television. They watch Special Victims Unit, they watch NCIS, and those are all homicides and robberies and rapes and arson. And less than 10% of my caseload is violent crime. But that's all anybody wants to talk to me about, right? But the real opportunity is this 90% of stuff where if we're looking at it, where we're revoking the licenses of Black and brown people, where we're convicting people of drug and property crimes that have better resolution, that don't lead to collateral consequences. You know, that's how I think we do it more fairly. So I probably took up too much time, but.
Yeah, the most powerful experience I had with a related conversation also happened in Durham. I was invited to talk to a group of middle school students. This is 20 years ago. And since I was specializing in death penalty, I thought, well, that's an awkward conversation to have with kids this young. So it turned into more conversation just about policing and, you know, how we can get help to kids and children who need help. And we had discussions about evictions and food insecurity and those sorts of things. After the class, the teacher took me to her closet and showed me a picture, a gallery of last year's class, the students from last year. And she went through the life histories of all of those kids, evictions, transient moves within the school district in Durham, family members who were victims of crime, witnesses to crime, arrested for crimes. And you know, she told me, Mr. Hill, you know, I'm convinced when these kids turn 18, half of them will be your clients. And you know, the challenge that we have is a system that doesn't recognize all of the ways in which our children, our young adults are subjected to real trauma. Yeah, it's hard when kids are moved 5-6 times in a year because they're evicted multiple times in a year. It's hard when they're coming to school hungry and going home with no idea when next they're going to eat. All of these create barriers to education. It creates fights in the school. It creates expulsions. And yeah, unless we've got a system that is responsive to the broad social net, all of these microaggressions, all of these daily traumas are unrecognized and they compound day after day, year after year. And you know, so it's not only the question, how do we address it when some 18, 19, 20-year-old is charged with a violent crime? what have we been doing for the 15 years before that? And that's why when I hear cries for transformation, it's often in how do we recognize, the true class of survivors of trauma. They're not necessarily the complaining witnesses, the witnesses under subpoena for things that are being litigated in court. Our survivors are our neighbors. Our survivors are our family members who are going through these issues with no real backstop, no community backstop.
And I did want to add, in light of what Ms. DeBerry said regarding being the DA and prosecution, and what Henderson Hill said regarding the trauma that a lot of young people face that often goes unnoticed. By the time they come in front of me in the court system, I think part of my job, my responsibility is not to re-traumatize these people, young people, old people, all the same, because everyone has some experience that likely put them there, not by choice, just by their life circumstances. And so I take a huge responsibility once an individual comes in front of me and trying to understand not just the fact that they are in front of me for committing a crime, but how they got here. What was their life experience? What was their challenge? What was their barrier or obstacle? And then what can I do about it? And so I take huge ownership of that, because that's the least I can do, is try to meet them where they are, try to understand their perspective, and then try to move it forward so they won't come back into the system knowing all these barriers exist. For example, if I send someone to get substance abuse treatment because they're there for some kind of substance use disorder, and I already know that the person is homeless, therefore I know they have no money to support that, then how do I address that problem? So then I have to work with probation, and hopefully they're also trauma informed. It can help the person with transportation, help them into some kind of living situation where they can work with the person on resources. But it's important that when someone has experienced trauma, as a lot of folks are who come before us, that we try to identify it, that the attorneys, defense counsel present that to us so we know what we're working with. Everyone isn't the same. Everyone doesn't stand on equal footing. So we have to have that information to be able to render what someone may be just or fair judgments to the extent that we can. But we have to have the information to make the person more productive and help them know that we do listen and we do want to work with them. And we do know that everyone isn't the same. Everyone doesn't have the same experiences that place them in the judicial system. And so we have to come at it from a perspective of understanding, but also listening to that backdrop that Henderson spoke about.
So I want to come at this sort of from a different perspective, sort of a more personal perspective. I know that myself and Henderson and Judge Weeks share the experience of having, I shouldn't say you didn't fight for it, you presided, Judge Weeks, but Henderson and I had the experience of standing in a courtroom, right, and arguing for the recognition of racial bias, like really, right, in a specific case. So in my instance, right, the case I argued in the United States Supreme Court, my client was on death row because his own lawyers introduced an expert who testified that he was more likely to commit crimes in the future because he was Black, period, hard stop. That was the only evidence of future dangerousness in the case. It is the thing upon which he was sentenced to death. This case went through all of the courts and we lost everywhere except the United States Supreme Court. But so when I argued that case, right, I'm literally arguing the question of whether or not Dwayne Buck should be condemned to death because he and I, right, share the fact, right, the fact of birth that we are both Black people, right? I am as indicted and implicated in the outcome of this argument, obviously not as, right, who's going to be executed, but I am fully, right, implicated by the outcome of this case, right? I have a 12, going to be 13-year-old daughter tomorrow. Her birthday's tomorrow, So, I mean, it was, it's a challenge, right? To stand in the well of the United States Supreme Court and demand recognition of what is ultimately my own humanity, right? To be called to ask for that, right, in a courtroom. And then to prepare, actually, and indeed, you know, if I was, you know, deep buried in my back of my head, right, expect a decision that didn't recognize it, right? Like that I was losing, right? Every other court I went to said there is no constitutional error in this. Every other one, every single one, right? There was no constitutional violation here, right? And so I had to go into that argument, right? In the knowledge, right? That the Supreme Court could affirm the finding that there is no constitutional error in a jury condemning a man to death based on his race, and the courts affirming, upholding, and facilitating that execution. And then the consequence of that, like for me, right, as a Black person, as a lawyer, right, as a person in this country, like what do you even do with that reality? You know, that's a challenge. And I will say on a funny note, so in the series of moots going through that, everybody kept telling me I had to fix my face because I had the screw face on the whole time, right? Because it was hard, right? It was hard not to be really personally angry about the case, because it really was, you know, it was about me. It was about, you know, all of us here, all right, and our humanity. And that is a, you know, it's a different burden to carry. And I don't know Judge Barry, Judge Williams as well, but I know, right, Judge Weeks and Henderson have stood in that space, and you understand sort of the challenge of demanding, right, a recognition of Black humanity with, you know, for a client, when in reality you're doing this, you know what, you're doing the same thing for yourself, and that is a thing.
Yeah, the Racial Justice Act adds an additional dimension to that, because you're advocating for your parents and friends and neighbors, everyone who gets a jury summons and thinks that, you know, this is their opportunity to carry one of the two most serious obligations of citizenship. And you're going to go into a courthouse that's going to look at you in one dimension and decide, because of this color of your skin, you cannot sit on this jury. And to see that happen over and over again in every county in the state, that there is this accepted narrative that says if you're African American, you're not as qualified, you're not adequate to make judgment on this most serious of criminal charges in the community. Yeah, so it does energize you in a way, but it is also it's a secret tax on us as professionals, because it shouldn't be that we've got to defend ourselves, our family, our community, and their right to full citizenship. But that's what we're called on to do. And it's frightening just in the current state. And I think I keep getting drawn back to January 6th and seeing the difference in which these rioters were received and are received by a whole political party here. That, you know, our people, our concerns, our health, our safety is just not respected and viewed as fully human, fully American. And we are charged to advocate and defend that fundamental position almost every time we're in court or we're advocating the issues that we work on.
You know, I've heard the comments about trauma, and in all candor, I had really not given a lot of thought up until the invitation to participate in this discussion about another aspect of the trauma that I think all of us share. And I've been listening to what was said. If the objective is to argue and advocate for fairness, and if you happen to be a person of color, part of the dimension of the trauma that I really hadn't come to acknowledge in my own life was the examples that were given about the harm that's done by folks who look like us in our own communities. And being fair in that context as well, not ignoring that. You know, on a personal note, I grew up in New Jersey. I grew up in a neighborhood that would commonly be considered to be a hood. I've lost family members to drugs. I've lost family members to violence. On one occasion, when I was holding court in Fayetteville, North Carolina, a young lady came before me on an extradition matter and kept looking at me and looking at my nameplate. Turned out she'd done time with one of my relatives. So I have that life experience that played into who I am and how I see things. And I've had instances where I've had senseless violence committed by folks who look like me on folks who look like us. And if the objective is fighting for fairness, that additional strain or context of, well, you have to be fair in all respects. You have to do what you believe to be right. You can't argue that others are unfair and then put yourself in a situation or scenario where you can't, and it comes at a cost. Say, these facts require that I do what I believe fair here as well. In preparation, I pulled an article that really blew my mind when I thought about the trauma that all of us, I think, have experienced to one degree or another at one level or another, and how it bears on our own personal lives. You know, I thought when I came to Fayetteville, North Carolina, that the practice of law was essentially what I saw every day. You got in the office at 8:15, 8:30 in the morning. Depending on what your experience level was you worked district court, then went up to superior court. Our office had a practice that you second chaired on serious matters within 1 year until you moved up. But after 6 o'clock at night, 6:30, 3 of the 5 lawyers in our office were always there. Every Saturday, every Sunday, a majority of the lawyers in our office were in the office. We had brief banks, motion banks. I thought that's what the practice of law was all about. When you compound the things that we've been talking about and how it impacts on us and what you bring into your home, that takes it to a whole nother level in my mind. And I am more mindful today of how that trauma, the intersection of race, the intersection of secondary trauma, the intersection of the emotional cost and toll that it takes on all of us. That's why I appreciate us having the opportunity to have this discussion, because there is a cost. And I'm hopeful that this discussion will enable us to take that cost into consideration in addition to all of the other heavyweight stuff that we're talking about now as well.
So we are getting inundated with a number of audience questions, and I have to go to a couple of these. This one in particular was being asked and forwarded to me a couple times. It's a question from a professor, and the professor asks, given the realities of working in a systemically racist system as a person of color, how do the panelists manage their own self-care?
Well, I had, just Judge Weeks set this up well. It's tough. I can be cold, I can be mean, I can be distracted. And a lot of that has happened since my mother used to tease me. She said she didn't know if I was born a lawyer or I just found whatever fit my personality to do for a living. But, I've been practicing law now since 1994, which is over half my life. And it changes you. Like you're not, you do see the world differently. I have a therapist that I meet with every week. In addition to being a lawyer, a prosecutor, the elected district attorney, a parent, Black woman in America. I'm also the boss of other people, right? And so I make decisions every day that impact the well-being of other people's lives. And this job can tend to, it's kind of popped me out of my friend group. I don't have a ton of friends who either do what I do or recognize the stress of what I do. And so I also have a chat that I participate in with other Black women elected prosecutors. Sometimes that's a very small group of people. And so, you just have to take care of yourself. I used to exercise. I don't do so much of that anymore. But I think you have to be, you have to be intentional about the ways in which you take care of yourself. I don't know if any of you all knew Professor Jerome Cope, who is professor of mine in law school, but my second year in law school, he told me that the law can be a jealous mistress. Now, beyond the kind of gender issues around that, that he said you have to watch out for that. That's been good advice. I mean, it can take over your whole life. I was really the first panel this morning was really powerful. I want to thank those folks for being so open about that this morning. I actually read that article about her husband in the New York Times when it happened, and recognize that in many colleagues. But there's a special weight that we take, and I've seen lots of. I hold my breath whenever the bar journal comes out, and it has this disciplines and disbarments in it, because it used to just be full of Black lawyers, and a lot of it has to do with just the stress of doing this work.
I consider myself a survivor as a boomer, because for most of my work career, I didn't have that kind of balance. And I think I survived notwithstanding that, because in each workplace, you develop friendships that were deep and meaningful. And I think both in the abolition community and the criminal defense community, there are some very, very special people, not all of them lawyers. And many of them have been people that you've been able to share some of the weight of the work that we do. And I think that's been especially important. I think the bars and the Black bars slowly appreciating the need for this. For the last few years, I've attended the annual program by LAPD. I'm sure I'm getting the initials wrong, but I think that part of the bar that focuses on microaggressions and the need for self-care, I think is critically important. I'm hopeful that lawyers, most especially Black lawyers of younger generations, are fully participating in that. I look back at my career and think that having a partner who was fully understanding, and having two kids who forced you to spend time away from these microaggressions and huge aggressions that you deal with in the court were important to stabilizing my life. But we don't do enough. And I think we do have to be more intentional as a profession and as a community of advocates to understand that what Christina sparked, this is an assault on us every time we deal with and have to defend this aspect of our client's interest. And we need to recognize its impact on us. And we've got to find community ways of carrying that burden. And I've seen where it's heartbreaking, where partners and colleagues don't have that support. And the self-destruction can ruin lives and take lives. And that's just painful in an unspeakable way.
You know, the challenge I face being a Superior Court judge is we have a lot of heavy cases that we deal with so far as individuals receiving heavy sentences, long sentences, extremely long sentences, life sentences, death penalty. And that's a huge burden. And Judge Weeks, I'm sure you understand what I'm saying about this. And so self-care is important because the way it works here in Mecklenburg during our criminal administrative weeks, we are paraded with a host of cases, back-to-back robberies, back-to-back sex offenses, back-to-back whatever it is. But by and large, it seems like a lot of the back-to-back violent crimes are people who look like me and people who I feel like I can relate to on some level when they start speaking. And it bothers me. And I carry that with me, not just as I sit on the bench, but when I leave the bench, I think about those people. Just a couple of weeks ago, I had 3 gentlemen, ages 17, 18, and 19, come out back to back. And each one of them got sentences for robberies of no prior records of less than 60 months each. And my heart wept for them. And by the time the 3rd gentleman came out, young man, kid, boy, child that he was, I was heartbroken. And that was all before 11 o'clock that morning on one day. And so when I see those kinds of things come before me and I see the courtroom full of Black and brown people, and I wonder, what is their story? What brought them here? And then what is my role? And how can I even help in this situation? That's a heavy burden to bear when I feel helpless a lot of times. And so when it comes to self-care, I do have a couple of sister circles, girlfriends who I talk with. I'm in Judge DeBerry's camp. I do need a therapist. I've been talking about it for years, but I haven't yet gone there. I'm a former treatment court judge. And so, you know, I've talked with counselors who work within the court system, and I see the benefits of having someone to talk to, someone to walk through some of the things that I struggle with or we struggle with in the profession. Because what I've learned over the years is if you don't address it, you may start self-medicating in some form or fashion to deal with it in other ways, to try to just take yourself out of that level of anxiety that comes along with a lot of what we deal with, or even depression that comes along with a lot of what we deal with. And so for me, it's been very beneficial to have, we have 31 judges here in Mecklenburg County, 21 in District Court, 10 in Superior Court. And so I have a lot of people here in Mecklenburg that I can talk to so far as on the bench. As a judge, we're somewhat isolated as to the number of people that we can't really talk to about things that go on in the courtroom. There's not a whole lot of relatability within the bar. It's mostly within the judicial division, if you will. And so there are a lot of the judges here, primarily African-American female judges here in Mecklenburg, that I do talk to on a one-on-one basis, or even in some group messages regarding what we're experiencing, how we're dealing with it. One of our judges, the longest serving judge in Mecklenburg County, Ricky McCoy Mitchell, always reminds me that self-care is important. You know, what are you doing to take your mind somewhere other than what you had to deal with in court today, or what's going on in the future? And so the way that I've dealt with it is in leaning on my colleagues for support, my family, church, prayer changes things. It really does. And so I've done that. But I think my sister circles have probably been the best thing for me, someone to talk to outside of a professional setting, if you will.
I would just say that for me, I think I echo everything that everyone else has said, but I think that, you know, I have found it very important to have a universe that isn't this, right? That isn't this, right? That doesn't touch criminal justice and isn't tethered to criminal justice. So I have, you know, sort of my core friends who they're not lawyers. They don't spend their time dealing with murders. They don't, you know, none of it. It is, you know, it is a world of, you know, parenting a 13-year-old and, you know, like the other stuff of life. And for me to have a space where I'm not, you know, in charge of a big organization, like I feel your pain, Mr. Berry, on that, right? And not in charge of a large organization, you know, not, you know, dealing with the challenges of litigating in court. It's just, you know, me at my most, you know, me, right? Not the professional me, just like the inside me, right? And I have a place where I can go and be that without all the pressure, without the expectation. And for me, that's a very, you know, a really important and precious space.
So this is a heavy quote that I read from Brian Stevenson a long time ago that resonated from the moment I read it, and I just wanted to read it to you all. He was interviewed in The Guardian, and he said, and I'm quoting here, he said, "I don't do what I do because I have to. I do what I do because I am broken too. You cannot defend condemned people without being broken. You recognize this community of the broken. That makes it not about them, but about you. I'm trying to save my life. When they're executed, a part of me dies. When they're exonerated, I feel their freedom." And of course, Brian Stevenson is a longtime, capital defense lawyer and an advocate, and his introspection is just, it's very compelling. I just wanted to ask what you make of this insight that he reflects on.
Brian testified as an expert witness in the initial RJ hearing that I had. And that was my first opportunity. I had colleagues who had worked with him or had been involved in programs with him, but it was my first opportunity to meet him. He, as part of his testimony, presented a study dealing with appellate Batson decisions in southeastern part of our country. North Carolina then and now has the reputation of being, if I recall correctly, the only state in that area that has never upheld a Batson challenge. There's some, if I'm wrong about that, Henderson, please let me know. But the only one that I'm aware of is they found on behalf of the prosecutors that a defense lawyer had violated Batson, but they never found that a prosecutor had. And I read much of his material. I wasn't able to articulate it until I heard it come from him. But when he said it, it hit home for me. Because I recognize that part of my life experience, my professional experience, had brought me to the same conclusion. I'm broken as well. And I'm fighting to do what I can, not just to unbreak other folks, but for myself as well.
For me personally, I'm trying to move through the story of Black brokenness into a story of Black joy. I just had a moment of joy because I saw Justice Sherry Beasley's face pop up in the top corner of my computer. And so I know she's out there. So I say hey to her. Serving under her as Chief Justice was one of the great honors of my life. So, but yeah, it's hard. You can't do this work unless you understand that trauma is, to be a human being is to be traumatized. And I recognize that, when I show up, for many people, I am a reminder of the worst day of their lives. And I try to keep that in front of me. In everything that I do in this work, in the hopes that nobody has to do it again this way.
Henderson, I can't tell if you're trying to turn your... No? Oh, something's going on. Okay. So we have 6 minutes left. I really don't want to leave with a heavy question, but all the questions that are coming in are pretty heavy. So here's the last one, and maybe somebody can end us on a more hopeful note. This is from an attendee. I am a Black female attorney practicing in a rural Arizona county. I am the only Black attorney in the county. I have faced countless microaggressions and instances of racial bias, mostly from the bench and from prosecutors. I tried to notice a judge for cause for racial bias, and the presiding judge's written response was littered with ignorance, mischaracterization of my arguments, conflating racial animus and racial bias, and frankly danced on the line of overt racism. I feel powerless, and I have been prevented from responding so as not to, quote, anger the bench. What can I do? I feel powerless. I've considered leaving the county, but then I let racism win, and that is something I cannot do.
For what it's worth, I learned this lesson early on in my life. What don't kill you makes you stronger. Hang in there, do what you got to do, and stay steadfast to what you know is right.
I wrote a answer to that question in the Q&A, and I'll just say quickly, you know, I feel for you, sis. That is a rough situation to be in. When I was a criminal defense attorney, I was the only Black woman the only Black woman practicing law in 4 counties. And I was defending a young man in a trial. And at the end of the trial, the judge delivered to me a 10-page poison pen letter in which he had, I assume, rather than paying attention to what was going on in the trial, had spent time criticizing me. 10 handwritten legal note pages, criticizing me, how I had failed my client, and how I had besmirched the profession, the legal profession. And, you know, I didn't do anything about that, and I still haven't. And I'll tell you why, is because, you know, I tell people, if my law license is all I got, if I'm not practicing law, I'm flipping burgers. And so you gotta, my law license is gold. And so you gotta weigh, you know, the now plus the future. File it, write your notice, write down what happened, put it in a file in your office. Karma comes around, and one day, you know, he might need you for something, or he'll be in front of you for something, and you will have that. And so take that into how you, you know, keep that in mind as you make your decisions. And here's another thing: pay it forward. Don't ever do anybody that way, right? Like, you be the person. I tell the young lawyers in my office all the time, you be the lawyer you want to be. You practice with integrity. You practice fairness. Let them deal with themselves.
So I was just going to add, I actually don't, I don't know that I think that you need to be a martyr to this, right? I don't think you're required to stay and suffer through a system that is racist toward you. I don't think you should feel as if, you know, you have some obligation to subject yourself to that. I actually don't think that's right. You have choices, you can exercise them. And I don't think you should feel, you know, that your choice is to stay and be mistreated or to be defeated and go. That's not right. You have the right to self-care. You have the right to be treated well. You have the right to make a choice to go to a place where where you'll be respected and honored. And I don't think that's defeat. I think that's, integrity and respecting yourself. So I don't accept, I guess, the proposal that you have to stay and experience that. You don't have to stay and experience that. You have choices. It's a big country, and a lot of people would be appreciative of your work and your commitment.
Well, I think those are some very strong words to end on. So thank you so much to our very outstanding panelists. And thank you especially to Mark Rabel and the Wake Forest law students for your incredible work in putting this symposium together. I look forward to the next and final panel.
Thank you.
I just want to take a moment to recognize the profound reflections we just heard in that last panel. If our 700 guests could give a roaring applause, I'm sure they would. So it was such a privilege to end on that note there with that panel. So Next, I'm going to introduce our next moderator, who really needs no introduction. Professor Kenneth Townsend is the Director of Leadership and Character for the Professional Schools and Scholar in Residence at the Wake Forest School of Law. A recipient of the Truman Scholarship for Public Service and the Rhodes Scholarship, he earned a BA from Millsaps College and a Master's in Philosophy from the University of Oxford and a JD from Yale University. A licensed attorney and frequent constitutional law or frequent commentator on public affairs, he's taught courses in ethics, political theory, public policy, and constitutional law at Millsaps College, the University of Mississippi, and Yale University. He teaches professional responsibility and leadership and character in the professions at the Wake Forest School of Law. And as a student in both of his courses, I can attest he is the real deal. His research focuses on the relationship between law and morality, the role of religion in a democracy, and the ethical obligations of professionals. Ladies and gentlemen, it's my pleasure to introduce Professor Kenneth Townsend.
Thanks for those kind words, Kyle, and thanks to Ethan. The two of you have done extraordinary work in putting this symposium together. And thanks, of course, to Professor Mark Rabel, who has been the brains behind this operation from the start. This represents his passion and life's work in so many ways, and I've been honored to be able to be brought along for some of it. And thanks, of course, to all of you who have participated as panelists or moderators in the conversation so far. What an extraordinary day we have had. Thanks to each of you. So here's how our last session is going to go. Here in just a moment, I'm going to offer some short introductions for our extremely distinguished final panel. And then I'm going to set up some questions to get the conversation started, but I'm hoping to mostly get out of the way because y'all don't want to hear too much from me. We've got some impressive folks who have done some extraordinary work, and I'm really looking forward. I know you are looking forward as well to hearing from them. But without anything further, so I see that we have all three of our panelists here on the screen. I'm going to offer just a few words to introduce them, and then we'll get going. So Chief Justice Sherry Beasley, whom no doubt almost all of you already know, was the first African-American woman in North Carolina Supreme Court's 200-year history to serve as the Chief Justice. She served on the state's highest court since 2012 and was named Chief Justice in March of 2019. Justice Beasley also served for 4 years as an associate judge on the North Carolina Court of Appeals and was a district court judge for a decade in the 12th Judicial District in Cumberland County. Before beginning her judicial career in 1999, Justice Beasley was a public defender in Cumberland County. Justice Beasley's commitment to fair and accessible courts extends beyond the halls of justice. She has mentored countless students and judges, lectures at area law schools, and travels nationwide and abroad to promote the rule of law, the administration of justice, the importance of an independent judiciary, and fair judicial selection. A graduate of the University of Tennessee College of Law and Douglas College of Rutgers University, Justice Beasley earned her LLM in Judicial Studies from the Duke University School of Law. She has held several leadership roles in the ABA and in the North Carolina Bar Association and has received a number of awards for her leadership and service. And now, just as a few weeks ago, she's back in private practice at McGuire Woods. Welcome, Justice Beasley. We're so glad to have you. Your name has already come up earlier in today's conversations. Thank you for being here.
Thank you.
And now, Mr. Derek Johnson, whom I have the good pleasure of crossing paths with a bit when I lived in Mississippi in my previous role. Derek Johnson currently serves as president and CEO of the NAACP, a title that he has held since October of 2017. He formerly served as vice chairman of the NAACP National Board of Directors, as well as the state president for the Mississippi State Conference of the NAACP. A longstanding member and leader of the NAACP, Mr. Johnson has helped guide the association through a period of re-envisioning and reinvigoration. Under his leadership, the NAACP has undertaken such efforts as the We Are Done Dying campaign, exposing the inequities embedded in the American healthcare system and the country at large, and the victorious 2020 Supreme Court lawsuit, NAACP versus Trump, which prevented the Trump administration from rescinding the DACA program for millions of young immigrants. Born in Detroit, Mr. Johnson attended Tougaloo College in Jackson, Mississippi. He then received his JD from South Texas College of Law in Houston, Texas, and then has served over the years as an annual guest lecturer at Harvard Law School, lending his expertise to Professor Lonnie Guarner's course on social movements, and as an adjunct professor at Tougaloo. Mr. Johnson is frequently featured on CNN, MSNBC, CBS, ABC, among other outlets. So his face probably looks familiar to many of you, where he advocates on behalf of the Black community and all of those who are affected by systemic oppression and prejudice. Thank you so much, Mr. Johnson, for being with us today. We're glad to have you. And finally, we have Judge Carlton Reeves, whom I've had the good pleasure of getting to know over the years, again, back when I lived in Mississippi, and whom I consider a personal hero in many ways. Judge Reeves is a judge on the U.S. District Court for the Southern District of Mississippi. He was appointed in 2010 by President Obama. Previously, Judge Reeves worked in private practice at his own firm, Paget, Reeves, Johnson in Jackson, and then was Assistant U.S. Attorney and Chief of the Civil Division in the U.S. Attorney's Office for the Southern District of Mississippi from 1995 to 2001. A graduate of Jackson State University and the University of Virginia Law School, Judge Reeves clerked for Justice Reuben Anderson of the Supreme Court of Mississippi before beginning his own legal career. The second African-American to serve as a federal judge in Mississippi, Judge Reeves is the author and number of many notable and groundbreaking decisions, including Campaign for Southern Equality versus Bryant, which struck down the state's same-sex marriage ban, and the United States v. Butler, which featured the really horrific, tragic, race-motivated murder of 48-year-old Black man James Craig Anderson. In a speech last year at UVA, where he was awarded the Thomas Jefferson Medal in Law, Judge Reeves spoke out against present-day attacks on the federal judiciary and called for greater diversity on the federal bench. So nice to see you, Judge Reeves. Thank you for being with us today. So to quickly catch us up to speed on where we are, this is our last session of the day. We've had a series of conversations focused on secondary trauma and the legal profession. And for those who haven't been around for the whole session, let me provide just a very quick overview. When we talk about secondary trauma, some of what we've heard about includes some of the most horrific and acute cases of representing alleged child sex offenders and capital cases, some of the hardest work that lawyers can face in many respects. But when we've talked about secondary trauma, we've also talked about the various ways in which lawyers face serious occupational hazards, no matter what line of work they work in. There are things like billable hours, competitive workplace, occasional negativity and personality that lawyers have to confront themselves, institutional factors, cultural factors, social factors at play that present various challenges. So I don't want us to feel like we have to focus simply on the most acute forms of secondary trauma in our conversation today. I want us to be able to talk about that as well as the broader challenges that just about any lawyer might face. As I alluded to, we've talked about institutional and cultural concerns as well as more personal sorts of concerns that lawyers face. So I'd like for us to keep that in mind as our conversation moves forward. We've talked a bit about COVID and the ways in which this pandemic has exacerbated some of the ongoing challenges that lawyers and the law profession faces. This last panel that we just heard from was an extraordinary panel that focused on race and the ways in which the trauma associated with the system of law as well as the practice of law is uneven and disproportionately impacts people of color, and our conversation focused in particular on Black Americans. So that's a little bit of the background that we've come from so far today. This session is focused on lawyers taking leadership. And the reason that I've invited each of you, that we as a symposium have invited each of you, you all have had tremendous legal careers and have embodied the best of the legal profession in so many ways. And when we think about ways of navigating challenges associated with the practice of law, one thing that I think about as an attorney myself is, what would some of my exemplars do, right? Who are some people in my life who have managed to lead through adversity and keep their head above water and to make a positive difference in the world? And certainly the three of you are very high on that list. So I think to get things started, what I'd like to do is pose this question related to exemplar, since I consider each of you an exemplar. I mean, who is someone in your own life that you have perhaps looked to as an example for navigating personal and or professional distress? And what is it about that person's example that you that you were impressed by, or that has shaped your life in some way or another? And if that doesn't prompt an immediate response, then I'm happy to pose another question. I've got a long list, and I don't want to go through too many questions because I want to make sure the audience has a chance too. But Justice Beasley, you're the first one on my screen, so I'm going to give you the opportunity first if there's anyone that comes to mind for you. But if not, I'm guessing Judge Reeves or Mr. Johnson might jump in as well.
Professor Townsend, I'm really delighted to be here this afternoon, and I'm truly honored to be on this panel with Judge Reeves and with Mr. Johnson, both of whom really have had very esteemed records of service, and I am truly thankful to be here. I really must say before I answer your question that I came in on the end of the other seminar. And when I heard my colleagues speaking so poignantly about their feelings about the practice of law and how they've often been treated in courtroom settings and in other capacities, it literally made my eyes well. Part of it is that I know them. And Judge Weeks, I actually tried my first case in front of him as a young lawyer. So I know them, but it just frankly made me think about how we kind of do this all day, every day, and how often we're not really, I mean, I'm not really necessarily attuned to that. You face whatever that situation is. For me, it's easier to confront it and not just to move on. If I'm going to be upset or quaking in my boots, if you're going to be that either way, for me, it's easier to just confront that. And my mother, as we talk about who sort of helps you think about how to navigate, and she's passed on, but she was very forthcoming. You never had to really wonder what she was thinking. Now, her approach was very different than mine, but for me, there really is something refreshing about just putting it on the table, calling it what it is, and then we don't have to really dance around it. You might be upset or angry or whatever that emotion is after you say it, but whatever that thing is for me that I'm feeling, if I don't say it, it's going to be worse. And I also think that for ongoing relationships, it's not really fair to the other person for them to walk away thinking that what they said or did was okay, and that I received it well. So for me, it's less about having a teachable moment for them and more about us having an understanding about where our relationship is and how it's really important for us to be able to move forward and likely work together because of our respective roles and the like. So there have certainly been a lot of people along the way who have modeled how to navigate, and certainly Judge Weeks is one of those people, and people do it differently, and just because people do it differently doesn't mean that they don't serve as examples for how you determine for yourself the right way to do it.
Great. Thank you so much. Thank you. Judge Reeves, you're next on my screen, so I'm going to come to you. Who are people in your life who have provided examples to help guide you through challenging times? And so just so y'all can start thinking, in a moment, I'm going to ask you about a particular maybe challenge in your own legal or personal careers.
Yeah, thank you, Kenneth, and thank you, Wake Forest, for inviting me. It's such a pleasure to finally meet Justice Beasley, someone I've read about and seen over the last several years, and commend her for her leadership of the North Carolina Supreme Court, where one of my dear friends actually serves, Anita Earls. And it's good to see Derek again. I don't see him often anymore. Don't see him often because he's everywhere except Jackson and except around me. So it's so good to see him and serve on this panel with him. Like Justice Beasley said, our lives each of our lives are full of intersections of people in our lives at various stages of our lives. There are school teachers back in Yazoo City, Mississippi, who have influenced me in ways in which they still impact my life. going back to the 8th grade, a social studies teacher of mine, Thelma McGee, talked to us about two things I distinctly remember. She would be about the age of Emmett Till. And when we were talking about just a snippet, because this is 8th grade and yes, it's in Mississippi, we know we didn't go into detail, but the pain that she felt in talking about them killing that little boy. And I only came to realize later in life that she must have been about the same age as he, about the time that he was killed. So that was somewhat impactful of me. But growing up in Kansas City, the school teachers, going to Jackson State University, Charles Holmes, Mary Coleman, Allie Mack, Katina Moreland Young, Roy D. Berry, Leslie McLemore, all of these great thinkers about, and people talking about trying to make Mississippi a better place, encouraging us to go off to law school, go off to graduate school, do stuff away, come back home. And then you go from there. And, in my legal career, it was the man who gave me that first opportunity to be a law clerk, Justice Reuben Anderson, no doubt about it. Took an interest in me, took an interest in a guy who was in law school who wanted to come back home. And from there, we practiced together at the same law firm. And it was, and I heard the young lady about being the only Black person in that community in Arizona and how stressful that was. And I know how difficult it is for people to be the only Black, I don't know, but I've heard stories of being the only Black person in law firms. Where here, I was at a law firm with the man who mentored me and trained me. And I had somebody in that law firm who I could always go talk to about every issue, about any issue. And so in formulating who I would become as a lawyer, Justice Reuben Anderson would be that person, I think. And I also had the opportunity to serve there on the court for a brief moment while Justice Fred Banks was on the court. And he and Justice Anderson were childhood friends, saw approached the law in a different way. People will tell you, Derek will tell you, Fred Banks is the smartest lawyer in the state of Mississippi, deserved to be much on the Fifth Circuit or wherever he needed to be, SCOTUS even. And it's those individuals, I think, that have influenced me the most in my legal career. And then, of course, friends and family, brothers and sisters, and all of that have influenced me as well.
Wonderful. Thank you so much, Judge Reeves. It's nice to hear all these familiar Mississippi names here as I sit in North Carolina. So now I'm going to hand it over to someone else who's spent a great deal of time in Mississippi, Mr. Derek Johnson. Thank you again for being with us. And I wonder if you could reflect for just a moment as well about maybe somebody or multiple people who have provided an example for you as you've navigated difficulties in your own life.
Sure, Kenneth. Thank you for the invitation. And I feel like I should be in the audience when I'm on here with Judge Reeves, and also honored to meet you, Judge Beasley. And like Judge Reeves, Anita Earls also is a good friend, and we've done a lot of civil rights type stuff together. I also feel like I should be in the audience because although I have a law degree, I've never practiced. And I made that decision for multiple reasons, but one of the key reasons, and Carlton, as I was listening to Carlton talk, being a part of this enclave of what I thought were people who were giants, both in thought and commitment and perseverance. Growing up in Detroit, first in my family to finish college, and getting to Mississippi, having no family there, being on Tougaloo's campus created a level of exposure and freedom that I didn't know exist. And I only realized it exists because of some of those giants. Getting on campus and I can recall walking across the yard and everybody I met seemed like they said they were pre-law or pre-med, and I had never met a Black doctor or a lawyer that I knew personally. And so when the advisor asked what my major was going to be, I said pre-law because I didn't want to take another math class unless I had to. But in the midst of that, running across people like Hollis Watkins, one of the original SNCC organizers in Mississippi, and working with him and getting an appreciation of loving people. Therefore, it was important for us to work with community leaders, and they were the experts of addressing the harms they seen committed around them and to them, and the work of organizing their voices to push their leadership forward, not for me to be forward. Benny Thompson, Congressman Thompson, just owning your power, understanding that if you are in a position of power, it is incumbent upon you not to conform to a status quo that's not in our best interest, but leveraging that power to expand opportunity for so many others. Fred Banks, who's the longest serving member on the NAACP National Board of Directors, a walk-in genius, a walk-in history lesson. I often ask him, I say, Judge, when are you going to write your book? His response, because he's so humble, was nothing new I can say that had already been said. And I always disagree with him because there's so much to be said from his perspective that will be enlightening, and to show how you can stand in your power, be clear about your voice, not conform to the status quo, and be accepted. Judge Reeves, in that same vein, I can recall prior to him going to the federal bench and taking on fight because it was the right fight and not being afraid of people viewing it as political or partisan. Because there's so much around the question of justice that we have allowed people to redefine as partisan or political, with its simple protection of equal protection under the law, or just issues of justice, and having the courage to stand up there. Judge, I recall the time before you got appointed, we'll go unnamed, there was an individual who felt entitled that they should be considered for a federal appointment, but they did nothing to help people. They were an excellent lawyer, but they wouldn't take risk in their mind to help people, to ensure equal protection under the law will be afforded to everyone. And so just being a part of that enclave and understanding that it's not me, I'm a part of a continuum of pushing forward to make democracy work for everyone.
I love what you said there, Mr. Johnson. Thanks so much for that. I think that really helps us move this conversation in an important direction associated with the pressures and responsibilities of leadership and of power, whether we like it or not. Lawyers have certain power and certain responsibilities that come with that. And I'm wondering if all of you, for a moment, this might be a hard thing for you all to do, but to maybe set aside the virtue of humility for a moment and reflect with us for a moment about a time in your own work where you feel like you have taken advantage of a moment that has presented itself and have used your power, your position, your role in a leadership capacity for good. Who would like to volunteer first? I'll take volunteers. If not, I'm a good teacher, so I can cold call if needed. But any volunteers here for a time when you feel like effectively used your position, your power, your role in leadership for good?
I'll volunteer.
Thank you.
I think everybody here knows that I was the Chief Justice of the Supreme Court of North Carolina through December 31st of last year, and was no longer the Chief Justice after I conceded in my race. There were 5.4 million votes cast, and I lost by 401 votes. And frankly, there were lots of moments when I thought it was important in my service as Chief Justice to, yes, lead the Supreme Court of North Carolina and also the judicial branch of government, but to also be thoughtful about the fact that we needed to be acknowledge this racial and gender disparities in our courts. And we had to be thoughtful about the cases that come before our courts. And we really needed to be thoughtful and work on the outcomes of those cases in our courts. And so when George Floyd died and Ahmaud Arbery and Breonna Taylor, and there were protests across North Carolina and this nation, and I made a statement, a public statement denouncing racism and racist practices in our courts in North Carolina. It was important to me as a Chief Justice to lead by example. And though I had been doing that, the right intersection of emotion and action on behalf of people across the state and the nation just made the statement timely in the way, only the way that it could. At the same time, Chief Justice Burnett Johnson, the only other African-American woman serving at the time as Chief Justice woman, and by the way, there are no African-American women serving as Chief Justice in the nation at this time, but our statements were featured by the Wall Street Journal and the New York Times, along with some other chiefs. But it was important as Chief Justice for me to be unequivocal about the standards of our courts, to acknowledge that North Carolina has had a very difficult history around racial disparities in our courts. And so as a result of that, the Supreme Court approved a commission on fairness and equity, and I was able to make those appointments before I left office. But there are true benchmarks about what's supposed to happen. And this is not just another facial commission making folks feel good, but we just gotta do things differently. And while we have great judges and DAs and clerks of court, we must acknowledge that there are problems. And it was great to begin having really important, constructive, but very difficult conversations about racial and gender disparities in our courts. And then as a part of those conversations, really determine how we are going to be action-based. And I think we can ill afford as judges to say it's their problem, it's law enforcement, it's everybody else's, and judges and other court officials really have to take responsibility for what happens in our courtrooms. You just had DA Satana DeBerry from Durham County on, and Satana gets it. She is the right kind of prosecutor with the right kind of heart. She is serious about justice in all the ways that all of us should be. But that really should come from the top. And none of us should, because of our responsibilities and our elected offices and whatever. In fact, that's all the more reason when you have the platform that it's important to use it in that way.
Wonderful. Thank you for setting that example several months ago. I remember that was something that I noted. I was still a relatively new North Carolina resident and learning my way around, and it stood out to me, and I was impressed. And thank you for setting an example now by volunteering and jumping in first. Thank you, Justice Beasley, for your leadership. Judge Reeves or Mr. Johnson, who wants to jump in here?
I'll jump in. Using powers for good. I can recall countless election challenges. Every election cycle, there'd be an individual who could be running for the first or just running for office. And the system in many jurisdictions were structured in a way in which if you didn't understand the rules of engagement in terms of counting or canvassing after the fact, you could lose or an election can be stolen from you. And I will always appreciate when there were a set number of us who would get caught and go into the room, and the dynamics would change. And in many cases, it will be the same set of individuals opposing fair election processes. And I can recall Hollis Watkins making a comment when I first started working with him, that an expert is someone who knows a little bit more than everyone that's in the room at that time. And it was very clear when certain individuals show up in the room that it would change the dynamic. The air would shift in a way in which those who were seeking just to be considered for office in a fair and open process, you can see a level of comfort, which was always a good thing to see, particularly when you consider some of the rural areas and a set of individuals who had always done things a certain way, and the way they were doing it was neither legal or just. when you walk in a room, that dynamic change. There's multiple examples of that I will always appreciate seeing individuals being able to do that.
Thank you. Thank you so much. Judge Reeves, it's your turn now.
With respect to I guess a couple of things sort of stand out. The people back here in Mississippi, my friends and people who know me well, they know that I always wanted to be a judge. They know that. They know that I always wanted to be a federal judge, because my view of judges are heroes. Because but for the fact of judges, we in Mississippi would not have the rights or the privileges even that others in Mississippi, we just wouldn't be able to do it. We had to go to court. Black folk had to go to court to get everything, whether it's swimming in a swimming pool, voting, being in school with other students of other races, proving to them that they are as smart as you are. But for the fact of judges, none of that would be possible. So for the longest, I always wanted to be a judge. So there may, in some person's mind, there may be an easy pathway to it, whether you run for it or if the stars align themselves in ways that everything comes together. If it's an appointment, the politics of it all works out. There are choices that people have to make at some point in time. I was the president of the Magnolia Bar Association, which is the predominantly African-American bar association that, again, rose up and became necessary because Black lawyers were not allowed to be in the Mississippi bar. So it is a bar association that still exists. I knew I wanted to be involved in that bar association, and ultimately I became president. But through working with, again, the giants, the people whose shoulders I stand on, these other lawyers back here, one of the big pushes of the Magnolia Bar over the decades was the lack of African-American judges, the lack of judicial diversity, and there were all these appointments coming up. And now I'm one of the leaders. I'm not the president at the time. I might be one of the other officers, the president-elect, or even the secretary, or just a member. But there were nominations going forward and all that. And the Magnolia Bar took the principal position that there should be some diversity with respect to the nominations. I'm the second African-American to have been appointed to the federal district court here, well, the federal courts here in Mississippi. From 1817 to 2010, I'm the second one. The one immediately before me was Judge Henry Wingate, about 1985. So from 1985 to 2010, although there have been but somewhere between 18 and 23 nominations from coming out of Mississippi, not one of them had been African-American. And Derek and many others were involved in that, in pressing the senators, taking public stances, and pushing and cajoling and arguing and all that. And I had been counseled by friends and colleagues, maybe you should step back. Maybe you should not do this. You want to be a judge. But I thought that it was the right thing to do, and it was the only thing to do. And I tell young people that, you have to, people who might not agree with you on some things, most instances agree with the passion that you might bring to something. And they will respect you for that passion that you have to your pertinent cause. So when the opportunity came up and my nomination was being considered, there was no real pushback. even from the senators who we pushed up against with respect to our respect to the prior nominations, to make one sort of detour. The other thing is with the power that I now have. A couple of cases, many cases, you have the opportunity to write and think about it. But one of the cases that I had was a challenge at Mississippi's, what we call Mississippi's Confederate flag. There was a lawyer filed a lawsuit, said Mississippi still carrying this Confederate flag. It's a stain on me, it hurts me and all that. Well, I ruled that the young man did not have standing to bring the claim, but it was important for me to at least tell the other side of the Confederate battle, the Confederate image that we here in Mississippi have been told. For example, Mississippi seceded from the Union, not because of slavery, but for some other reason. I don't know what that other reason was, but that's how we were taught. That's how they taught. That's public schools, the United Daughters of Confederacy and all of that. So in addressing the standing issue on the flag thing, there's several pages of what one might consider dicta, but it tells the other side of the story as to why Mississippi separated from the Union, the Confederacy, the lost cause, and all of that stuff. And so it was important because I'm in this position now where my voice can be used to tell what I consider to be the truth.
I'm gonna jump in on that. For the law students, one of the things I learned early is better to be respected than liked, but you can only be respected if you know your craft. And knowing your craft is really important if you want to own your power. And once you own your power, tell the truth on how this justice system can work for everyone. Equal protection of the law is a great phrase, but it's a reality that a lot of communities have been pursuing, particularly African-American community. And it's so important to ground a value proposition there, know your craft. And there are going to be a lot of times that people are not going to like the direction that you're going, but they have to respect it, because out of that respect, Judge Reeves, when it was being considered for that first federal appointment after about 10 years of fighting to make sure there was diversity on the court, not only did both the senators agree, I received a call from the former governor's nephew to say, please tell, he said Carlton, because they knew each other from when they grew up, that Governor Haley Barbour is going to support him if he's going to be considered. But that's unheard of, because almost everything that was being advanced during his tenure as governor, we fought against. It was vocal, it was clear, but at the end of the day, because Judge Reeves knew his craft, he stood in a value proposition that you couldn't dispute, although you might not have liked and you disagreed with, but you couldn't dispute it. He was clearly the person that was going to be on the federal court. But more importantly, because of the fight, every federal appointment during the 8 years of the Obama administration were African Americans, because over time we made the case of the lack of diversity. So we're talking about 2 federal district court judges, a circuit court judge, the head of rural development, both U.S. attorneys, both U.S. Marshals, all because we made the fight. It was a long fight, it was 10 years, but we were very clear. It's better to be respected than liked, and we knew the principles for which we were fighting for.
So well put. Thank you both. I mean, there's so much that you all have just reflected on. I'm gonna, for the audience benefit, I'm gonna draw out a few of the things that really stick with me now. and then move our conversation forward. And we're starting to get some questions from the audience as well. So very shortly, we're going to move to those. Some of those connect very well with some of what you all have already said. But building on what Mr. Johnson just said, the long view, it's important. What I'm hearing from some of you here is that you have to not simply think about what seems easy in a given moment, but you have to be prepared to take the long view and to work for what you believe in. You have to be prepared to own your power, to use Mr. Johnson's phrase. And in doing that, one way of doing that in a profession like law is knowing your craft, being well respected for the work that you do, and not running from the responsibilities that you have. Something that Judge Reeves said in writing the opinion on the state flag, it reminded me of a class that I taught just last week about the role of lawyers and of judges in particular in promoting civic mindedness, in helping us understand the context in which our whole system operates. And I think that's one of the things that you have done about as good as anybody, Judge Reeves, in your opinions. I'm reminded of the McClendon opinion from a few months ago on qualified immunity, which ended up telling just a beautiful and at times painful story about race in America. Maybe some of that was dicta, but you know what? It was important to tell that story. And so how do we use whatever role we have, whether it's as a judge, an activist, a leader of a nonprofit organization, or just an attorney in private practice, to promote civic mindedness? Something else that you noted, Judge Reeves, about how to balance your passion and zeal for diversity on the bench, on the one hand, with potential concerns that some folks had that, if you're too loud, you might upset some folks, and you have to kind of put your head down maybe to be a judge. And this leads, I think, to the first question from the audience that we're going to bring in here, which I'm going to read and then also maybe elaborate on just a little bit. So this is directed especially towards Justice Beasley and Judge Reeves, although no doubt, Mr. Johnson, you can probably weigh in as well. As judges, I'm quoting here, as judges, how do you grapple with wanting to stimulate positive change in your communities as it relates to racial justice, while maintaining the impartiality and professionalism from the bench that judges are expected to have? I think another way of thinking about this is, do you think of yourself as a judge? How do you balance a concern to affect positive social change while also not losing your ability to be a neutral, impartial judge? So Justice Beasley, would you like to jump into this question, and then we'll hear from Judge Reeves as well?
Well, I think actually the non-judge probably put it the best, that equal justice under the law is equal. and it doesn't matter whether you're a judge or not, that there is no equivocation around what that really means. Now, each of us has our respective roles around how we make sure that we promote that, but it just kind of is what it is. I do think that it's really important to, when I was the Chief Justice, I was very clear about what my role was. I was not an activist. I was the Chief Justice. And when I made the statement about George Floyd's death and the impact of racial disparities on our courts, there was nothing at all inconsistent with my role as Chief Justice and the leader of the judicial branch, and acknowledging that there are racial disparities in our courts. And if courts are inherently supposed to be fair and just, actually that statement and the work around that, because that was just one of the many things that we were doing around making sure that we were not imposing excessive fines and fees. I mean, that's an equal justice mission, and a whole host of things, and setting fair bonds and that kind of a thing. All of that is really consistent with being the Chief Justice. Now, whether prior chiefs acted in that way or not is something different, but so much of that is driven by culture. And often it's comfortable to do what folks continue to do over and over again, rather than thinking about why each of us is called to serve for the period of time in which we serve. And so for the time that I served, my 2 years as Chief Justice, it was not to be comfortable. It was not to go along to get along. It was to really be thoughtful about how can we make sure that justice is really accessible to everybody. When we have more than half the folks who come into our courts who represent themselves, and there's one kind of justice that they receive when they represent themselves, and there may be another kind of justice when one is represented by a lawyer. that Chief Justices have to be clear about what the standards really ought to be in our courts and really have to be. And I think so much of that was made easier because so many judges had been feeling the desire to do something, but just didn't know what to do. And I'm saying judges, but court leaders, generally speaking. And so to have those folks in partnership was really important, and I think led to a lot of great success. In terms of my work in the communities, that hasn't changed for me. I mean, I know none of us can take it all on, right? But it's been really important to me I've always weekly gone to a low performing school and read every week to first graders. That's important to me. Hunger, even as Chief Justice, I did it every week. And another thing that's really important to me is hunger. In North Carolina, 1 in 5 children before the pandemic was hungry, and during the pandemic, 1 in 3. Just think about that. 1 in 3 children is hungry. And so many of my efforts have been that way. So for me, so much of that, as we heard the prior session talk about, the things that sort of weigh on them, it's important for us all to have balance. And to do what we do well, my role was not to be an activist, and so that I'm not taking that piece on. And I will say, as I think about my life after the bench, I served as a judge for 22 years. I thought I was going to win my election, and I hadn't thought about what my life was going to really look like. And so now I'm a partner at a law firm, and that's really exciting. And I'm actually thinking about a U.S. Senate run. So, but I'm saying that to say, as difficult as being a judge or lawyer might be, and whether the things happen to us or we're facing discrimination as practitioners, and the question before in the other session about whether or not this practitioner should leave the city or not. One of the things we have to think about is, and I will say this inartfully, but if you go, you also go with you, right? So we think about what running means and placing yourself in another situation. When I went to college in New Jersey at Rutgers, people always had these notions about what it was like in the South. And my thing is, I kind of, if I'm going to have some racism, I kind of like my Southern racism better than my Northeastern racism. It doesn't feel the same, right? And so, leaving doesn't solve the problem. It doesn't mean you can't leave and you can't do something somewhere else, but there are always issues everywhere. And we have to just commit to be in the journey. And to do so in a way that makes things better for people around us and for people who come behind us.
Thank you so much.
Professor Rabel.
Thank you, Justice Beasley. Judge Reeves, clearly this is something that you've given a bit of thought to based on something that you said a moment ago about how you can promote change, but also be viewed as and actually be a type of judge who can uphold the responsibilities of impartiality as expected. But I think that the flag example that you raised a moment ago is a case where, if you were to design things from scratch and weren't concerned about the law and questions of standing, you maybe would have ruled in a different way, but you had responsibilities as a judge as well as a human being. And how have you balanced these concerns over the time?
Yeah, one thing is understanding that, judges are human beings too. And unlike what we sort of grew up on learning, legal realism is that once you put on the robe, you become a different person. No, you don't. You're the same person with a robe. So all the things that have come into your life and has caused, that has molded you, it's still with you when you become a judge. A Black judge's experience is quite different, I think, from a white judge's experience. First of all, there are not many of us. Just like that, when we grew up in Yazoo City, the people who were our leaders were, I guess to some degree, were as far as professionals go, it was teachers, preachers, maybe. But you didn't see lawyers, you didn't see doctors really. not nearly of them. So as a judge now, I still think that I must be that person who must, who my group of folk depend on. My family members talk about it all too often. I mean, I'm asked, why can't you do something about it? Why can't you do something about it? Because you're a judge, why can't you do something about it? And so I think our responsibility is to make sure, yes, there are canons of ethics, there's rules and stuff, but there are opportunities. As long as you're talking about justice, and you know, we should be honest with ourselves. Equal justice under the law does not exist. The word equal does not, I mean, it just does not exist, because equal means everything is the same no matter what players are changed. You know, 2 + 2 = 4. And if you turn that around, 4 = 2 + 2, that's what equal justice should look like. But we know it does not. And we have to accept that and understand that we have an added responsibility, or at least in my mind. I may be, you know, speaking out of turn with some people. In my mind, we do, as African American judges, and as judges, period. Because every judge takes the same oath, and every judge must have to take some responsibility to make sure that the persons who are involved in the process, whether unintentionally or intentionally, you either invited there willingly, or either you caused yourself to be there because you initiated the process. What we want to do is make sure that whoever is involved in the process, once their process has concluded, that if they or have to go through the process again, the first thing that they want to do is to go back and do it the way we did it before. We would want them to feel that way. And I think that I have that responsibility, Kenneth, to make sure that folk feel like they are invested in the system, and that the system protects them in all of the ways that it protects everyone else.
There's something really powerful about what you're saying, the integrity of the legal system. You as a judge, and we as lawyers in various ways, are responsible for upholding the integrity of the system. And I think implicit in what you said as well is an acknowledgement that, you know, we've heard this phrase, equal justice under the law, several times so far from each of you in different ways. This is not a self-enforcing ideal, right? This is an ideal that we have, but it doesn't manifest itself. It requires people to manifest it. And you as a judge, if you are helping realize equal justice under the law, that is not an exercise in partisanship. That's not an exercise in bias if you are taking steps to help realize equal justice under the law.
Absolutely.
Thank you. We've got another question from the audience I'm going to go ahead and bring in here, and again, maybe elaborate on it just slightly to allow us to expand the focus just a bit. But the question is as follows: how can lawyers and judges lead the fight against secondary trauma in the legal community, and how can we improve resources for those impacted? And so that's the question. And my slight elaboration on it is as follows. We talked a moment ago about examples in your own legal careers where you have assumed the responsibilities of leadership and have acted in a way to promote good. Where are there areas that you see within legal education, within the legal profession, within the operation of law, broadly conceived, where people, the system, are not assuming roles of leadership, responsibilities of power to affect good? Where is there improvement to be had? Where do you look around and see the greatest need? And of course, there you could probably talk all day about some of these areas of need, but what are some that particularly come to mind, and how do you think that we as lawyers, judges, can make a difference?
So I'll start off. Judge Beasley, she touched on it slightly, of the lack of a true public defender system that's well-staffed and equitable is a huge problem all across the country. It's not a Southern problem. And it creates a level of injustice that it is in bad need of repair. Secondly, when the Congress gutted the appropriations for legal services, it also crippled the ability of everyday citizens, particularly African Americans in our case, from being able to utilize the legal support around a myriad of issues, whether it was redistricting or you name it. We lack in our legal system true representation because of money. And there's always been that tension in this society between having a true democracy under a capitalistic system. And in that tension, you have this scenario where when democracy is weak or is being manipulated, capital exploit people. But if you're able to strengthen democracy, you can keep capital in check. And that plays out in our court system as it does in all areas of life. And so that inequity really bubbles up when you look at mass incarceration. That inequity bubbles up when you look at the lack of true representation of our tax dollars to support the quality of life that citizens should be appreciating, particularly when in many cases they are paying more than their fair share in taxes, but not seeing those dollars come back into those communities. And when you look at low wealth areas, the data from their poverty index is being used to leverage federal funds from CDBG, but those funds are not being applied in the communities in which they live. And all those areas is where you see the lacking of some legal support where we need to really shore up.
Great, thank you. Excellent examples. I can tell that this is something you've thought a little bit about. Thank you, Mr. Johnson. Judge Reeves or Justice Beasley, which of you would like to jump in here?
You mute, Judge.
Maybe unmute yourself, Judge Reeves.
Okay, I'm sorry. I'll jump in for just a second. You know, how can one be involved and do, advocate in whatever roles you're in? Take the responsibility and not only support certain candidates for certain your causes, but to actually run yourself. And I know that says a lot, to actually run yourself. But I do think we need more responsible citizen leaders, more educated citizens leaders, more persons who have the fortitude to push back against what they might be fed by the lobbyists and all that. We see it here and everywhere else. So I think you should advocate, be involved in the public policy debates, be involved in the religious community, and confronting the issues that they confront. I mean, it's just so many different ways in which, particularly you as young lawyers, I say this to the young lawyers out there and to the law students. You have to understand that you will be given so much power when you take that oath to be a lawyer. You will have the key to the courthouse. Judges have made it, judges and the legal profession. Once you become the lawyer, you have the key to the courthouse. Nobody else has a right to represent anyone else except a lawyer. You can represent yourself, but you cannot represent anyone else. You cannot represent any cause by yourself unless you are that lawyer. And as a lawyer, you have that key to the courthouse, and you must unlock that door for the purpose of doing justice. One of the things that I'm sort of pushing my colleagues, when I say colleagues, I'm talking about judges across the country, as well as law schools, law students. I'm doing my best to encourage many more first-generation students, many more African American, many more people who are of affinity groups and whatnot, people who've never had access before to become judicial law clerks. But the only way you become a judicial law clerk is to get judges to hire you. So I'm pushing my colleagues. I'm saying, judges, you need to think about adding diversity to your chambers. You need to think about bringing in more women. You need to be thinking about African American, Indians, Hispanics, gay people. You need to be thinking about this. And as you think about it, judges, and I've told my colleagues this, as you think about it, judges, please give them the benefit of being a white male. And what do you mean by that? Because I've heard judges, I've talked to them, you know, fortunately, I have not had an experience of having a bad law clerk yet. And I don't expect to, because I do everything I can do. I select a person. So this says a lot about you if you select the wrong person, but that's but you might have a bad experience with law clerks. And I've had my colleagues talk about the bad experiences that they've had. Person couldn't do the job, slept, you know, whatever but invariably they've had bad experiences with white male clerks. And their next set of clerks is a white male. So I tell them, please give that African American or that woman the benefit of the doubt. Treat them like you do that white male clerk. In other words, if that first female falls on her face and doesn't do the job, please don't penalize that great female that's waiting to get through the door just because the one before her did not make it. We don't do white males like that, so don't need to do everyone else like that. So one of the things that I'm involved in now is this judicial diversity as well as law clerk diversity and making sure that these opportunities are available to all these. But you can do it through legislation, advocacy, and all that. And I'm sorry, one final thing. I do have a connection to North Carolina, I like to say, Justice Beasley. 1988, I worked for what I consider the best law firm in the country in Charlotte, North Carolina, Ferguson Stein Law Firm. That firm inspired me to come back to Mississippi to do exactly what they did. That was a firm of white people, black people, women, and everything along the strata who did public interest work, who made money, who did criminals, who did everything because it was for the good of Charlotte. It was for the good of North Carolina. And it was a fully integrated firm. And it inspired the firm of Pygott, Reeves, Johnson, and Minor. It was the template that we used. And the Pygott Reeves firm was founded in 2001. And it was, I think, the second integrated firm in Mississippi. The first one was with Reuben Anderson, Fred Banks, and Mel Leventhal from the late 1960s. Mm-hmm. So 1968, 69, 70. So another 30 years, then you had Pygott Reeves. So, you know, those are the things that I sort of focus on and talk about. And this whole diversity push that you might hear in several of my speeches is all inspired by this whole thing that we can work together and we can do great things together. And we can make sure that, you know, we pursue that goal of equal justice and making this country more perfect.
Thank you so much. Thank you, Judge Reeves. Justice Beasley, what would you like to share here? What are the things that you see when you look around as growth opportunities with respect to the legal profession, legal education, capacity to navigate occupational hazards, secondary trauma, the challenges of law?
I would pick up on the point that Judge Reeves about lawyers being empowered. We are at a place where we are experiencing a pandemic like nothing we ever could have imagined. That's compounded by heightened racial tensions and governmental institutions and corporations and law firms, and a whole lot of folks are trying to figure out how to do better. And I think as lawyers and as law students, really we can ill afford to kind of throw our hands up and say, you all go figure it out. If you think about every single moment in this nation's history where we've had these crises, it's really been lawyers who've been at the forefront of using our court system to change people's lives. It's been lawyers who've been thinking about how to be innovative to work through crises. And certainly they've partnered with other folks from other professions, but lawyers have always led the way. And so I hope your students really are inspired that even these are difficult situations around the pandemic and heightened racial tensions, and frankly, the insurgency on January the 6th, which if you care anything about this nation and democracy, you should be moved by. However you are moved, that lawyers really do have a wealth of opportunity to change people's lives and to make communities stronger. And I hope that your students feel that sense of empowerment even in their state. And I know it's easy to sort of find yourself buried in your books, but don't lose sight of the import of this moment. Because it doesn't just impact you, it also gives you an opportunity to make contributions in some very powerful ways as law students and as lawyers. The other thing I would say is we're getting better about it, but we don't talk about it enough. And lawyers are called upon to lead the Red Cross Committee and the Diversity, Equity, and Inclusion Committee and the NAACP as the CEO and all of these really wonderful things, and practice law and be judges and all that. And it is important. And when you compound race, gender, fluidity, and everything else on top of that, it is important for us to take care of our mental health. And it is so important that if whether we or somebody that's around us, we see them struggling, that we tap them on the shoulder and say, hey, Jan or Fred, maybe you should think about getting some help. It's nothing to be ashamed about. It's nothing to be embarrassed about. And we can only be our best when we're taking care of ourselves. And it's not selfish. Self-love and self-care are very important, especially during these very stressful times. And so I would just encourage your students to do that. And the other thing I would say is we've talked a lot about race and gender and diversity. But I would encourage, as I'm now on this side of it, and I'm a part of an international law firm, which is great, I hear a whole lot about diversity, equity, and inclusion. And my bottom line, and I've been very frank with my firm about this, is we just have to make the commitment. We have all the programs we want, right? But we have to know the benefit, not just for diverse lawyers and diverse clients, that we be engaged, but the benefit is for everybody. We're all wealthier when our law firms are diverse. And when I think it was Judge Reeves who said earlier, you give the same chances to Bob's son, who came in because Bob was a great lawyer, than you do to Letitia, who has come in, doesn't have any lawyers in her family, first generation. Trust me, she's got a lot of experiences and brilliance that got her where she is. And so we've got to think differently about what good practitioners look like.
Absolutely.
Well, thank you so much, y'all. I mean, there are a number of questions that have come in, but I'm looking at the clock here and I see that we've kept y'all an hour and 2 minutes already. And I know that you are extremely busy people. This has been an absolute delight for me. And I know it has been for everybody who is watching. From last I heard, we had over 30 states represented in some way or another who'd signed up for this, over 1,000 people who'd signed up to take part at some point in the day in this symposium. Thank you on behalf of everyone. Thank you for sharing your wisdom, your stories, and I know that we're all better off because of it. I think at this point, I'm probably supposed to wrap up our session, as much as I don't want to. I'd really love to spend more time with y'all, but I hope to to have a chance to reconnect or to connect at some point in another context, maybe even in person one of these days, who knows. And I believe at this point, Kyle or Ethan is going to come on and officially wrap things up. But if I'm supposed to do anything different, one of y'all tell me I'm supposed to do something different, and I'll follow your instructions. Thank you again, Judge Reeves, Justice Beasley, and Mr. Johnson. Very grateful.
Thank you.
Thank you.
Yeah, so on behalf of the Wake Forest Law Review, we'd like to thank all of our attendees that tuned in today. We'd also like to thank our panelists and our moderators for their incredible contributions to this awesome event. And also thank you to our wonderful sponsors, the Wake Forest Program for Leadership and Character, the Wake Forest Department of Psychology, the Wake Forest School of Medicine, Wake Forest University's Provost Office, the ACLU of North Carolina, the Innocence Project, and the Forsyth County Bar Association. Thank you also to Dean Aiken and the Law Review for being so supportive, and thank you to the IT people for keeping this webinar afloat. Finally, thank you to our awesome online editors, Chris Fleury and Andy Anderson, who have been instrumental in helping us market this event. And also thank you to our incoming symposium editors, Kelsey Rector and Gabe Marks, and the rest of the Wake Forest Law Review for all of their support. This officially concludes our event, and thank you so much for everybody who attended.